from the transition, you need to have we need to have contracts that are more modern and that can address issues to do with climate change, regulatory changes, issues to do with expert determination, because now you're looking at situations where you have these energy contracts, and the energy contracts are very technical, and as a result of that, you need to have expert determination clauses which are agile and which provide for these, which deal with these technical complex issues. So I think it's very important that arbitration substantively catches up with what is happening today and addresses the issues of the transition. Thank you very much.
Okay, thank you, Aisha, and I'll move to Alan. What are your thoughts? Is the international arbitration framework that we currently have agile enough to handle the complex disputes? And feel free to draw from your own experiences.
Okay, thank you. I think I've noticed in the last 10, 20 years, there's been a shift in project development, in the way countries are viewing their energy. And partly it's because of the stakeholders. So you have an instance where, one, we have the Sustainable Development Goal number 7, where countries are supposed to now provide power, ensure that there is a very high level of connectivity and access. I think Uganda's target is, they say full connectivity, which is around 80%, 80% access. Now you have that stakeholder you're dealing with, but you have to develop a power project that is going to be cost reflective, which means you also have to be efficient, because it's not enough to provide reliable power, it must be affordable. If it is reliable but not affordable, you won't get access. So we've seen a growth in, one, project development. At some point, we had, I think we right now have about 90% renewable energy. Part of it is because we are looking at ensuring that we stay green. We've had all the international conferences like the COP, we've had the Tokyo Protocol, which we signed up for. So you want to reduce the amount of greenhouse gases from energy projects. At that level, you have to think about, one, how to get financing. So financiers are looking at ESG, how you operate environmentally, socially, and in your governance. The environment, of course, has taken the lead because it's easy to predict. So another thing that we've seen a lot of is regional power pools. So the East African regional power pool is growing. The idea is, rather than spend money building a power plant, in Uganda, if you have a surplus, you could sell to another country, or if, say, Ethiopia has a lot more power, you can create a pool. That also helps with reliability. So if you have a bigger connected network, you won't have too many shocks that affect you. Now, the question on arbitration is based on the relationships you have. So with a power pool, you then have power purchase agreements with different regional players. Someone says you can't have conflict if you don't have contact. That relationship may lead to an issue with supply. Then locally, because we've done, in Uganda we did the unbundling, eventually there was a power sales agreement. So there's a power purchase agreement between the generators and the transmission company. Then there's a power sales agreement between the transmission company and distribution companies. Right now, of course, there's a dispute between UETCL and Umeme, which was a former distributor. And that is being handled by international arbitration. So first, because they're state players or companies that are owned by the state, arbitration becomes a very important dispute resolution tool. Secondly, because it's very technical, you're going into modeling, tariff setting, policy. And then thirdly, because there are public policy implications. and you might not want to discourage investors by putting all your information out there. So the use of arbitration is actually, I think it should be critical. There should be only one dispute resolution mechanism, and it shouldn't be the usual adjudication, because first of all, the courts are already overworked. Then you start giving them, volumes of information. And then, like Aisha had said, we have every contract that I've seen in our concession has the option of using an expert determination. I don't think we have used it enough. But whenever we go into a dispute, say with a party, it is somehow resolved after an expert has looked at it. So you'll have, I won't call it wasted, the court's time. You go through the court process, then after closing your case, you wake up and tell the judge, oh, by the way, one of the parties is withdrawing the case because we've reached a settlement. So I believe that we should evolve arbitration to be part of the process of running a utility or providing the service of electricity to a community from the very start, leading to dispute avoidance, expert adjudication. Then you go into arbitration as a matter of course. And this should lead to good faith on both sides and a willingness to use those tools at every stage. So, but I think we should focus a lot on avoidance of disputes. Thank you.
Thank you, Alan. I agree with you. Dispute avoidance rather than resolution. Just maybe ask Dr. Yak his thoughts on the same question, and also feel free to draw from your experience or any recent reforms you must have observed. Yeah, thank you.
Thank you very much, moderator. First and foremost, I want to thank ALP for inviting us in this important conference. I'm bringing greeting from South Sudan, my colleagues who are supposed to be here with me, but due to other reasons, they couldn't make it. In South Sudan, we are operating oil. And I've been in this oil sector for more than 15 years. We are managing a very complicated chain of businesses. We have oil in South Sudan. We have facilities in Sudan, processing facilities and the pipelines and the port in Port Sudan. The distance about 1,600 kilometers. Then we have oil tankers. And then we have equipments and machineries and some goods that are coming from outside. All these are governed by contracts. In those contracts, we have adopted a standard clause of arbitration. And we're managing more than 3,000 contracts. For the last 10 years that I've been in this office, good enough, we never had any case that took us to arbitration in London. We adopt London as a venue for arbitration. We have some few cases that were complicated, but we were able to solve them amicably between us and our contractors. It's a situation that sometimes, if you're not careful, you can lose a lot of money, because we are managing figures that are big, in billions of dollars on a yearly basis on some contractors. Sudan, something that is very important for you to know, during those days when they were developing the oil, you know, we have these regional borders that divide south and the north, but in one country. By then, before 2011, before the separation. But what was interesting, during those days, whether by default or by design, but I think by design, all the facilities that are processing the oil were built in the territory of what is today known as Sudan, beyond the borders of South Sudan. So at the time of separation, those facilities belong to Sudan. And we have to pay money to process the oil. And you have to have that terrible contracts with a lot of complications that you cannot default. If you default, you will not process, you don't process, and then you stop the production. So the arbitration clause in those contracts are very active. And recently we just had a discussion over them when we were renewing them, because some of the terms are so much punitive on us. But all in all is that Uganda have oil, you're going to have oil here. It's good that most of the facilities that are processing your oil, you build them in Uganda. Don't build them outside Uganda. If you build them outside Uganda, you will lose a lot of money. You build them all in Uganda, the pipeline maybe is going to Tanzania, wherever you have agreed. But most of the facilities that are processing the crude oil, I advise you build them in Uganda so that you don't lose a lot of money. This is what we have gone through. This is what we are managing. And it's not easy to get out of it. There are a lot of things that we can discuss about petroleum. But I think as time goes today, we can share those experiences. Thank you very much.
Thank you so much. And building on that point, Aisha, you sit at the center of commercial disputes in Uganda, specifically within the energy portfolio. So let me start with mediation. Yeah? Given the new ADR policy framework, what practical steps can encourage meaningful cooling off mediation periods in energy purchase agreements before parties escalate to arbitration? What has worked, what has not worked, what's on the ground? Yeah.
Okay. First of all, as lawyers in the sector, we advise our clients to avoid getting into these disputes in the first place, because when you look at the contracts in the energy sector, many of them are 20 years, 30 years, 40 years. So if you are getting into a contract for a long term, disputes can be had on that crucial business relationship. But where the dispute has come up and you must proceed, you still encourage them to preserve that critical relationship. So when it comes to cooling off in the sector, what we have is a multi-tiered dispute resolution mechanism. And this is what I would recommend continues. Some of what I'm recommending is already there in the sector, some is not. This dispute resolution mechanism should have a formal notice of dispute, which you see in most of the power purchase agreements that we have in the sector and other energy agreements. Then you have the mutual discussions, mostly between the management teams of both entities, trying to discuss in order to reach a resolution. What I have seen in the energy contracts here is that the clauses on mutual discussions are not detailed enough. So you find that parties get to that stage and they're like, okay, what do we do? Do we just call and have a meeting? And I think they need to beef them up a bit and provide a bit on the procedure. But also we find that these mutual discussions For instance, if you have a dispute with a government entity, you have a clause on mutual discussion which says the mutual discussion should take place within 30 to 60 days. But in most cases, you find that those days lapse when, people are just going around and saying, we are still reviewing, we are still reviewing, we are still trying to understand the dispute. Before you know it, one party wants an extension, but the other party is like, I'm fed up, I just want to move on to arbitration. So I think there is some improvement that must be done there. Then some of the agreements would provide for mediation, but most of them in the sector do not provide for mediation. Many of them just provide for moving on to arbitration, or in some few cases, expert determination. But also what we have seen is that usually the mutual discussions and maybe even mediation may not work, especially if there are public funds that are involved. Here in Uganda, we have that issue of the Auditor General coming and auditing and asking, why did you make this decision? So we find that many of the technical staff or even the management of these entities, even where they think that they can settle this dispute, they shy away from it because they're like, it's just easier to explain if we have an award or if the expert makes a determination so that we can safeguard ourselves. So that is a challenge that I have identified. But also, crucially, I think what may help with this cooling off period is if in many of the agreements that are entered into in the sector, there is a clear distinction between technical disputes and other disputes. Because once that is made clear, then it is clear what is going to go for expert determination and what will eventually just end up in arbitration before expert determination. Because you find that at times the parties are then arguing about whether a dispute is technical or not. And that slows down the dispute resolution process. I think also what needs to be done is that the contracts should provide for interim relief, to ensure supply continuity, asset preservation, and just for safety generally. And yes, because I think this can help in encouraging people to cool off, and in encouraging mediation. So the other thing that I would think the agreements should provide for is extension of timelines. Like in case, for instance, I mentioned the mutual discussions or even the mediation. If there is a particular timeline and the parties still feel like they still need to have a discussion, I think the contracts should provide for that. Thank you, Edith.
Thank you, Aisha. And from that angle, I would like to bring in Dr. Yak. You've handled complex upstream petroleum contracts, so let's begin there. I think it's Aisha who talked about expert determinations. What trends are you seeing in the use of expert determination before arbitration, particularly in South Sudan and the wider Nile Basin?
7 years ago, we had contractual problems that almost led us to court. But then when the matter was brought to my attention and I was tasked by the board to manage the case, we said before we go to court, let us first try to resolve the matter amicably. And if we fail, maybe we bring other people to help us inform experts. First and foremost, I called the parties and I requested them to suspend initiating the court cases and give us a chance to resolve the matter first. because in our contracting formula, even though you are a subcontractor, there are linkages that you don't do things without us and we don't do things without you. So we involved some experts. We resolved the matter. It took us like a month and a half to resolve the matter. And it was a win-win solution, no loss. We were able to establish the gaps and the differences, and the experts were able to provide reasonable, conscious resolutions that were adopted with less fees, So it's always good to employ mediation, experts, interventions before you go and arbitrate the matter in the panels, in the tribunals. So is the model that we have used, and we have benefited from it, and we are still interested to use it should something of the same nature arise.
Okay.
Thank you.
Thank you. Let's shift the gears slightly to downstream. Alan, as the head of legal service at Umeme, you sit at the heart of the regulatory ecosystem. So maybe let's start with the relationship with ERA. How have disputes between Umeme and Electricity Regulatory Authority evolved over the years? And from your perspective, has having Uganda as a domestic seat worked well for utility-scale disagreements?
Yes, thank you. I think I joined Umeme in 2015. At that time, we had a dispute with the Electricity Regulatory Authority, which started in 2012 and ran until 2016. The irony is that the day the decision was supposed to be given by the Electricity Disputes Tribunal, the very same day, the parties entered into a consent. And it took 4 years. And the spirit behind it was there should be no situation where the Electricity Disputes Tribunal has given an adjudicated decision that could result in a loss of confidence in investing in the sector. So there was an agreement reached. It took about a year to negotiate, but it took about 4 years to resolve. I like what the Chief Justice said at the opening of this conference, where he says that courts do dispute adjudication, not dispute resolution. Because at the end of the day, you have one winner and one loser. In this particular case, you have the opportunity to take charge of the conclusion of your matter and find consensus. So, Umeme does not have a license to operate a utility anymore. However, for the last 20 years, the one thing I noticed was the establishment of the Electricity Disputes Tribunal, which was specialized for utility matters, was very important in the unbundling of the sector and the electricity reforms. The tribunal has run for 20 years. I think there's been a lot of discussion around changing the format of the tribunal. And one of the discussions has been creating an arbitration center for disputes around electricity. And I agree with it because, one, they're very complex issues, and you'll find that in many cases, the matters are resolved by technical information. So you have a complex sector, you have multiple stakeholders, and I think each relationship should have its own way of solving problems. The sector deals with assets that are owned by the people of Uganda, held in trust by the government. So the utility, essentially, okay, UEDCL will own the assets, but not, it's more like a trustee. Now, when Umeme was around, they had a concession, but the assets were still owned by UEDCL. So Umeme had a contract. If you decide to go to court and get adjudicated settlements, the value of any damages will become part of the cost of running the utility, which could be passed on to the consumers. So in the end, the people who pay for any mistakes the utilities make are actually the consumers. including the people who might have sued the utility. So you want to now make electricity affordable, but as a public policy, you need to make sure that you do not saddle the utility with excess costs that will lead to an increase in the cost of power. So that was what the ADT was initially designed to do. Secondly, you want to get confidence because the regulator's role is to encourage investment, so you're attracting investment. So if you have a dispute between the regulator and a utility, financiers will start worrying. They call it the weighted average cost of capital. Is known, but when there's a risk, they increase the cost of capital. So you'll find that while you could have borrowed money at 13%, the utility will say, I'll throw in an extra 3% because of this risk. And then eventually, you will not be sure about how the concession will end. The only thing I can say about Umeme's arbitration is that it's happening right now. I can't go into details about what it is. But the fact that there's an arbitration going on could affect a decision to invest in distribution today. So the government of Uganda has to look at the public policy and the strategic implications of the dispute resolution mechanism they set up. So speed is very important. Responsibility and being relational is important. So when you have a dispute between a consumer and a utility, the way our rules are set up, which is still very new, is the first course of action should have been to the regulator. So the regulator forms the first dispute resolution area. Then the decision of the regulator is taken to the Electricity Disputes Tribunal. Then if the Disputes Tribunal makes a decision, then an appeal lies to the High Court. So we haven't done it very efficiently, though I'm sure the utility isn't going anywhere. But what that means is you have different layers of settlement before you get into the adjudication space. And you have a tribunal that is now set up for that purpose. I know they're trying to now increase the instances where you go into mediation and arbitration so that you don't have too many cases, one, running for longer than a year, because they will affect your tariffs. You'll be adjusting your tariffs to cover a case that got up 3 years before, but also dealing with the relationship. A utility will always serve a customer. If they have a dispute with a customer, you still have to be served. So they would want to make it in a way that the relationship is maintained. And then thirdly, you don't want a loss of confidence. So if you look at electricity, whenever there is an issue with electricity, it can even become a political issue. So you want the network, we call it having the network being quiet. We're a few entities who will not enjoy being in the papers a lot because we're in the papers for the wrong reasons. So so on the question of the seat of arbitration being local, depending on the relationship, I think everything where you're dealing with a regulator, of course, should have its own adjudication place, and I think they should deal with the arbitration because of the confidential nature and the complex nature of the relationship. So arbitration would be ideal, and because it's domestic, I think arbitration domestically should be ideal. Depending on the threshold, if you have a matter, say, below, let's say, $10 million, I don't see why you should spend all that money on international arbitration. But if it goes above, I think in an argument, 8 million, I think ours is 8 million. Anything above 8 million should go into international arbitration because, one, you're dealing with a government, so your investors need to understand that they're going to a neutral place. So what happens was they said, you need to go to, you pick London as a seat, you could pick Kigali, Mauritius, many other places, Nairobi, but you pick a seat which is not, which cannot be influenced, in quotes, and that is based on perception. You have an arbitrator who is appointed who, and in our case, cannot be a national of a country which has shareholding exceeding 5%, or the government of Uganda. So you will be very careful about how you pick your arbitrators. And then, of course, because of the complex nature, you need to have an expert on board to advise the arbitrator. It's taking a bit of time, but you look at the quality. So I believe there should be thresholds. There should be a threshold below which you have local domestic arbitration. But if it involves the state and it's complex and it's above a certain amount, you should go to a neutral seat.
Thank you, Alan, for sharing your insights and developments in that area. Just now, let's turn to Aisha. Let's turn to local content. Yeah. Uganda's energy projects are expanding, and of course, with that expansion comes with disagreements with local subcontractors. So how do we make international arbitration less intimidating for these local subcontractors who provide construction services, engineering, logistics, and services?
Okay, thank you. First of all, just thinking of local content, in both the oil and gas sector as well as the power sector, you have a legal framework that provides for local content, and that has really helped to promote the SMEs in Uganda, which is the majority of businesses in Uganda. And today, when you look at the national supplier database, you see that the SMEs that are participating have gone up from 500 to over 2,000 in the past few years. And their share of the procurement value has also gone up to about 72%. I think this is very commendable, and government has done a good job in this area. Now, looking at how to make international arbitration accessible to SMEs, I think we need to start from the beginning. We need to start by sensitizing the people that own these SMEs about arbitration, because many of them don't know about it. They also don't know the difference between arbitration and going to court. So they need to know about this. You need to have probably organizations such as Gumzo La ADR teaming up with the annual, or participating in the annual National Local Content Conference, and just enlightening and sensitizing these people about arbitration. I also think that probably the Petroleum Authority needs to do a lot of work in encouraging many of these suppliers to seek legal advice before they execute many of these contracts, because we've seen instances where they've executed a contract and it provides for international arbitration, yes, but then it also provides for the place of arbitration is Singapore. And this man with a small business cannot afford to go to Singapore to enter into, to get a resolution of a dispute. So you find that, yes, a lot of work needs to be done around that. I think the PAU has now taken the initiative, and during their review of some of these supply contracts that go to them for approval, they are encouraging the parties to amend and provide for provide for the place of arbitration to at least be in Uganda or somewhere close by where the parties can afford. So I think in terms of making it accessible, making arbitration accessible to the SMEs, it's also very important to manage the cost of arbitration. And I think here lawyers maybe drafting these contracts could provide for sole arbitrators, but also I think allowing for virtual hearings and capping the recoverable costs for smaller claims, as well as document-only hearings, can also go a long way in making this the cost manageable. But we are also seeing instances where the SMEs could access third-party funding from institutions that do this in order to be able to make this, the international arbitration more accessible. Thank you, Edith. That's all.
Thank you, Aisha. Maybe just move on to Dr. Yak. And I know this is a particular area of interest. Stabilization clauses, yeah, in this new era. So with African states updating their environmental, protection laws, how are these international companies reacting? Are we seeing a regulatory chill? Are we seeing renegotiations, or are we full on to arbitration?
You mean environmental issues?
I beg your pardon?
Environmental issues?
African countries have now, they have upped up their game when it comes to environmental protections. But then there's also, there are these, let me give an example, maybe these investment agreements or treaties that, by the time they entered into these agreements, these laws were not really in force. So how are these companies reacting? Are they full on going to arbitration, or is there a regulatory chill, or are they renegotiating these agreements?
This is a very important and so debatable question. We can talk about it for days. Nowadays, environmental issues are big problems. In South Sudan, now we're in Arusha. We're at the court now because of environmental issue. A certain NGO went to the oil field and got some leakages. They went and they quantified the leakages in terms of environmental damages. And when they convert these damages into money, it's almost $1 billion. The court, as we talk now, is in Arusha. The process is taking place in Tanzania. When this international company reacted to the litigation, first and foremost, they said we have not committed an environmental problems. Second, they said that is the work of NGO trying to inflict losses into our investment. Third, they said it was a collusion of some of the competitors that are not in the blocks. But then we call ourselves for a meeting, and I'm in that committee. When we check into environmental laws and regulations, one big mistake we got was that the environmental law was not enforced, was not yet enacted by the parliament. And that is a very big gap. I hope Uganda has already environmental law in place to manage your environmental issues when it comes to oil production. Because when you're producing oil, always the leakages could be from the pipes, could be from the trunk pipes, or from these feeder pipes, from the facilities, from the power plant, from the processing plant. They're all there. You just need to have a response mechanism in place. Because, for example, if you have a leakages of pipe and you have a crude underground, the first thing you do, once you get that information, is to write to the site. Excavate a very big hole, and then you drain the crude to that hole to avoid it spreading. And then you close the valve, and you divert the crude to the storage tanks, and you bring the welders to do the welding. When you do that, get the vacuum truck, drain the crude, take it back to the processing. Take all this soil, the contaminated soil, take it to the processing. Get a new soil from the river, put it there, do the plantation. If the soil responds, and then the soil now is okay. Those initiatives have to be in place, because you can never avoid environmental pollutions when you are doing a business on extractive industry. They are always there. But you just need to have a very good response mechanism from the operation side. And you need to have laws and regulations that should the situation arise, you are ready to respond based on what is already there. If those gaps are there, it's a very big problem between you and investors, because that fees, the money that come from that environmental pollution, is money, is a lot of money. Sometimes you say these polluter pay principles and whatever it is contested, is debatable, they don't accept. First, you need to have laws that are in place, that are very active. Second, you need to have a very good response mechanism from the operations. If this thing happens, this is what you are supposed to do. Thank you.
Thank you, Dr. Yak. Maybe to take Alan, just back a bit, because you touched on this, yeah? Given the disputes that are recurring around technical losses and tariff adjustments, would specialized energy arbitration tribunals serve Uganda better than commercial arbitration, or do we just strengthen what already exists?
Yes, thank you. Yeah, we've had, right now we actually have a dispute that is related to the buyout amount, and the buyout amount was determined by the investments made by the utility minus the amounts that were allowed in the tariff. So that the investments should be unrecovered through the tariff and undepreciated. So the government of Uganda undertook to guarantee the recovery. And the basis of this is you attract investment into your country, so the entity that is investing has to recover what it put in, which is called the capital, its cost of capital, plus an agreed return on investment. Now, if they don't get that through the tariff, they have to get it through, I think, our taxes or maybe future tariffs. So the government of Uganda undertook to pay the buyout amount. But now it was the role of the regulator to make sure that what you pay in your tariff is enough to cover the costs of the sector. So the way you compute the tariff is you get the entire cost of the sector from generation to distribution, and you divide it by the number of units that are sold, and that gets you the tariff. If they feel that the tariff is too high, they have to adjust it either through a subsidy, and I think as at 2012, the government wanted to make the tariff cost reflective, or they make sure that you increase the number of units that you sell through industrialization, new connections, so that what each consumer pays is less because you're selling more. Now, of course, it is affected by two things. One, if you're transporting electricity on a power line, some of it is lost through friction, heat, and then by the time you get to the home, there's less power being sold. And then some of the power is stolen. People will not pay bills, people will bypass a meter. So you then get a technical loss, which is, there's a technical loss and a commercial loss. So what you buy from, what the distributor will buy from the transmission company is is more than what they sell to the final distributor. So now that I've finished with the definitions, at the end of the day, you'll find that the final consumer, who is the customer, will pay, say, 15% less in costs because of what has either been lost in technical losses, comes down to about 9%, and then commercial losses, which is about 6%, which is from power theft. So you have to make sure you, first of all, fight power theft, which sort of takes care of the commercial losses. Then for technical losses, you have to deal with investment. So you have to reinforce your power lines, you have to deal with putting new transformers on, and that way you will find that you're actually reducing the losses. And every step is there. Now, where it comes to a dispute, the utility has to invest. If they invest, they have to recover. If the regulator is trying to keep the tariff low, they might arrange for the concessionaire or the utility not to recover its full complement, its full entitlement. And if the utility does not recover what it should get, it leads to a dispute. So we also have issues like inflation, fuel adjustments, because if you're using generation fuel, sometimes the price of fuel will affect the cost. So the regulator's role is to develop a tariff that accurately but covers reasonable costs. So you also don't want your utility to gold plate. So they set the tariff, they approve the investments, then they approve the investments that go into, they call it a rate base, because the utility is the owner of the assets, but they're public, so you have to pay for them. So the dispute will arise where the investment is made on the understanding that it will be recovered, but the tariff is not sufficient for the investor to recover his money. So he will have to get his money either through the tariff or through the guarantee of the government. Now, some of those decisions are made, these were made in 2005, 2004. This is 2026. The feeling you have, the promises you make to recover, to attract your investors are not the same promises you make when they're going away. At that point, you might actually feel, no, these guys, they have taken too much money, too much of our money, and they kept calling the concession bad. Now, from a lawyer's perspective, there's no such thing as a bad contract if you both signed it. So the disputes that arise usually come from a feeling that there's a regulatory risk where the regulator will not allow you to recover what you have invested, or will not allow you to perform in a particular way. So stabilization clauses were very useful for us, because if there's a change of law, we submit a bill based on the impact. Or we ask that we be exempted from certain things. We got a few tax exemptions which later on were taken away, but the cost now has come. So what I think is, at the time when you're designing a project or designing a concession, you must make sure you are aware and alive to the risks that come from, let's say you look at the future, 20 years down the road. In 2005, Umeme's network was not as good as it is now. It was not as risky. It was a lot more risky as it was then. But in 2012, when a lot of investment was done, it became less risky. I think there was a point of, what they call it, buyer's remorse, where you're saying, now, why are we paying these guys 20% when now, it's really good? So you have to plan when you're dealing with these things, with a concessionaire. And if you don't arrange, if you don't sort of future project how it should be, you will find yourself in a dispute because you don't feel as eager to sign up a concessionaire in the 10th year as you did in year one. So maybe when you're setting your tariffs, you should arrange for, at some point, the regulator brought in an issue of verification. So you have to deal with what is reasonable. You have to be very clear about how you determine your tariff, what costs are allowable, what growth you want to see, and how you're going to make sure that the final, that denominator where you're talking about units sold, can cover your entire costs. So you have to look at the entire, first of all, the policy. You have to look at what the government is willing to bring to bear. You have to look at the relationship with developers, with concessionaires, with utilities. And then you also have to look at the economics behind it. At some point in 2012, I think our tariffs went up by 25%. And the question there was, would you rather have cheap electricity that is unreliable, or would you rather pay for your electricity in full and get I won't call it a Mercedes-Benz, but I'm just saying there's a reason why people buy, say, off-roaders, and they could have bought smaller cars. So do you want cheap and reliable power, or do you want slightly more expensive, reliable power? So you also go to your consumers who are willing to pay more. So it's a delicate balancing act. You have your utility, which is investing, which has stakeholders like shareholders they have to deal with. Then they also have to deal with the regulator who wants the quality and the value and sets targets. Then you also have the customer who you have to make sure is paying the right price, because when someone steals power, that cost is passed on to the legitimate consumers. Avoid power theft, then you invest in a reliable network. All that requires funding, requires assurance, but also requires that the regulator is working to avoid a dispute. If you have clear contracts, you have a clear tariff setting mechanism, involve the right people, you will make sure you avoid a dispute. Then we should also deal with experts, bring experts in to advise at the earliest instance. I think dispute avoidance boards should be in place for every utility at every level, either from the tariff perspective or from the construction perspective. Your idea is to avoid a dispute, because once you have a dispute, regardless of the outcome, you lose confidence and the cost of investment goes up. So we have to look at it from a public policy and investment assurance perspective. Thank you.
Thank you, Alan. That was a holistic view. But still on de-escalating disputes, and I would like to hear from Dr. Yak, given the cross-border nature now of pipelines, yeah, how can we use harmonized regional arbitration mechanisms to de-escalate disputes before they turn into a diplomatic standoff between, with neighboring states?
That is a very important question. The pipeline, the pipe for the oil, have some stakeholders. There's the owner of the pipeline, and there's the cheapest, the people that are taking the crude through the pipe. And then you enter into what you call crude oil transportation agreement, quota. This quota will address the right of the owner of the pipe, the rights of the cheapest, including the handling in the ports, wherever ports you are disposing of the crudes, because the crude belongs to cheapest and the owner of the pipe up to the disconnection of the hose from the ship, when the ship is now going to international waters. In most cases, and we had the issue before on the pipeline issue, there was a pipe leakage in Sudan. And we lost about almost like 1.5 million barrels. And then people went for a meeting. They were asking themselves, who should be responsible for these losses? Who is going to pay? The owner said it's a force majeure. The cheapest say it cannot be a force majeure. And then, how do we get out of this? You go back to the agreement. The agreement says, this pipe belongs to you and I'm renting it. And you take the full responsibility of your pipe. Even for you to allow the pipe a leakage of up to 1.5 million is also negligent. Because the leakages today, maybe you start with 1,000 of barrels. If you control it, it will be something that is a small quantity and it can be overcome. But if I've gone to that far, there's element of negligence here. Somebody must be responsible, and that is the owner of the pipeline. The case of Uganda now, pipeline, At the beginning, I don't know the investment model of it. At the beginning now, maybe it belonged to the contractor, not yet to the government of Uganda and Tanzania. If it's still a property of the contractor, and that is the oil company, they will be the one to collect the fees until they recover the cost of investment plus the profit margin that they put there. And then thereafter, the ownership will change. What belongs in the territory of Uganda will belong to Uganda, and what belongs to that territory could be Tanzania, could be Kenya, could be whatever country you are passing through because you are a landlocked, will belong to that country. And then the crude oil pipeline agreements and the crude oil transportation agreements will details the roles and the responsibility of each owner and the shipper. And should anything arise in the process of operation, each and every one of that the stakeholder will know this one belongs to myself. But it's something that is very complicated because given from the experience that we went through, anything that involves too much cash is always a problem. The problem is, you know, when you have oil, you budget your yearly budget, the country budget, and you put some of the budget in the oil money. An interruption in that income, it also interrupt the country budget. And it's always a complicated matter to accept any responsibility that comes with financial loss. If those agreements are not structured in the way that each stakeholder is fully protected, it's always a debate that is endless. And you know, going into arbitration sometimes also is strain the relationship of some countries. It's not that it's not just a walk in the park. You have a problem that is political and diplomatic. And it's not always advisable to go that far. It's good that when you are adapting those two agreements, there are two agreements that govern the pipeline. One you call crude oil pipeline agreements, and the other one is called crude oil transportation agreements. The first one is between the cheapest and the owner of the pipe. The second one is for the operation, is for the operator. If CNOC or Total is the one operating, and then they have a direct responsibility also on the pipe. If something happens, there's somewhere that you can go to them. And the first one is for the countries and the owner of the crude. It's something that when you are developing those two agreements later on, you need to go explicitly to detail the roles and the responsibility of each stakeholder so that later on when we have a problem, you don't get into problem. What we got in our agreements, there was a gap. What I told you before on that leakages is not captured. That's why we were struggling how to settle it. But I think with the good thing with Uganda, you have good lawyers. You have you are entrenched legally. I'm sure when you are developing that document later on, it will cover a lot of things that will be very good. Dr. Honoria has been teaching in Juba University and is aware of those laws. Maybe later on you can also help when you are drafting those agreements. Thank you very much.
Thank you for sharing your perspective, Doctor. Okay, so it's Women's Month, and this panel is hosted by Women in Arbitration. So I'll just, Aisha, as the only lady here, maybe you can give us advantages that women practitioners bring to these technical and high-stake energy disputes that may be missed when panels are male-dominated.
Thank you, Edith. First of all, I think this room also has more men than women this morning, which is surprising, but I think we all know the usual unsung heroes in so many rooms, probably including this one. It's usually us, the women. We bring calmness in every situation. We have the ability to read negotiation dynamics and manage tensions in any room. And I think that is usually very critical when it comes to resolving disputes, especially through mediation. But also, as women, we are emotional. And ladies, don't let anyone lie to you. That is not a weakness. It is actually a strength. It makes us more, it makes it easier for people to connect with us. But it also makes us more empathetic. And we are able to build trust easily. And I think that is all critical to dispute resolution. But also, we are meticulous in nature, which helps us to pay attention to detail. And also, we are able to adhere to procedure. And that makes whatever proceedings we are involved in fair, but also legal and not easily challenged later on. So I think we play a very important role on any panel that we are part of. Thank you, Edith.
Thank you, Aisha. And I would like to hear from the male perspective. Alan?
I think early in my career, I was representing a company that had a claim from a child that had been injured by one of their cars. I approached it like a lawyer. I asked my client, what is your defense? And they had a defense saying the child was negligent. I went up against another young lady who was a lawyer on the opposing side. Halfway through the discussion, she told me, you realize this is someone's child. I had thought about it like it was a case. I was thinking about it from an academic perspective of, cause of action, defense. And she got me thinking about the social aspects of your impact on a child who's someone's sibling. And what happened there was, we then decided that we would settle the matter in a way that was not adversarial, because if you have an injured child, everybody has already lost. I think the reason why I'm asking this, I'm saying this is, well, speak for most of us men, we are very compartmentalized. We can easily decide to focus on the academics of a matter and not think about it beyond that. While you'll find a lady now saying, this is a lawsuit, but there is a child. So I like the fact that we are being challenged, and to be honest, in every office I've worked, there are more ladies than men. We're being challenged to be more inclusive. We're being challenged to be more aware of what our social contract is, and to also understand that sometimes you can win. What's the theme this year? By giving to gain. You can win by conceding something and taking the high road. And when you do that, you actually will improve, especially on things like your reputation. You could give up a bit more money, but then you will get a reputation and you could actually gain more. So I'm learning more about being aware, being inclusive, and dealing with the issues outside the strictly legal. So I think that's an advantage. Plus I have 5 sisters, so they also help me deal with that bit. So that also helps you understand that there is more to what we do than the things that we are paid for. There is our social contract. So I think the ladies are very good at that. If we have an all-boys club, chances are you probably won't think too much about some of these things. Thank you.
Thank you, Alan. I'm very glad to hear that. So let me wrap up with a forward-looking question for each of you, and I'll ask for brief answers. In 30 seconds, I will start with Dr. Yak. If you could insert one modern clause into an energy contract today, something that would stop disputes from reaching a full-scale hearing, what would that clause look like in 30 seconds? If you would insert one modern clause into an energy contract, what would it look like in 30 seconds?
30 seconds, okay. You know, oil contracts, what is so much needed, just to be a very detailed person. When you're drafting petroleum contracts, you make sure that you are detailed, you are calm, you don't rush. Because any decision that you take, and if it is not well digested, it can be so much of detrimental effects. So I recommend when you're putting that clause, be very detailed, be calm, don't rush.
Aisha?
Thank you. I think for me, I would recommend a standing dispute prevention clause, which would establish a process whereby parties identify potential disputes earlier, have regular meetings where they have discussions regarding these potential disputes, and also agree to negotiate in good faith to resolve them. Thank you.
Thank you. Let's hear from Alan.
The good thing with coming last is I can just add on. I think we should have mandatory expert determinations, which may not be binding, and then those should be factored into mediation. So you should have the experts report, then mediation between the parties, which if it is local, it could be facilitated by the regulator. If not, you could get the regional regulatory body to set up a panel either of experts or of arbitrators. Then following that, we should have a threshold where your arbitration should be domestic, and then the next way should be international. I don't think we should rush to arbitration. It's complicated. That way, you should also factor it into the energy policy, where the ministry should, the government of Uganda, for instance, should be very strict about avoiding disputes. Then you should have enough bodies, one, to look at the technical aspects so that you're not just stuck to submissions that are open, and you restrict it to relevant matters. And then every party should have their obligations clear. So I don't think an arbitration should just be open to everything. They should now probably pick out what can and cannot be arbitrated, so that that multi-tiered dispute resolution mechanism will help with complex matters. Thank you.
Thank you, Alan. I think what this panel has brought out clearly is expert determination. So I'm going to open the floor for questions. I don't know if we have any questions. You can just raise your hand. Okay, Professor Wayne has a question. May I please have a microphone? Here in the front.
I really want to thank you very much, panelists. We have really enjoyed listening to you, Alan, Aisha, and Doc. I'm very curious whether you've had community claims and what that has meant in terms of decision making, balancing contract, the sanctity, and other public policy issues. I think that I would be very curious, being in the energy. I think there's a lot of instability when it comes to renewal, what states are trying to do in terms of policy, and then contracts that they previously got into. And then I know you mentioned, Alan, that DBs are the way to go, in making sure that you have a standing DB. Do we have capacity in terms of adjudicators and people who can actually be a part of that? I was very, very curious about that. Thank you.
Aisha, I think the question is for you. It's for Aisha? It's okay, because Aisha is only talked about the last part, I think. So, okay. Dr. Yak can answer.
I didn't get the question well. Can I get it again?
The mic.
So a lot of these infrastructure disputes, sometimes involve claims by communities. And I'm curious how that, whether you have experiences where that has happened, and how you balance the question of the sanctity of the contract, what's been negotiated by government, and these public areas of where the community claims are coming from, human rights, environment, labor rights, and all of that. Thank you.
Thank you very much. This issue of community is actually a routine activities in form of corporate social responsibilities and in form of compensation. In form of corporate social responsibilities, you have the education, health, water, or you can say sanitation, roads, plus others. In our case, we make sure that we minimize methods that can bring some disputes between the company and the local communities. These roles are divided into two. There are roles that are undertaken by the government. There are roles that are being taken care of by the company itself. Compensation are taken care of by the company itself. Water and sanitation are taken care of by the company itself. Feeder roads are taken care of by the company itself. Electricity, because in the where you are operating oil, you have too much power. The power plant that you are using, you have too much power that you can give to the community, provided that they have enough infrastructure that can absorb the load. Whenever a dispute arises, what model we use always will avoid going to court. We resolve it through negotiation. We call them, we see what is the matter. Maybe they said, our goats, they got drawn in the pit, in the borrow pit. And then you quantify the goats. How many goats? You take the pictures, you get the reports, you write to authority, and then you see how much is the goat, is the price per a goat. Maybe a cow, maybe human beings. You get that information, you go into negotiation using the physical information on the ground. If the goat is $100, it must be $100. And then you enter into agreement with the community, and you sign that agreement. And you make sure that you pay that money, or you give them that good on time, on the shorter time possible. The more they delay, the more they cause problem to the oil field. Because sometimes they can just stop the car, they can just come to the OBC, Operation Base Camp, and say nobody's going to work today. Shooting them is not a solution. Harassing them is not a solution. So it's good to address their needs amicably, and then you resolve the matter because you are with them most of the time. Again, the land, I don't know the policy here, where they are staying, this land is being leased. If this is oil field and you are staying here, where you are staying is being leased, and there's a payment every year. You make sure that money also goes to them. Because when you are a contractor, the land does not belong to you. It belongs to somebody that is there. So you are leasing from there. If you are leasing from the government, you pay the government and the government will pay them. If the government is not paying, sometimes government don't pay. You go to them, they said, we are supposed to get this money from our land this year. The money didn't come. You go and sit. If it is like up to 10,000, you can pay, no problem. You shoulder this one because you're good to have a good relationship with them. Because in our country we have 3 blocks. One block, what they have adapted, in which I was part of it in terms of education, is that these students of that particular area, even if there are 200 or 300 people, if they set for secondary school certificate and they are going to university, all these students are sponsored by the oil company. Parents don't pay anything. When they quarrel, we said, we have no money, maybe we can stop the fee that we are paying for the student. They say, no. We want our kid to study. We can solve this. Because let them also see some tangible benefit that come to them. In that way, they can listen to you. But if they're getting nothing, it's a problem. It's always good. Those compensation things will always be arising. It's always good to develop a mechanism of controlling this situation without going to arbitration. Because if you will go to arbitration, you have too much muscles. You have too much muscles when you are oil company. You have money. You have connections. You can even delay the process. You delay the process, the transformer oil is gone. The car is arrested on the road. Some engineers have been beaten. They said, here, you are not coming here. And then you have a better relationship. And then the NGOs will come in and they said, you are humiliating the local population. Thank you.
Thank you so much, Dr. Yak. Our time is past. Please help me appreciate our panelists. Thank you so much. I think we've all appreciated how complex the energy transition is and how international arbitration has to evolve with it. I request that we take a picture here. Thank you so much for joining us and being part of the audience and for the engagement. I'll hand over to the program organizers.
Can we give a bigger round of applause to Edith and the panel? So we're running a little bit behind schedule. I would like to invite to this stage Lady Justice Susan Odongo, Judge of the High Court, Commercial Division. She has a long, illustrious career, having worked previously at the Attorney General's Chamber. I would like her to introduce her panel and also tell us the next session that we'll be taking. Please give her a round of applause. Welcome, Lady Justice.
My lords, good morning, our distinguished guests and participants. It is my pleasure to moderate this morning the discussion on disputes to integrate, from disputes to integration, the African Continental Free Trade Area Disputes Framework as a catalyst of resolving trade disputes and boosting intra-African trade. To help our conversation, we will begin with the keynote address and transition into a panel discussion. Just as a brief, we will look at the African Continental Free Trade Area Agreement, which is acronymed as AFCFTA. Since its entry into force in May 2019, the agreement has been described as the most ambitious economic integration initiative on the continent. By this agreement, Africa chose to speak with one voice. Africa opted to repaint the canvas on economic integration. So what did the African state parties choose to do? They chose to create a singular continental market for goods and services. They opted to promote intra-African trade and also enhance economic integration across Africa. However, for such a large market to function effectively, it is very important to have a predictable and credible dispute resolution mechanism for the state parties. And one of the keys of the AFCFTA is the dispute settlement mechanism established under the Protocol on Rules and Procedures for the Settlement of Disputes. This system provides a structured process through which state parties can address disagreements arising from the interpretation or application of the agreement. So you note there is that, that qualification. State parties, not just anybody, and they are limited to the interpretation and application of the agreement. The dispute settlement mechanism has a number of layers: consultation between state parties, good offices, conciliation and mediation. Panels are established in case the parties are not successful with their consultations, and parties can as well escalate their disputes to the appellate body. That said, Africa continues to deepen economic integration. The questions surrounding trade governance and dispute settlement demand both wisdom and expertise. And these are conversations that require voices that are able to connect principle with practice and continental vision with institutional realities. Today, our keynote speaker is one such voice. 3 years of experience and distinguished engagement in this area, they have contributed significantly to shaping the dialogue around the issues that concern dispute settlement and generally the AFCFTA. Distinguished audience, please join me in welcoming Dr. Joy Kategekwa. Dr. Joy, allow me to call you that, serves as a director of the African Development Bank Group's Regional Integration Coordination Office, leading the team delivering the bank's transformative Integrate Africa portfolio. Previously, she served as Regional Strategy Advisor on Africa at UNDP in New York, overseeing creation of the African Continental Free Trade Area portfolio. Dr. Joy is a respected international trade and investment lawyer with a firm conviction about Africa's ability to prosper through efficient utilization of its vast assets. She has dedicated her 21-year career to structuring Africa's trade policy, negotiations, and industry landscape for sustainable development, and to ensure that Africa's integration into global trade is beneficial and wealth-creating. Dr. Joy, we do welcome you, and we are eager to hear what you have to say. We are yearning to hear your reflections as relates to the topic that you're going to present to us. Please, Dr. Joy. Thank you.
Thank you very much, Lady Justice Susan Odongo, my sister, my friend from law school. It's such an honor to see you in this space.
Good to see
And
you
thank
too,
you very
Joy.
much. Thank you very much, Francis, for the kind invitation. Francis is always on the cutting edge of thoughts and conversations and convenings that transform Africa. So I do want to recognize that. When we talk about from disputes to integration, the AFCFTA's framework as a catalyst of resolving trade disputes and boosting intra-African trade, I thought about how to simplify and contextualize this conversation. And so I thought maybe I'll try to answer a few questions. The first one is whether Africa can afford not to integrate. The second one is why the AFCFTA is important in that equation. The third is, well, how do disputes enter that? And then the fourth is, how do lawyers help us to go further? And in all of this, I'll have helped us to sort of situate the conversation around how disputes can and should be the catalyst. And by the time I conclude in 10 minutes, I'm really hoping that we've agreed that there's value in testing out this system and that we might be part of those who test it out. So let's start with, can Africa afford not to integrate? You know, we often talk about a world that is complex. We've heard about VUCA, so volatile, uncertain, complex, ambiguous. And as if VUCA were not enough, we now have a new leadership framework that helps us to understand the complexity of the world in which we are. And analysts are calling it BANI, the BANI world, brittle, anxious, non-linear, incomprehensible world. In this complex world, if there's anything of a lesson for Africa, it is the criticality of building resilience. It is the criticality of looking closer to where you are. It's the criticality of strengthening your own production systems. And the continent of Africa is in good stead because for a while now, COVID taught us that Africa must build its industrial base. Africa must integrate in that way. Can we afford not to integrate? Well, you think about this 55 countries, all of them powerhouses with major, major endowments, but none of them solid enough to go on their own. So you think about countries where maybe only 4 have populations above 100 million people, where 48 countries have populations under 50 million people. You have countries where 16 of them are landlocked. And you just think about the economic promise that is foregone when countries try to go it alone. And therefore, in the context of Africa, in a BANI world, integration is not a choice. Integration is not something that might be nice to have. It's at the core of development strategy. It's at the core of building resilience strategy. And so what does the AFCFTA have to do? How does it get us to integrate? As Lady Justice told us, it is really a gateway to integration through trade law, that countries are agreeing through this African Continental Free Trade Area to give each other treatment that will remove aspects of discrimination. And so when you think about it, 2 major pillars, that for goods and services coming from outside of our country, we shall give them treatment no less favorable than that which we give to any other country in the world, right? Most favored nation. But that when they enter our jurisdiction, we shall give them treatment no less favorable than that which we give our own. This is important for understanding that this notion of treatment and the promise of treatment that's non-discriminatory is at the core of how the AFCFTA seeks to advance integration. So we've seen that integration is important in this BANI world. We've seen that the African Continental Free Trade Area creates a rules framework that anchors that by building non-discrimination. Well, what then do disputes have to do with that? Lady Justice has told us about the understanding on settlement of disputes. She's given us a sense of what is there in terms of interpretative value and application of these agreements, these non-discrimination agreements. And so I'll probably just add by talking about the scope. What is in the body of this huge agreement called the AFCFTA? So you think about goods, trade in goods, you think about trade in services, you think about intellectual property rights, you think about investment, you think about competition, you think about special, legal provisions for how women and youth-led enterprises interface with the One Africa market. And there you have this huge scope. this scope needs to be implemented, because outside of implementation, it remains a promise that's somewhat far from the reality. So since its entry into force, as Lady Justice told us, there have been some important things. The baby is 5 years old. So you've had 5 years of implementation, much of which has been spent by finalizing negotiations and the annexures and the schedules, you know, the sort of parts of the legal instrument that the countries give to the Secretariat to say, well, because of this treatment we have agreed, this is now how our tariff structure will look. This is now how our services regulations will look, that sort of thing. But there have also been particular moves on the export side. And here you're looking at the Guided Trade Initiative. You may have seen several heads of state flagging off consignments, shipments leaving one country to another, from Kenya to Ghana, from Rwanda to Ghana, for example, just to give to explain the point, from Cameroon and so on and so forth. 39 countries have signed up for this Guided Trade Initiative. And when you look at the numbers, about 5,000 certificates of origin have been issued, which means that these products, goods, services are saying that they've been made in a state party of the AFCFTA, are entering the jurisdiction of another country and are testing out that non-discrimination. So why don't we know much more about it? Is that enough? Is that the ambition? How do we scale? And this is my last point. This is where lawyers can help us to go further and faster. When we think about the AFCFTA as a public good, a development accelerator that has done this great thing of transforming and shaking up the landscape in legal terms, we must be part of how it is tested. And so testing it is essentially about what has happened in these spaces of the Guided Trade Initiative. When we talk about these numbers of 5,000 certificates of origin, what has been the experience? Is the treatment actually given? Now, some will say, well, Africa, in terms of our predisposition, our approach to issues, well, we don't really confront these issues. I don't know that that is true. Because when you look at what happens in the specifics of the regional economic communities, you hear that the courts are active, testing out one issue or the other. But also when you think about the AFCFTA as an invitation to industrialize, we know that there's friction in these processes. And so how is it that we can utilize the AFCFTA dispute settlement mechanism? Perhaps through arbitration, perhaps through ADR, as Lady Justice told us. This is 3 ideas I give to you for consideration. The first one is to test out and understand what exactly has been the experience of those that have participated in the Guided Trade Initiative. How have they experienced the treatment issue? The second one is to engage with sort of governments to make them understand the strategic importance of bringing to bear and testing out the veracity of the promises in the treaty. And then the third, of course, is to mobilize yourselves and private sector to ensure that the first case is brought. So thank you very much, Lady Justice.
Thank you very much, Dr. Joy. That was very insightful, and we have learned quite a lot about what you have spoken to us in relation to the AFCFTA dispute settlement mechanism. We will now transition to our panel discussion, where a distinguished duo of experts will speak to us about their reflections in relation to what has been presented by Dr. Joy. Like they say, wisdom is like a baobab tree. Not one person can embrace it. So we'd want to hear the reflections from our 2 panelists. We have Ms. Kolofelo Kugler, who is the head of trade at BESO. The head of trade at BESO, a Swiss trade compliance tech startup. She's also a non-resident scholar in the African program of the Carnegie Endowment for International Peace in Washington, D.C. Previously, she was counsel at the Advisory Center at the World Trade Organization Law in Geneva, Switzerland, where she represented developing countries in the World Trade Organization disputes. She was also a PhD fellow in the Trade Law Project at the University of Lucerne, Switzerland. As a consultant, Kolofelo served as a legal advisor to the AFCFTA Secretariat for negotiations of the AFCFTA Digital Trade Protocol and was instrumental in drafting the protocol and its annexures. Our other panelist is Mr. Benjamin Ingeno, who is an associate at LaLave. He specializes in international, commercial, and investor trade arbitration with a focus on African markets. Building on the keynote address, let me turn to Ms. Kolofelo. Please allow, are you online?
Yes, I am. Good morning. Thank you very much, Lady Justice, and thank you to all the conference.
Good morning.
Yes, it's good to see you.
Good to see you. Good to see you. I believe you are following Dr. Joy's keynote address.
Yes,
yes.
Which is a very tough act to follow, I must say. Good morning, all.
Good morning.
So I think I would address essentially 4 topics on the issue and largely just expanding on what Dr. Joy has already laid a very adequate foundation, speaking about any criticisms to the fact that the AFCFTA dispute settlement mechanism seems to replicate the WTO's dispute settlement mechanism.
I don't know how the sound is on your side. It seems to be a bit.
I will speak a little bit louder. Is this better?
There's a bit of a slight echo somewhere there. Try again.
Okay. Is this better?
I think that's better, yes, that's better.
Okay, I will try and just keep to this level. I'll also address the issue of foreign shopping between the AFCFTA dispute settlement mechanism and potentially with any of the RECs dispute settlement mechanisms. And also, consider whether ADR or, dispute settlement would serve as a catalyst, as Dr. Joy has set out, for trade in Africa. And then finally, just make a few comments about if we're sitting here 4 years, 5 years from now, what would be the indicator of success of dispute settlement, especially when we're looking at alternative means of dispute resolution. I think, let me just start by saying that borrowing or institutional borrowing is not necessarily a sign of weakness, especially in the trade space. You can look across trade agreements all over the world. The WTO's dispute settlement mechanism has been the gold standard. I struggle to find, any regional trade agreement that does not look like the WTO's. So borrowing is not necessarily a bad thing, but I think what we need to think about and what needs to be implemented in the African context is Africanizing it sufficiently for our own realities. So I think I will suggest probably 3. We should look at a system that is more accessible and less litigation heavy. I can give you the WTO's numbers since 1995, 30 plus years. There's been over 644 disputes that have been filed at the WTO, with over 350 panel reports, or at least dispute settlement reports that have been issued. Yes, we know right now the system is facing a bit of a crisis, but it's still one that's being used. Now, some of these disputes have been huge disputes, very high stakes disputes. And let's really face facts. In Africa, the majority of trade frictions, and generally in the world, are not these large-scale disputes that require these large-scale types of litigation, in a formal way. We have many practical border delays, licensing delays, standards issues, and as we've seen across even the EAC region, temporary border restrictions or bans. And so, assessment system that relies too heavily on formal adjudication may cause a lot of delay, and they may be very too slow and too costly for these everyday problems. So we must really think about using and equipping and institutionalizing the good offices, consultation and mediation structures that we already have in the AFCFTA dispute settlement mechanism under Article 8. Secondly, we really need to focus on implementation rather than ruling focused. Of course, it would be great to get decisions, but without implementation, really those decisions are empty. So even sometimes when a winning party wins a judgment, that judgment can be empty if it's not implemented. So in the African context, we really need to concentrate on emphasizing compliance roadmaps, phased implementation, perhaps even technical cooperation alongside dispute resolution, especially for that party that does not win, the so-called losing party. And finally, if we don't recognize asymmetries in legal and institutional capacity across states, the system will just never be used. So we need to recognize that African states have got different trade litigation capacities. Some have got more, some have got less. Without the support structures, technical assistance, balanced panel rosters as well, the stronger countries will be the ones with a benefit from the system while the weaker do not. Secondly, just a note on forum shopping. And this seems to be a fear, but I think we all know that Africa's trade regulatory infrastructure
on forum shopping,
Yes.
I would like you to highlight the fact that under the RECs, the regional economic communities, there seems to be a more accommodative dispute settlement mechanism.
Yeah.
So maybe you could juxtapose the two under the RECs and the AFCFTA agreement. Thank you.
Yeah. I think, it's kind of maybe not that complicated under the AFCFTA. I think the AFCFTA is quite straightforward. It really does state that any dispute that is initiated under the AFCFTA dispute settlement mechanism may not be instituted under the RECs. So there is really a clear signal that there wouldn't be any forum shopping in that way. And so, but I think, as maybe you allude to, there would be an opportunity for more cooperation institutionally. I think really sometimes it's not about jurisdiction, but rather applicable law, right? Sometimes a matter may fall under two agreements under the REC or under the AFCFTA, but maybe one agreement is more closer to the facts and the realities at issue. So I think really this just calls for cooperation. Of course, litigants are free to use whichever forum they want. Sometimes, depending on the issue, if it's an issue in, for example, EAC, where it's a customs union, it will make more sense to go to the EAC Court of Justice. And so, rather than creating complexity or competition between the systems, let's think about how the ecosystem can mutually reinforce and support each other, making sure that the issues are dealt with in the most appropriate forum under the most appropriate agreement. And last but not least, let's maybe think about the broader, case of what does dispute or what does a strong dispute settlement system really mean for African integration and African trade. And really, a strong dispute settlement system serves as a signal that African countries are open for trade, right? It's got a preventative effect, right? A credible dispute settlement system can catalyze trade. A credible dispute settlement system reduces uncertainty for traders, for investors. A certain dispute settlement system serves to discipline state behavior and state action. And of course, it decreases the political cost of litigation or losing cases. When dispute settlement is depoliticized, then it's really just that. It's part and parcel of doing business on the continent. And this is something that really, as Africans, we need to embrace, that litigation or dispute settlement is not a political slight. It really is about increasing trade, cross-border trade across our nations on this continent. And if I may just finally look forward in 2030 and just think of, what is it that we would have achieved if we had really instituted a dispute settlement system, whether it be ADR or strengthening what we have in the AFCFTA dispute settlement systems across the agreements. And I think it's really not about a high number of cases. To me, high number of cases show that there still is trade friction trade friction happens all the time, but if the system is really very, very litigious, then there isn't, a really fundamental problem. But for me, it's rather whether trade barriers are addressed quickly and predictably, and really, of course, whether African businesses feel confident to trade across borders. We know that intra-Africa trade is sitting at about 16 to 18%, depending on what database you consult. As a comparison, intra-regional trade in the EU is sitting over 60%. So this is really what an effective dispute settlement system would try to resolve. Making sure that African businesses feel as comfortable as trading in Uganda as they are, between Uganda and South Africa, Uganda and Nigeria, Uganda and Egypt. And this is really what I think an effective dispute settlement system would achieve for our continent. Thank you very much.
Thank you very much, Ms. Kolofelo. If you could just briefly, from the keynote address and what you have so far spoken to us about, if you had a mandate to implement just one specific measure or policy initiative to promote effective resolution of trade disputes in Africa, what would that game changer be? Just briefly, maybe in 1 or 2 minutes, you could address us on that.
I can even be much shorter than that. For me, it's a no-brainer. We have to get the traders closer to centers of dispute settlement. I think it's all well and good to have an amazing state-to-state dispute settlement system, but as I alluded to earlier, the type of dispute are probably not ones which we would, take to a state-to-state dispute settlement system that probably takes many, many months. So how do we implement these types of systems within countries, within jurisdictions, within arbitration centers? And I think this is really where this really would unlock the strength of dispute settlement, the strength of creating a predictable ways of resolving day-to-day trade irritants. Thank you.
Dr. Joy, are you still with us? Dr. Joy? Okay, I think she took her leave. Our other panelists will not be joining us, so thank you very much, Ms. Kolofelo. I will open up the floor for our distinguished participants to ask some questions or make comments. We'll limit to 2 questions and 2 comments. There's a hand at the back, if we could have the microphone.
Thank you. My name is Michelle Mawanda, and I think I will be asking a question to Dr. Kolofelo. Just a brief one. From your bio, I see that you worked with the WTO, so I would like you to help us draw maybe lessons from what has been happening with the WTO dispute settlement resolution and the appellate body, the impasse that we have there. What lessons could the AFCFTA dispute body draw from that? And also, do you think that having the regional arbitration is going to be easier on the REC level as a continental free trade area? Because I've seen something like that happening with OHADA, and still challenges of costs accessing the place of where the court is still happens in that same regional community. So do you think that the dispute settlement body of the AFCFTA could be able to resolve that, especially from people who are coming from smaller economies like us here? Thank you.
Thank you so much for your question. I just want to make a precision. I litigated at the WTO. I did not work at the WTO, but nonetheless. So I think, first of all, the first question is that the AFCFTA dispute settlement protocol has already resolved that issue, to be honest. I think that was the learning that the African negotiators saw in real time from 2017, when, countries like the United States were systematically gutting the dispute settlement system of the WTO until 2019 in December, when it essentially ground to a halt. And if you can remember in our AFCFTA memory, the AFCFTA agreements came into force on the 29th of May 2019. So that's been resolved in that instead of waiting for members to essentially agree on appointments of appellate body members, in the AFCFTA Dispute Settlement Protocol, the Director General and the chair of the AB can decide essentially on who gets appointed. So in that way, we have avoided and we've learned in real time lessons from then. The second question is a really instrumental one, and I think it goes back to my previous comment in that, of course, we would like to and we would celebrate a successful state-to-state dispute settlement mechanism and the AFCFTA working, efficiently. But the reality is that it really takes big cases to go to the state level. There's going to be a lot of discussion and essentially lobbying for a state to take up a case. And it's not every case that will be taken up there. And rather than essentially relying on states taking up a case, we should really be using national courts, creating commercial sections of national courts that prioritize commercial disputes, especially those that are AFCFTA based, and also the national and regional arbitration centers. I'm talking more of commercial arbitration rather than the RECs. Of course, the RECs are always going to be there. Of course, the RECs can be used. But as we know, there's only been 2 trade cases that have been litigated in African RECs so far, in EAC and in COMESA. So in that way, it seems like East Africa is doing better than the rest of the continent. And as we know, this tribunal does not exist anymore. And so I think just for the day-to-day issues that we traders deal with every single day, that would be the most appropriate fora. Alternative dispute resolution as well, of course, should be strengthened, mediation, conciliation, et cetera, rather than really trying to rely on or even overload the AFCFTA dispute settlement system.
Thank you. Can we have one more question or comment from the audience? There's a hand here.
Yeah, thank you very much again to the panel. So Article 27 refers to arbitration and panels from which arbitrators could be selected. What work has been made in that regard? I think maybe there's not enough outreach for us to know how to position our members, practitioners for those panels. Thank you.
Yeah, absolutely. So yes, arbitration in the AFCFTA dispute settlement mechanism is there, it's available, and it can be used. It would be part and parcel of even traditional. As I can say right now, none of the structures of arbitrators or potential arbitrators or even panelists have been established. As of right now, we've only got 5 appellate body members that have been appointed at the AFCFTA. So this is a process that is ongoing to all. And I think really it's how member states sort of engage with the Secretariat, and you, of course, and the Bar Association engaging with your own government as to how do we access these opportunities. And I think this is a really fair question. There's a lot of demand for of course, skilled arbitrators, skilled panelists, et cetera, and I think you'll be very well placed in engaging with the government at how do members of your bar association or your associations access these opportunities. So thank you.
Any more questions or comments? Okay, I'll take it that that is all from our distinguished participants. I want to thank you again, Ms. Kolofelo. It was good to have you. Dr. Joy has taken her leave, but we send our appreciation. Just to close, as the AFCFTA continues to evolve, the relevance and vitality of its dispute settlement mechanism is very important in enabling for the economic integration that the African state parties have envisioned in undertaking this venture. Rather ambitious, but it started off in 2019, and we look forward to having a number of disputes settled within that system. That said, we come to the end of this panel discussion. I want to thank once again our panelists for her insightful contribution and our audience for the thoughtful engagement.
Thank you very much, Lady Justice, and thank you all.
That said, I would like to invite Lady Justice Anna Mugenyi, the head of the Commercial Division, my boss, to give out certificates. I hope our panelist is still available. Ms. Kolofelo? Oh, the previous panelists. We have Mr. Alan Rakakoko. This was a previous panel, my lord. We have Dr. Isaac Yak Tutdale. Apologies if I have not pronounced it well. Oh, that's a move there, my lord. My lord, we have Ms. Aisha Naiga Wamala. Mr. Dr. Jack? We shall have a photo moment with the judge, the head of the commercial division.
Distinguished ladies and gentlemen, I'd like to request one more time that we give a big round of applause to Justice Susan Odongo. and the panelists. Thank you, Lady Justice. Our tea break is now. Would like to invite you to have a cup of tea or coffee, and we should be back here in 10 minutes. So let's be on our feet, allow the blood to flow a little bit, and then we should be back here for the next session. Thank you.
Be humble. in this aspect about it. Our topic for today is navigating a unique African pathway in international arbitration and fostering connections to promote arbitration. As you're all aware, Africa has been lagging behind in terms of arbitration. We've all along been dragged to the international courts, international arbitration, for dealing with aspects of how matters are to be arbitrated. We deal with the parties at the point of bargaining who are at a stronger and a more advanced position, and as such, we tend to be found to be dragged into aspects of international arbitration. Now, this topic we're looking at is how are we positioning ourselves, how is Africa going to position itself in order to now be able to take a stronger mantle in the actual arbitration. We already have seen many countries in Africa, for instance, Rwanda, Kenya, Ghana, taking a lead in this aspect as regards having arbitration now being conducted within their jurisdictions as their specific seats for arbitration. Now, in this regard, I would like to invite our keynote speaker, Mr. Olusopo Sashore. He's a senior counsel and member of the Inner Bar of Nigeria. He was appointed a senior counsel in 2006. He's a seasoned arbitrator and strategic litigator with over 30 years of experience. He's got vast experience in environmental litigation and advises on climate change law, energy transitions, renewable carbon markets, amongst other things. He has significant experience as well in commercial arbitration. Mr. Olusopo is a counsel and legal advisor for a 10 million square meter city infrastructure development project in Nigeria, energy advisor to energy sector investors and transactions involving significant power companies, M&A transactions. He's also a member of ICCA's Consultative Workshop Cooperation Among African Arbitral Initiatives, London Court of International Arbitration, African User Group, the panel of the recognized international market experts of Advisory Committee. Let's put our hands together to welcome our keynote speaker today. You're most welcome. And without much ado, I'd like to give you the floor to take on this topic for us today. Thank you very much. You could, yeah.
Good morning, ladies and gentlemen. As they say in my part of the world, thank God it's Friday. But I'm sure you're thanking God it's Friday because you'd like to hear my paper, not because you want to get out of here. Is that correct? Well, I really enjoyed the session before. I thank you so much, my Lord, for such a kind introduction. Thank you very much. I really enjoyed the last session before the break on AFCFTA, which is a subject that's very close to my heart. Coincidentally, I'm going to be talking about it in the context of navigating a unique African pathway for our leadership in international arbitration. I say AFCFTA because it's also related to the firm that I work at. The name of my law firm is Africa Law Practice International. Africa Law Practice International is a firm which I share with my good friend and brother, Francis Gimara, who is behind this Gumzo, who's one of the people who have put this Gumzo together. And we're in 11 countries across Africa. We are a Pan-African law firm built from within Africa, not from without. And we're very proud of that because it relates to the integration that we all seek so much. And it's part of this project called Finding a Unique Pathway for International Arbitration. But I say AFCFTA because the whole vision behind having a Pan-African firm started with a conversation between myself and Francis 10 years ago, actually, almost to the day, in Washington, D.C. We had several conversations, and instead of attending the International Bar Association conference that we were there for, we ended up, huddling up in different cafes and bars just to think through this idea. And 10 years, we'll all start celebrating the actual 10th anniversary very shortly, but 10 years ago is a long time, but yet not such a long time because it's passed very quickly. But when we conceived the idea, we conceived it around the fact that not only did we want to practice law and make money, but we wanted to look at Africa as a borderless continent, a borderless stretch of land where we could travel within each other's countries and combine our efforts to work together. And we also made one bet. We actually bet on something. We bet on Africa. We bet on something that was called the AFCFTA in 2016. I now know everybody knows how to pronounce it and everybody knows a lot about it. But in 2016, it wasn't so much that anybody knew. But we were aware of it and we believed that that was the future of Africa. And that was the future of Africa disputes and transactions. And that if we built a firm whose raison was related to this, we could succeed. But in doing that, we were betting on Africa, which to many people, particularly those who are not of this continent, they didn't share a lot of confidence in. Now, who can tell me how far the treaty had gone? Now we have 54 countries who have adopted the treaty. I wonder who could guess how many countries had adopted the treaty in 2016. I thought nobody would adventure to do so. I can tell you, 0. There were no countries at all. The idea had been mooted as far back as 1981. The decision to do it had been passed in 2015, and yet none of the countries had yet signed or adopted it. But we bet on Africa, and I think we bet a good bet. And if you think so, could you share me a round of applause, please? You see? So the core of my paper is another bet on Africa, a bet that Africa is going to lead in international arbitration from where it is now, which is not a leadership position. In the paper, I'm going to try and tell you why I think we will lead. And in doing so, anybody who knows me knows that I like a bit of history. And in my love for history, I always see it play out in future planning. It's funny how things from the past can help you in future planning. So I want to tell you that we are often thought of as latecomers into the arbitration party. And therefore, the evidence is there. London, Paris, sometimes Geneva, Washington. These are the centers that now Singapore, Kuala Lumpur, these are the centers that we're often, as the introducer said, dragged to in order to defend or litigate some dispute before an arbitral tribunal, often full of non-Africans. And I've had the occasion of many, many times to be in that situation. It's not comfortable at all. But in the paper, I'm going to talk about what I call African Traditional Customary Dispute Resolution, TCDR. I'm going to talk about the situation of Africa and its experience historically. And I'm going to talk about some comparative doctrines between the countries in Africa. And then I'll show you certain structural gaps that we need to fill to fulfill this promise. And finally, I'm going to come up with some suggestions for the path and the way forward. But first of all, I have to convince you that Africa owns arbitration. I know you've heard Africa owns ADR, but ADR is the great-grandfather of arbitration, and Africa owns both of them. And therefore, for us to be able to be the leverages that will push African arbitration and dispute resolution forward, we have to, first of all, immerse ourselves in the belief and knowledge that Africa is the owner of arbitration, in as much as we are told from the evidence of other cities and other jurisdictions that that can't truly be so. If so, why do we go to London to arbitrate? Well, here we go. When the story of arbitration is told, it's often told in the terms of Europe. It's never told in terms of Accra, Nairobi, Lagos, Cairo, Kigali, or Kampala. In any event, it's never been disputed whether or not you accept my thesis, and this is my thesis. It's never been disputed that arbitration is related directly to law merchant. That is the lex mercatoria. The lex mercatoria, and that is the law merchant, which developed with as soon as the age of travel, as soon as the ships began to travel, that is when the law merchant started. Travel, trade, and transport came together, inevitably into disputes. With travel, trade, and transport came a dispute, because you would do things during trade that would cause disagreements. So the merchants decided to find a quick way in which they could settle their disputes without having to drag themselves into the jurisdictions they found themselves, so that they could make their way to the next port or the way home. So the lex mercatoria, the law merchant, is at least, if it's not the great-grandfather, it is the great-uncle of arbitration. But then we're told that this is owned by Europe. It can't be true, because these merchants, as we've seen through the history books, and I put citations there, when the paper is circulated, you'll all be able to appreciate it. It shows that many of these voyages had come to Africa, places like Egypt, places like Mombasa, places like in West Africa, the entire Gar region, which is now called Ghana. And they had come there in the 1400s and 1500s. And there is no doubt that they were influenced by the kings and queens and lords they met there, and the manner of consensus building in order to resolve what would otherwise be a conflicting situation. And so the African continent has traditionally resolved their disputes through a voluntary submission to elders, to chiefs, to lineage heads, and to community councils. And the objective was always to keep harmony. The decisions were not so much judgments as they were remedies, which I'm sure you're familiar with, those of you who are all arbitration experts in this room. It isn't so much a decision that you're after. You're after a remedy to a wrong. You want a solution to a problem. And this was what African chiefs and the communities had been doing since before the medieval times. And so this practice is still noticeable in many traditional societies today. And these practices have existed alongside and in spite of the formalized court system. Arbitration was therefore only introduced to us in this modern form that you see it through the efforts of the colonial invasion of Africa. And that's when they brought statutes that were built around their home statutes, particularly the British, and introduced to us a concept which quite clearly we were already very familiar with, where private dispute resolution, as opposed to public dispute resolution. The court system is what we call public dispute resolution. The self-appointed party-given jurisdiction is what we call the private dispute resolution system. And so I need you to be able to accept, because many of you are decision makers. I'm sure future or probably present attorneys general may be in this room. When you become Attorney General, if we don't have this mindset, it'll dovetail into many of the decisions that I'm going to talk about as we go along. So it was in the post-colonial courts that we then found ourselves having to shift and sometimes abandon what I call TCDR, our traditional customary dispute resolution Remember that phrase, TCDR, because I'm going to come back to it. And we started abandoning it in favor of this court system and this newly introduced version of what we'd all had called the arbitration statutes that the colonials had brought. But certain countries, and I'll talk about mine because I have the court decisions at hand, but I'm aware it happens in East Africa a lot. In certain countries, it was until certain countries started to recognize traditional customary dispute resolution in court cases. So there would be a land matter, a land dispute, and one of the parties would plead the fact that, well, we had a meeting of elders or a meeting of the chiefs, and he had said that this is the position that he takes, and I had said this is the position I take, and the decision we had both agreed to came out of that matter. Now he brings me to court and he's saying something else. Court, you can't allow him to say something else because we had said so, we'd agreed on something in the traditional fora that we held. And the Supreme Court of Nigeria accepted this view and said there are certain features of traditional customary dispute resolution that it would accept as, and some of the lawyers in the room will be familiar with this phrase, as res judicatum. That means a situation that you had pleaded before, you had litigated before, and you cannot resile from. And this was a breakthrough because it meant the traditional court system, albeit now populated by Africans at the helm of affairs in the highest court of the land, was saying that they recognized that there was a parallel dispute settlement system that was going on. And if you came to plead it before us as a defense or as a shield against a party trying to deny the position he had taken before, they would recognize it as res judicatum, and he would be stopped from resiling from that position. And when the Supreme Court did that, in the first time it did it in Nigeria was in 1981, and it was a huge breakthrough, and several cases followed that decision. And now, in many of the common law jurisdictions, you find customary arbitration, as it's also known as, customary arbitration being formally recognized by the courts. And so if the courts have recognized that there is something that existed before and still exists now, how can we then, as modern-day international commercial law practitioners, still be thinking or behaving or drawing up contracts or approaching dispute settlement clauses as if we are aliens to something that we've just learned, something that we're just trying to catch up with, something that the Europeans have taught us and we know very little about? So I think we need to unlearn that attitude. We need to change that attitude into the belief that, yes, when we come up with dispute resolution mechanisms, these are ours. These are ways in which, and I'll demonstrate some other ways, some features. These are ways in which we have always brought remedies to our societies. And these communities had certain features that you could still recognize in today's world. The parties, first of all, accepted the decision immediately after it was pronounced. Either party would not reject the award or the decision at the time, and they felt they were bound by it. They felt they were bound by it, even if only momentarily, until they felt that they could try and somersault. And even sometimes you could see the semblance of oath-taking. Now, I've tried to practice my Swahili, but it's not very good. And I know there's a Swahili phrase for what we call taking a juju oath in West Africa. It's Kiapo Cha Karihobo. I don't know. I'm not sure. Nobody's laughing, so maybe I didn't get it right. Did I get it right? I did well. Okay. I'll clap for myself. Where both parties agree, voluntarily agree. Another feature of the customary arbitration is voluntary agreement. Isn't that something you recognize in modern-day arbitration? There were oath-taking. There was a voluntary agreement. There was a huge degree of consent to the process as well as to the procedure. You knew the procedure that the Council of Chiefs or the elders were going to adopt. And so that was the involvement of parties. Again, you can see a party-centered, a party sort of controlled to an extent process that dealt with consensus building. And these were the features. And I could point out some more, but I don't have much time, so let me try and move on. I'd really like to participate in the panel sessions. So, we've established that before the English statutes, we had a robust system of arbitration, customary albeit. And so we shouldn't, I know how difficult it is, somebody said it earlier on today, how difficult it is in negotiating, some of you who are in-house counsel or advisors to big corporations, how difficult it is to have an upper hand in an international contract being financed by a Western country, institute, or company. How the financier often says, well, if I'm going to give you my money, I want Paris arbitration. But I know that there are systems, I know there are methods, and we'll talk about some of them, in which you can resist that insistence on going to Paris or London. My tie is straight. So, as things went along, as it turned out, whilst we were abandoning our customary arbitration only to come back to them in the 80s and the 90s by the sheer dint and stubbornness of our newly found judicial officers occupying the apex of our appellate system. Statutes began to emerge that were African-led legislation from African legislators, and the difference became rather clear. Many of us now have more modern statutes built after what we've called the UNCITRAL model law. But the UNCITRAL model law, by the sheer grace of God, actually had Africans sitting in the law commission. And so there was an input there already. But we still haven't got to where we want to go, and we'll keep doing it. Now we have very renowned centers. Some of them you know very well. I'm not going to bore you telling you about the center here in Kampala, the center in Nairobi, in Cairo, in Lagos, in Mauritius, and all of them. In fact, interestingly, the Mauritius Center, I don't know how many of you know that, was cheekily started by the London Court of International Arbitration. And the idea was to make it a satellite on the continent. So they recognized the market was here. They recognized the disputes in Africa were there. And they recognized that maybe there was a dearth of centers. And they recognized the fact that maybe you wouldn't always want to come to London. And they recognized there was even talent here in Africa that were experts and counsel. And so they thought, well, why don't we bring London to Africa? Maybe that'll keep them here. But thankfully, that relationship didn't last very long. They've left, and MIAC, the Mauritius International Arbitration Center, still exists. Sometimes when you want a neutral location, I have used it with great success, and I think I would encourage everybody to do so. So, another piece of evidence, and this is a very funny thesis that I have, and I'll just try and describe it to you. I tend not to read. You know, Africa, having had this informal yet recognized and binding process of traditional customary dispute resolution, TCDR, having had it infused, albeit unwittingly and without being acknowledged, into what has now come back to us as international commercial arbitration. They came here, observed something, took it away, wrapped it around, and brought it back as something modern and brand new as international commercial arbitration. Yet we found ourselves in this hegemony, a web of intricate institutions that had institutionalized themselves in what was a growing industry called commercial arbitration, a growing multi-billion-dollar industry in which we played little or no part at all in the 60s. But later, a couple of decades later, a chap called Lord Harry Wolff decided that, well, was told to decide to find a way to reform the court system in the United Kingdom. And he's important not because he's from the United Kingdom. He's important because what he then came up with is called the Wolf Reforms. And the Wolf Reforms then found their way into almost every common law country in their own reforms. They were not called Wolf Reforms when they got to our countries, but we took the principles there. And what were the principles that came out of the Wolf Reforms? He was trying to take away the civil procedure, and there's a reason I'm saying this. He was trying to take away the civil procedure of the United Kingdom from the 18th century and 19th century strictures of council-led process, of strict adversarial rules. You can't do this, you must do this, you must do this. He was trying to step that aside and bring in a more party-centered civil procedure process in the courts. Suddenly, judges were doing case management. Victims' interests were being looked at. Parties had more say in how many witnesses and how long the case would be heard for. And all these relaxation of a new procedural philosophy came out of the United Kingdom. But when we then analyzed it, we found that Lord Wolf was largely influenced by international commercial arbitration. So here was a civil procedure system in the public dispute resolution industry, the courts, going to borrow from the private dispute resolution system, arbitration, now called international arbitration, to bring some of those principles into civil procedure. When I started practice, you argued your case on a given day. You filed a motion on given days, and people, what the parties wanted was of no moment whatsoever. It was you and the judge in the interest of the party who was either at home or on the back benches. But here was a new approach. And what was he doing? He was borrowing from international commercial arbitration, which I have just theorized, had itself borrowed many of its principles from traditional, customary African dispute resolution of before the medieval times. So we traveled full circle and brought back into the civil procedure system of the public system principles that were certainly African in origin. And it's right there. Before the Wolf Reforms, you wouldn't have this exchange of written addresses, party-driven procedure, and all the other things that are now in our system. This is important because judicial case management, procedural proportionality, the encouragement in the court systems now, encouragement of the parties in the court to go to ADR. And now we have things like multi-door courthouses, where judges now direct you to go to mediation at stages in your litigation process. And so that reverse influence is not amusing because it's amusing for the sake of it, but it's something that if we don't notice, it again leads to a loss of our identity as owners of ADR, as Africans. So even in the court system that we now practice today, we should encourage more ADR. We should encourage a higher influence of multi-door courthouses and leave the difficult, untractable, and maybe only criminal matters to the courts to be able to deal with, so that we can have this more consensual approach to our particularly commercial disputes. So, I'm making good progress. Am I boring you? You dare not. Don't try it. Don't say yes. Don't try it. But there's some critical gaps. And I'm sure in the course of the last 4 or 5 days, you've heard some of this before, so I'm not going to bore you with all of it. But it's inherently inherently interwoven with my suggestions. And I'd like you to pay attention to my suggestions. So if you choose to ignore me throughout my talk, wait for my suggestions. But so this part you must listen to because it's connected. The critical gaps that exist. And I'll just name them and then talk about them. Because of the colonial maps that were drawn for us prior to the 1900s, we have a patchwork of fragmented legal frameworks across the continent. from door to door, you see some similarities, whether your heritage was English, Portuguese, or French, but then that was it. Beyond that, you couldn't marry a French system into the common law, and you couldn't marry the common law into a Lusophone system. And so that fragmentation across the continent is one of the critical problems that driving our unique pathway to international commercial arbitration leadership will present. In the OHADA countries, there's 17 of them who've come together and harmonized a good portion of their commercial law. But it hasn't happened in any of the other colonial heritage countries. But so the hope is that with the AFCFTA, which I'll talk about later on, the hope is that with the AFCFTA, we can find greater harmonization across our general bodies of law. This is what UNCITRAL does when it comes up with model laws for certain subjects. But it does so in a patchwork of ways. It's global, therefore it's very unwieldy. So I'm wondering, in the 54 countries, it might be simpler. Nobody would have bet nobody would have bet the way me and Francis bet that 54 African countries could, within 10 years, adopt one single agreement. It was not only the fastest, it is now the largest free market area in the world. If anybody had told you with the skepticism that they have for Africa, they would have said, don't mind them, they can't do it. And in 2016, it looked like that. So Francis must have looked like madmen when we decided to bet on Africa. But now we know it's a good bet. So I'm betting further that, we can slowly but surely start picking subjects. We have our own UNCITRAL in Africa, where we harmonize our laws on certain subjects. And the free market is going to, well, not compel us, it will make it imperative that we do so. Besides harmonization, we have the relative limited participation. We're still on this subject. We've been on this subject for 20 years. The limited participation of African practitioners and institutions in international arbitration. The biases are still there. The discrimination is still there. The biases against the owners of the dispute. A dispute between two companies who are trying to do a contract in Africa, that dispute is then exported into a seat in London. You know what that does? With the huge amount of money that goes out there, talking about fees, talking about hotels, cars, car hires, some shopping. Because shopping must happen now. I mean, when you're during the break time. So these things are exported out of it. And we've been on this subject for 20 years, and it's still happening. In fact, when the School of Oriental and African Studies, the arbitration center led by Dr. Emilia, who some of you Onyema, who you may know, a brilliant scholar and a teacher and a reader in the University of London. And she collaborates with some law firms. And she did a survey recently, found out that 82.2% of African arbitration practitioners had not sat as arbitrators in international arbitration, while 74% of them believed that African practitioners were not adequately represented in international arbitration proceedings involving African parties. Now, you can look that up, and I know she's put it free on the internet, but it is a 2026, 2024 survey report. 2024 survey report. It also reported that 64% of respondents did not consider Nigeria and Kenya to be arbitration-friendly jurisdictions, citing such things as judicial interference. It's not true. Citing such things as delay in arbitral proceedings. Delay? You try doing a ICC Paris arbitration. It takes a year to get your procedural process done. And so these perceptions are there. And inconsistent support for arbitration from the courts. That's not true from my analysis of the cases. But the perception is stronger and is stronger and is stronger. We can defeat this perception, and we'll talk about that in a minute. Consequently, our venues were ignored, reinforcing again the paradox that while Africa possesses a substantial pool of arbitration expertise, its practitioners and institutions, we remain comparatively underutilized in the global arbitration system. What is the other gap? Don't forget, we're talking about gaps. We're going to fill them up later on. Another major challenge is the judicial capacity and the attitudes towards arbitration. You know, having argued vociferously that it's not true that there's excessive judicial interference, but then I must admit that there's a capacity issue as well, because we can't say that majority of the judges or the judicial officers across the continent actually grasp and have capacity built knowledge in what it takes not to interfere. So we need some of you who are involved in government need to try and assist us with that and making sure that our attitudes towards it, because an attitude of one judge in Tanzania can affect, and one judge's decision in Tanzania can affect the perception of unfriendly jurisdiction labeled on that country for the next 10 years. One judge, one decision. And so we need to make sure that that is not the case. I mean, those of you who are litigators, you know about a procedure called the Mareva injunction. It was a shipping case in which the UK courts gave a freezing order. And all of a sudden, everybody went haywire. And it reinforced London as this friendly place where you could go to get freezing orders against ships that were trying to run away from litigation. So one decision, one judge in one case can create a really bad reputation. So we need to strengthen our capacity. That's a gap. And then, of course, there's infrastructure and institutional development. But I don't want to pay too much heedance to that, because there's some difficult places to go to that we still go to go. It's not easy for me to go to Singapore from Lagos. It takes me 14 hours. It's just as bad as those 14 hours are as useless to me as a pothole road in the center of Lagos. So if you think my infrastructure is bad, think about how long it takes me to get to Singapore. So, you know, therefore, we've got to strike a good balance through thoughtful legal reforms, institutional innovation, and a desire to preserve our Africa dispute resolution heritage and maintaining our credibility within the global arbitration system. So, the much-awaited way forward. How am I doing for time? I don't know. Is there a timekeeper? I should wrap it up. Okay, so this is the way forward. This is the solution. So who's going to drums roll? Somebody roll the drum. Thank you. Thank you very much. So what do we have? So I guess the opposite of some of them will be the opposite of the gaps that I have given, but some of them are a little not so obvious. One obvious one is we have to strengthen our legal frameworks. Okay, we have to now make sure that we're all up to date. There's a new law. I think it's probably the latest on the continent, give or take. The Arbitration and Mediation Act in Nigeria, the AMA, which I was fortunate to be part of the drafting committee, made it through a private member's bill through the two houses after 10 years of long, hard-worked lobbying. And I think it's probably the most modern of all the laws. Take a look. If you ever get involved, try and get something. It's a useful piece of legislation. It surpasses in many areas the unsettlement model law as it's presently constituted. But number two is why I say I enjoyed the session before. Another way in which we can navigate the future of African arbitration is to full throttle, wholeheartedly embrace the AFCFTA. Embrace the AFCFTA, and I'll tell you why. The AFCFTA will significantly shape dispute resolution by introducing a rules-based, predictable framework that mirrors to some extent the WTO model, while adapting it to African realities. It's actually Africa for Africa. It is one piece of legislation that comes up with African solutions for African problems. Now, the AFCFTA is a common market law. It's a common market treaty. The big common market treaties before us that have fame and fortune, the EU, for instance, when their treaty was passed, did not have dispute resolution, did not have arbitration, did not have alternate dispute resolution as an option. It just didn't have it, and it still doesn't. It is based, the dispute settlement system is based on the European Court of Justice. And the European Court of Justice got so strong that it was conflicting with many of the home states. In fact, one of the reasons why Brexit succeeded, one of the several reasons, besides many other reasons, was the fact that they felt that the ECJ was too strong for the English courts. And so the AFCFTA submits your dispute to this rule-based dispute settlement body, a centralized dispute settlement body under the Protocol on Rules and Procedures on the Settlement of Disputes, what we call PRPSD. And the beauty of it means that in Africa, we've realized that our trade disputes, however serious they are, will be resolved by dispute resolution. In fact, it comes naturally to us, and one of the examples I always cite is the Ghana and Nigeria dispute of 2019 to 2020. Now, in Ghana, there were hundreds of Nigerian traders, small traders, but making together huge amounts of money. They were trading in all sorts of things, ranging from gold to toiletries, okay? And the Ghanaians were very upset that it seemed as if these Nigerians had come to both Kumasi and Accra to take away their business. And so under the Ghana Investment Promotion Act, the authorities moved in and closed hundreds of Nigerian traders' shops. Closed their shops and said, no, you can't work here anymore, you can't do it. And they cited the rule in the act that said you must be capitalized to the tune of $1 million if you were a foreigner in a small business. And the Nigerians argued, how can we be in a small business and capitalized to be $100 million? At any rate, the ECOWAS law guarantees me free movement and free right to establish. So your Investment Promotion Authority Act must be wrong because ECOWAS law is transnational. And so there was this stalemate for the whole of the Christmas of 2019 into 2020. And what was the outcome of it? There is a court of justice in West Africa, but the two countries did not go to court and did not resolve that trade. The trade dispute was resolved. They did not resolve it in court. They resolved it through ADR. There were diplomatic engagements, there was negotiation, and it ended up in a joint technical committee. So it shows the first instinct of Africans isn't to drag disputes. We still had this system of sitting down, even in a country-led dispute like that. And I also cite another example with a different result, but in a different route that arises in this different result. It's the same result. It went in Kenya versus Uganda, and the series of restrictions instituted by the Kenyans on the Ugandan agricultural products, milk, sugar, eggs, as far back as 2019, despite the treaties between the two countries. And then there was a retaliation by the Ugandans against Kenyan businesses, and then the Kenyan energy regulator refused to give UNOC a license in Kenya. And then Kenya, for some reason, went to the EACJ. And you're wondering, what the hell am I saying when I say we don't resolve our disputes? They went to the EACJ, but the disputes were not resolved by the EACJ. They were resolved by ADR. What happened? Ministers started to sit in 2025. And at the end of it, they agreed to eliminate all tariff and non-tariff barriers. And in line with EAC protocols, they agreed to a joint border committee, and therefore the tensions eased. I'm not on the ground, so I couldn't tell you that it's all hunky-dory and happy-go-after. But I'm showing to you that in Africa, even at the sovereign level, there is more the tendency to settle matters through dispute resolution. And this is the effect that AFCFTA is going to benefit from, because it isn't the first instinct of African countries or individuals to take matters to the public system. So we must encourage ADR, African solutions for African problems. That's what AFCFTA promises us, and making sure that arbitration, the treaty itself makes sure that arbitration is a key tool. And because it's a key tool, it focuses our minds towards capacity building. So if you want to make money in dispute resolution in the future, try and learn the emerging dispute resolution regime under that protocol, because it's going to make a lot of difference, and it's going to keep a lot of our disputes on the African continent. So London, Paris, Geneva, New York, we better watch out. We're not coming there anymore. We'll get good shopping in our cities. So the other solution I have, and I only have 6, this is number 3, we must use African seats. The seat that you write into the agreement is more important than the rules you choose, because the seat is the supervisory law that will make sure it's enforced, that will make sure errors are corrected, the errors of the tribunal are corrected. So if nothing at all, choose African seats. Seat your dispute in Africa. Make sure that we insist on that. And we'll make sure that international commercial disputes stay in Africa. Use Africa's experts. You know, the Chartered Institute of Arbitrators, who I'm a proud member of since 1991, has 20% of its branches, and therefore its branch population, on the African continent. It's the largest continent membership in the entire 150-year-old institute. So that means the people who are qualified to train, teach, and practice in arbitration, they are in Africa. It's mind-boggling. Promote only African arbitral institutions. If you can't get the seat, okay, you can't get the seat law, insist that it is an arbitration center in Kampala. And I'm saying Kampala because I'm hoping to get onto the list of the Kampala Center. So this is a shout out to anybody who can make that happen. It's in this room. I'll be seeing you later. So insist on African arbitral institutions. That way, at least we can keep some of that industry. It's a multi-billion-dollar business that is being fleeced out of Nigeria, out of Africa. And finally, reclaim Africa's identity in traditional customary arbitration, dispute resolution and arbitration. We must strategically and consciously embrace the connection between the history of African traditional customary dispute resolution and the future of ADR in the world, in Africa and the world. We must have a cultural reclamation. It is a mindset. We must culturally reclaim and unlearn the fact that it is alien to us and that we are catching up. Espouse rules that we export to the world, because we now have the confidence to say it's a cultural reclamation. We must have a functional continuity of that our traditional system. Functional, in the sense that recognize them, harness them, keep them, modernize what has to be modernized, but keep the flexibility and the accessibility. So that functional continuity will also assist us in ensuring we strengthen them and they don't find their way into the Europe-led rules. And then, admittedly, we must modernize. We must modernize. Where technology can help, even our informal systems, let's make sure that we find a balance between the tradition, the heritage of our rules and modern use of tools. And with that, I think I've given what I think is the panacea. So the future of arbitration in Africa will ultimately depend on the continent's willingness to assert its own voice within the global arbitration order. By modernizing legal frameworks, strengthening arbitral institutions, promoting African expertise, integrating elements of indigenous dispute resolution traditions, Africa can develop a distinctive arbitration model that is both globally credible and locally grounded. In doing so, the continent will not be merely participating in international arbitration. It will help to shape the future of arbitration all over the world. Thank you for listening.
Thank you very much, Mr. Olasopo, for unpacking for us the topic of today. He's taken us through the historical background, taken us through what he sees as the challenges, and given us a direction of what Africa actually needs in order to get to the next level. Now, we have two discussants who are going to discuss your presentation this morning, and I'd like to call upon Ms. Barbara Kelly. She's with us over here. Barbara, if you could join us, and William Okalo could also join us to have a quick discussion of your presentation, and would have further interactions with all of us who are present who would wish to have some contribution. As Barbara takes her seat, I'll just give her a brief bio. She's an accomplished advocate of the High Court of Kenya with over 15 years of experience in financial law, regulatory framework, reform, ADR. She's a certified ADR practitioner with expertise in mediation, arbitration, dispute boards, and serves on the board of several women-led mentorship institutions promoting inclusive access to justice. Barbara's played a pivotal role in supporting the digital transformation of the judiciary through development of e-filing, learning of platforms under the judiciary's enterprise architect, contributing to the draft of Kenya's national ADR policy, and publication of legal case digests on ADR, commercial law, and the Big Four agenda. She's assisted in operationalizing the Nairobi Center for International Arbitration and the development of the 2015 rules. Barbara has a host of other matters. I'll just briefly put it at that at this point. Thank you so much. Let's give her another round of applause. Accompanying her is William. He's a well-respected practitioner with 10 years of legal experience with a great wealth in commercial litigation, criminal litigation, public interest litigation, employment law, conveyancing, and environmental law. He holds a bachelor's of law from Moi University and a postgraduate diploma in legal practice from the Kenya School of Law. He's an advocate of Kenya and East Africa Law Society. Now, Barbara, you've been following the presentation. I'm sure you'd like to have some comments in on what the presentation has been. But before you do that, I'd just like to let Mr. Olasopo know that ADR, from what our Chief Justice Emeritus has put it, really means Africa Dispute Resolution. So you're really on the same page along with him as regards what it means when you took us through the background of what Africa has done and how actually dispute resolution stems from and arises from actually the dispute resolution. So Barbara, you could actually maybe take us now to the next level in regard to your comments on the large-scale border issues concerning the ADR as presented. Thank you.
So, Supo, allow me to call him that. Sure, Supo mentioned how the different cross-border tensions were resolved through ADR. And it's true, and it is a reality of trade, that the easiest way of getting the clogs out is by sitting down and having a conversation, like what the organizers of this conference called it Gumzo. So the importance, and I think this cannot be understated, the importance of ADR in unlocking trade disputes cannot be understated. That it's very important and it's very pivotal because it addresses disputes faster, more amicably, without tensions from the other party, and recognizing that we must continue with the relationship between the two parties. Now, when you flip that and look at it from a commercial perspective, if this is different investors or different business entities that have the dispute between them and it is cross-border, then it is important that we take a number of steps. And I like to look at this from the perspective of a lawyer and reflect on the conversation that we have had today that has been led by Supo and yesterday by Professor Muigai. And I think this goes back to how we draft, especially our clauses, and how we manage contracts, because it is important that before the dispute festers, we must be able to address it. So either by incorporating dispute avoidance and adjudication boards that are then instituted at the start of the contract. Now, unfortunately in Africa, and this is a reality that we face not just in Uganda, but also in Kenya and in many other African countries, that when we come up with these commercial contracts, we fail to have the boards immediately be instituted and stand up so that they can walk the journey with, especially if it's an infrastructure project, with the clients or with the parties. So when we see the value of ADR, we also understand it is important to manage the dispute from the process of negotiating. So looking at what forum best suits our disputes. The Kenya case that has been mentioned by Supo is a classic example. The EACJ was not going to unlock it for us. They would have issued damages for failure to observe the treaty. But the two presidents, when they sat down in, I think it was Rakitura, am I pronouncing it correct? The issue was resolved. The ministers were told, sit down within the week, give us solutions. You cannot be refusing Ugandan milk to cross. And that was done. Even when the Tanzanians banned Kenyan eggs, and I find that to be very interesting because apparently in Kenya right now, there are no eggs. So we are importing our eggs from either Zambia or Zimbabwe, which makes it ridiculous. And if you to think about the small-scale holders who are busy transacting and going on with the business, they have no time to wait for your political or contractually correct dispute resolution practices. They need systems that can address their issues at the ground, at the moment, and within their lived realities. So it becomes very important to ensure that, especially for commercial entities, that the negotiations of the contracts are looking at predictability, enforceability of the outcomes that come out of it. So when you're drafting the clauses, you're looking at practicality. So removing, especially for the multi-tiered clauses, where you have processes that cannot even be implemented, amicable negotiation between the parties. I've said it before. Who will be doing the negotiation? By when? By what time? If there is no settlement agreement, what drives the next step? Are we going to arbitration? Yes. Before who? At what time? What is the requirement? Is it institutional? Is it ad hoc? So that we make it clear, especially for African countries, how we are going to ensure that predictability when it comes to dispute management. And then finally, I think I would just like to talk about the different roles that the different different parties who are involved in the contracts when you're looking at it from a commercial perspective. It's important to look at it from the legal framework that we choose. So legal frameworks need to be very predictable. If you're in Africa, you will be looking at, there are 42 African states that have ratified the New York Convention. So you do not want, especially as a practitioner, to choose a seat that is not a signatory to the African, to the ancestral model law. And Supo said it, and then yesterday I think Prof also mentioned it. But then I questioned, what is the point of reinventing the wheel when the process already works? The ancestral model law works well. It has some problems, but it works well. Do we need to be looking at a situation, for example, where at the end of the day we will be asked, do we need an Africa arbitration mode, an African investment law, an African model law? I don't think so. I think the question is, can we enforce what is coming out of the different countries when we are doing the cross-border kind of commercial enterprises? And in that answer, we'll be able to address what do we need to resolve or what do we need to perfect so that we can respect the sovereignties of the different countries in coming up with the different legal regimes that they want to. Because despite different countries not being part of the ancestral model law, business is still being done there. So we should be looking at it from the perspective of how do we promote predictability, enforceability, and competent decisions that are coming out of the different forums.
Thank you very much, Barbara. Now, if I may ask William, as a practitioner, how do you see you positioning yourselves in the next generation of arbitration as African arbitrators? It's not just as observers, but actual participants, active participants as a legal practitioner in this. What do you think about that now?
Well, thank you, and also to Oleshopo for the very informative talk that he's given. Africa in the future as a continent needs people that understand what exactly is befitting for Africa. What better stage to bring the younger generation of advocates, the younger generation of arbitrators into this thing that we believe in than when they come fresh from school. It is time that we started looking at Africa as having solutions for Africa by the way we train, by the way that we integrate the students that come into the field, by providing solutions that are African-based. If we are to continue with what has been in the past, where we are rushing to London, we are rushing to Paris, then the best that they can do is what befits them. And if we are alive to the fact that Africa is the next frontier for any market, whether it is in gold, whether it is in oil, energy, and what have you, it means that most of the disputes that we are going to have are going to be African-related. Now, we need to have structured training and skill development that can encompass the situations that come to this continent, Africa. What we are doing at ALP from a very young age is to pick those that are still in varsity. Some of them we have to take them through school. We have to pay their school fees so that we can, from that very young age, we can model them into what we believe that is Africa by Africa. So we take them through the training, and we believe that we have the package that it entails for us to bring in the next generation of arbitrators in Africa. You can see a program like this is part of the structural and deliberate skill development that we have, that anyone who would want to be participating actively in commercial arbitration in Africa would be missing out largely if they are not in this conference. So the best way to make this an important thing is by starting with those that are coming up in the arbitration and ensuring that they have the content that we need. Also, by organizing conferences like Gumzo La ADR, right from the name, is a dialogue. So we're giving that opportunity, we're giving that platform where we are sure that even from the attendance, we can see who is attending and see if we are really passing on the baton to the ones that are coming up in this field. And I think it is very important because not just for the practitioners as lawyers, but also the institutions like the Judiciary, institutions like the Ministry of Justice, not just in Uganda, in Kenya, in Rwanda, in Nigeria, all the member states are getting the same kind of content, and we are pulling each other up and not competing just unnecessarily, but believing in each other. And these forums give that opportunity for the younger ones to see that it is possible, because there are those that have already walked that path and believe in it. And also institutions like ACFCTA are very important in partnership, ensuring that the belief that they had when these programs were starting 10 years ago are getting people that can pick and run along with the vision. In the next 5 years, in the next 10 years, could we have an opportunity that this arbitration is going to be the run-to thing? As Senior already mentioned, that ADR was the grandfather of arbitration. And these are things that were entrenched in our culture. Are we losing our culture to the Westerners as we proceed in this legal profession, or can we go back and reclaim that which is already ours? So we look for more opportunities, create more opportunities so that we can train more people as they come into the legal field and understand what exactly it is that we are doing. Remember that in a world where everyone is looking down on Africa, we cannot afford to join them in looking down upon ourselves. Thank you.
Thank you very much, William. I'd just like to now quickly open up this discussion to a couple of questions you may have in the audience. If there's anybody who'd like to ask a question, a comment, we have one up front. Could we have microphones up front, please?
Judge, I don't know if you'll allow me before the microphones get to them.
Pardon?
I don't know if you'll allow me before the microphones get to them to just mention something.
Okay, just before the microphones.
Yeah.
Sorry.
William mentioned something about practice. I think it's important that as we seated here, we recognize that sometimes we develop regulations in a manner that cuts out other countries, especially for legal practice. Mm-hmm. So it's very easy for, apparently, a Zimbabwean to practice in Uganda, but not so for a Kenyan to practice in Uganda. So we need to, in the spirit of the CFTA, free movement of services and goods, we also need to look at our what facilitate dispute resolution competence. So those are things that we need to do when you're thinking about building trust, mutual trust amongst ourselves. Regulatory bias needs to go. We need to look at the regime that allows us to travel cross-country, the CFTA. Those are the factors that will improve the integration or the growth of trade and also facilitate dispute resolution services within Africa. If I need a visa to go to Nigeria and it takes me 30 days to get the visa, I have to pay $250 to get the visa to go to Nigeria. And then we're busy talking about the CFTA. I think we really need to sit down and look at ourselves and ask ourselves a question. What are we doing as practitioners to assist our governments to see that some of these regulations they come up with are actually anti-CFTA, and to recognize the CFTA and to grow dispute resolution in Africa so that we can retain the disputes in Africa. It's actually very easy for someone from the US or Europe to come to several of the African countries, but it's very difficult for Africans to cross across the 55 African states. So those are the questions, or rather, those are the issues that I would like us to push to our governments to recognize, because then they create a favorable environment for dispute resolution and for the growth of capacity of dispute practitioners within Africa in the spirit of Africanization. Thank you, Judge.
Thank you very much. We'll take the first question right in front.
I thank you very much for a very good presentation, Senior, and the panelists. I'm truly excited about the potential of African justice system, as it was coined on Tuesday by Emeritus CJ. I've just heard that ADR has been coined as the African Dispute Resolution. So I'm really excited about how our cultures, how our traditional norms can be weaved in. And it's really a happy day for me that we are having this conversation of AJS in an international arbitration discourse. So what are the ways that we can weave this in terms of enhancing our Africa for Africa very unique solutions for our problems, and especially touching on the international commercial arbitration in Africa. It's quite an exciting opportunity for us, and I would like to hear your insights deeper on that. Thank you.
Thank you. Do we have another? Okay, yeah, same.
Yes, thank you. I'd like to thank the panelists and the Senior Counsel for the presentation. I have two questions. My question firstly revolves around observations I made in the first presentation, as well as things that have been hinted on in this presentation. What struck me is the problem seems to revolve around, firstly, implementation, because the ADR pathway, as I understand it, and arbitration, the enforcement mechanisms all lead back to the court sector, which still does not deal with the problems that the courts face with implementation. So how do we address that so that the remedies that we get at the end of this system actually reflect on the ground? My second question revolves around yes, sorry about that. My second question also revolves around
Thank you. We have one more. This will be up front here. There's one in front.
Mine is not a question. It is to supplement on what Barbara stated earlier on. The need for us to re-emphasize dispute avoidance. From a tech perspective, we find that there's a lot of integration at a technical level, financial level. You find there's so many dynamics in probably a contract. So as we are reviewing contracts, I think for us to make ADR work, we need then to avoid that disputes at different levels. At an SLA level, at by probably deciding, is a dispute a tech dispute? Is it one of financial matters? Is it one that is a dispute around the interpretation of the contract? Because from that, then we are able to choose the right arbitrator with the right skills. If it's technical, then you're choosing someone who is more technical. If it is finance, then you're choosing someone with financial competence. If it is legal, then you know you're probably choosing someone with a legal background, instead of us bundling so many things in one, and we're submitting to one arbitrator who probably does not have the competence to cover everything. So for us to make ADR work in the different corporations, even at government level, is for us to then break down what is the actual dispute. How do we avoid it from ground level at the point of us drafting the contract? Do we need then to have dialogue from at the SLA level? Do we need to have dialogue at the different department level, operational level, so that then we go on breaking down the issue to then probably find what the actual dispute is?
Thank you. Would you like to have a comment or two on any of the two questions that were raised before we go through a last round?
I think the last speaker spoke about a situation where the dispute involved trying to avoid a situation where the arbitrator was not knowledgeable or skilled in the nature of the dispute. And I think the last one was contract stage expertise in order to avoid the dispute right from the negotiation stage, or at least reduce the possibility of a dispute. And you're right, your question is self-evident, the second one at least. the more expertise that is employed in the negotiation stage, the better it is for the outcome of the contract. I find that teams of negotiators who have both transaction lawyers as well as dispute lawyers already involved in the negotiation, there's an assumption that only subject matter experts should negotiate contracts on, say, an aircraft lease, or say a charter boat agreement, or something to do with the wet lease of, maybe code sharing of 2 airlines. I always insist that you have subject matter experts in the negotiation team, and what we call an 11th man, somebody who is not of that subject matter, but his only role is to watch out for risk, and he's a dispute resolution expert. So he's involved in the negotiation. No dispute has arisen, but the dispute resolution expert is involved in the negotiation to foresee what needs to be avoided from his experience as a dispute resolution. He's not a transaction lawyer, but he must be involved in the team that is negotiating. So you're bringing the dispute people closer to the subject matter, closer to the beginning of the value chain, if you like. And we're not waiting at the end to then take the matter to the dispute expert and say, well, we have a dispute. You can avoid it more by putting him in that team. And the other aspect of what you said, I believe, on the contrary, some of the best awards that I have seen have come from arbitrators who know nothing about the subject, because he carries no bias whatsoever. Mm-hmm. And all he's doing is looking for a remedy for where remedy is required, a fair and just decision, fair treatment of the equal treatment of the parties, and giving them the opportunities that they deserve to air the grievances that has resulted in the dispute. If expertise is required, he can order experts to advise him on technical points. Mm-hmm. But I find that the best decisions have come out from non-subject matter experts. And you bear me out, but I've been in arbitration since 1987, so I think just a little experience I have.
Okay, thank you. William, just 1 minute, if you have any parting shot you'd like to give us today.
Well, the reality is that as we progress, most of the areas that are opening up in business, energy, oil and gas, minerals, they're all going to land in a dispute one way or another. And like Senior has said, dispute resolution is going to be part of this greater conversation. So as we engage in setups like Gumzo La ADR, we need to bring in the stakeholders, the governments, the AG's offices, the judiciary, and have this kind of training so that they don't just see things from one angle, but they have the expertise, because we have engineers coming in, we have people that are in the construction, we have experts from different areas coming in, and forums like this are really going to be something that is very important towards the future of African businesses. Thank you.
Okay, thank you. Barbara, 1 minute.
Is that the African minute or the?
No, it is my minute.
I have a lot to say on this subject. How many of us know about good offices? Or have heard about the term good offices? Okay, that's barely 1% in this room. If we are talking about the Africa Free Continental Trade Agreement, we need to learn about its dispute settlement mechanisms. And good offices is one of the mechanisms that have been embedded to resolve any dispute that arise in the implementation of the free trade agreement in itself. So that shows us that sometimes the dispute settlement modality that is chosen is a stranger to majority of the people who are expected to benefit from the CFTA. So I would like to urge us to look at the different settlement mechanisms that are proposed there. There's an investment protocol, there is a services protocol that defines how disputes are to be reviewed. It is important that when we are talking as practitioners that we understand the different dispute modalities or dispute management modalities that exist. And finally, especially in the context of emerging industries, emerging ways of doing business, we have artificial intelligence, we have tech, we have new ways of doing, or rather managing energy, so on and so forth. It is important that we look at what kind of dispute forum is necessary for the disputes that we anticipate. So just like Supo has said, it's very, very important that you have, most like the value chain, the entire value chain in dispute management processes involved in the discussion on contract administration, so that we can reduce the disputes and have more time or put more effort into implementing the CFTA and actually actualizing the dream that one day we will be the Africa that we want, an Africa that prospers. So thank you, Judge.
Thank you very much, Barbara. And I'm not going to leave you out and give us the final parting shot of the wealth of wisdom that you've shared with us today as we go out today. Yes.
Oh. Hello? Okay, all right, I'm on. I think we omitted to answer the question of the lady in white and black over there, where she talked about the enforcement, and she talked about the fact that courts will still have to enforce, and how do we get away from that with all the... And it's a brilliant question. A good number of arbitration awards and into the future will always require court enforcement. A growing number of African countries have ratified and domesticated the New York Convention, which makes enforcement much easier. So courts, to a high degree, will always still be needed for enforcement. But imagine if you had a self-executory award as the award system that is being planned under the AFCFTA will be. You will have found that in the entire process chain of a dispute, at least 70% of it has been covered through the informal, party-driven dispute resolution mechanism the parties themselves have chosen. And you're leaving this 30% for enforcement. And I think it's a huge success. So it's not a sign of weakness of dispute resolution that sometimes you still have to go to courts to enforce. It's actually a sign of its strength. And more importantly, the hope is that under the AFCFTA, we will have a supranational court system, or some sort of supranational enforcement system that will work for the whole of Africa. And so you won't be going to the national courts, and therefore you won't be open to years-on litigation. A supernatural enforcement system from which there are no appeals. But just to put in my final word, is that international commercial arbitration has the role that it plays itself in integrating Africa and making sure that we are at the center of the future of international arbitration. It has its role because the use of neutrals as private people will continue to the foreseeable future. It has its role because it will always, to be successful, it will insist and foster arbitration-friendly economies. And so every country will be in the same directional push to make sure its economy and its state structures are arbitration-friendly, and therefore bringing about more uniformity across Africa. It will help us to continue to build skills, because without the skills, you'll be left behind, and nobody wants to be left behind. So commercial arbitration is something that we must commit to in our own particular ecosystems, as individuals in our own personal economies, to make sure that we are ready, we are involved, and we're at the top of our game. And honestly, Gumzo and this sort of gathering on an annual basis is one of those tools that will integrate and place Africa at the center and in the forefront of arbitration, global arbitration into the future.
Thank you very much, Mr. Olasupo. Ladies and gentlemen, let's put our hands together for this distinguished presentation we've had today. Thank you so much. We've had a brilliant discussion concerning the Africanization or the unique Africa pathway to international arbitration and fostering and promoting the arbitration. We're taken through the historical perspective, showed where we are, where we need to go, and what we need to do in order to get there. So let's give another big hand clap for the participants. Thank you so much. At this moment, I think there's a recognition to the panelists and the keynote speaker. I'd like to call upon our Deputy Chief Justice Emeritus to come forward. Come this way, okay. Barbara, one. William, thank you. And lastly, if we could all just take a step down to take a group photograph.
Ladies and gentlemen, this will mark the end of our morning session. I would like to request that we give a big round of applause to Justice Thomas Ochaya for excellent moderation. Thank you, Justice Thomas. Can we also appreciate Lord Justice Stephen, DCJ Emeritus, for the work well done. So it's time for us to take a short lunch break, and I think we now know where lunch is served, Amber Restaurant. We should be back here by 2 o'clock. I believe that 40 minutes are enough for us to get a quick bite, and we are back here so that we then start to wrap up this Gumzo session. Thank you so much, and see you all at 2 p.m.
Kagwa and Patson Renatwe. I'm not very sure if Mr. Moses Adrico, Senior Counsel, is in the room, but he should be joining us shortly. please allow me to introduce them. Yeah. And I'll introduce senior counsel when he is in the room. So before me are 4 subject experts in arbitration matters. I'm not very sure we could have chosen better expert in this jurisdiction than the people before us. Most of them, or all of them, are already known to you, but allow me to briefly introduce them. I'll start with Ms. Lillian Kiza. Lillian is an advocate here in Uganda, member of the Uganda Bar Association or Uganda Law Society, and she's also the founding and managing partner at Kiza and Kwanza Advocates. Previously, she served as the legal counsel and legal manager at Global Trust Bank, and she has nurtured and developed extensive legal practice in the area of banking, insurance, and land law. She has advised a number of finance institutions on securitization, on conveyancing, and on managing claims and disputes around banking and financial matters. Welcome, Lillian. Thank you. And this afternoon, Lillian will be taking us through drafting robust arbitration clauses. Secondly, allow me to introduce Mr. David Kagwa. I think most of you already know him much better. David is a fellow of the Chartered Institute of Arbitrators, London, and is currently the chairman of the Chartered Institute of Arbitrators in Uganda. I know him as quite a decorated ADR practitioner around. That's how I've always known him. David is a senior partner at Kagwa & Kagwa Advocates, and he specializes in construction and arbitration practice. He's acted as counsel and arbitrator in major arbitration matters under various framework, International Chamber of Commerce, LCIA, Chartered Institute, and even UNCITRAL. He holds an LLM in construction and arbitration law from University of Aberdeen in Scotland, and not very sure about the many things I may want to say about him, just to observe that amongst the people who have watched closely when it comes to ADR, especially in the construction area, has been David Kagwa for close to 10 years. Welcome, David. Allow me to also introduce Patson Renatwe. Patson is an advocate, founding and senior partner at Signum Advocates. He is UK trained as well as Uganda trained in matters project infrastructure, dispute resolutions, and employment matters. He has advised on mega infrastructure projects here and across the borders. And in the year 2022, he was recognized among top 30 rising arbitration practitioners in Africa. David is a fellow of the Patson is a fellow of the Chartered Institute of Arbitrators and also a member of the International Court of Arbitration's Commission on Arbitration and ADR. He currently heads the ADR practice or training at the Law Development Center. Please welcome Patson. And allow me to introduce Robert Kirunda. I don't know whether to mention the other one that many of you also know. I also know him as a prophet. And, and Robert is the founder and managing partner of Kirunda and Company Advocates. His practice is mainly focused on commercial law. He has served as a director at Finance Trust Bank, amongst other companies. He was part of the team that developed Uganda's fourth industrial revolution strategy, commonly known as FIR, and in that team, he led the legal and policy unit that team that was developing the legal and policy documents on science and technology track of the 4IR. He's an accredited arbitrator and a member of the Permanent Court of Arbitration at Hague. He's also a member of the Chartered Institute London and currently heads the arbitration cluster at the Uganda Law Society. Robert, if you wish to call him Dr. Robert Kirunda, has completed his PhD in law from University of Cape Town. And he is also the convener of the Center for Law and Energy Technology, which is also known as CLET, C-L-E-T, not C-L-I-T. So please, let's put our hands together for Robert. If you see Moses Adrico, Senior Counsel, next to you, remind him that we expect him up front. But meanwhile, allow me to go straight into the subject matter. And the format is simple. Each of the experts in the subjects will have about 10 minutes. They will share with you the practical tips in specific areas that they'll be addressing. And once we are done with that phase, we are going to take questions from amongst you. So if you have any question as the practical tips are given, just note it down. We will come once the final expert has concluded. And so allow me to invite Lillian over. Lillian, would you be comfortable here? Would you come here? Please come here. And what Lillian will be covering is the practical tips on how to draft robust arbitration clauses. And the question she will be answering as we begin is, Lillian, is there any other way of doing it? Please feel welcome.
Thank you, Amola. Good afternoon, everyone. This afternoon, I'll be talking about the concepts of drafting robust arbitration clauses, which are usually referred to as the midnight clauses because they come up after long and complex discussions or negotiations. So we all know that an arbitration agreement is a clause or an agreement between parties who are in a legally defined relationship where they agree to submit all their existing or future disputes for arbitration. Of course, today when you're drafting an arbitration clause, it requires moving beyond the standard size fits all language so that you can address all the rapidly changing technological, legal, and geopolitical landscapes. So you have to be very strict in how you draft it. I will incorporate both the traditional tenets and the trending ones whilst drafting an arbitration agreement. So when you're going to draft an arbitration agreement, it's always important to consider the consent of the parties. As Professor Parks, in his insights of general best practices for drafting arbitration clauses, he states that you should in unambiguous ways state that the parties have consented to refer their disputes to arbitration and not to use the national courts. It's supposed to be couched in mandatory language, and you use words like shall or will instead of using permissive words like may. So always couch it in mandatory terms. And there are instances also where a dispute may arise and the parties didn't have an arbitration agreement. When such an instance arises, the parties can sign a submission agreement if they didn't have one prior. In similar terms, you have to name it as a submission agreement if they didn't have an arbitration agreement before. So a submission agreement is signed when a dispute has arisen and the parties didn't have an arbitration agreement but intend to refer their matter to arbitration. So they sign that in similar terms and also proceed to arbitrate. When drafting an arbitration clause, always ensure that the scope of the disputes that you intend to encompass are clearly captured. So you find that one may say any disagreements that arise or relating to this agreement, including breach, termination, validity to this contract, will be referred to for arbitration, and that should be for finality. But also in specific circumstances, it might be good to carve out instances where you don't want arbitration to be in the mix. For instance, matters of fraud, you may carve out on matters of fraud, matters of IP, that is copyright claim, and also injunctive reliefs. So these may not be encompassed under the scope in which you intend to refer your matters for arbitration. You should always consider the arbitral rules also that will apply to the arbitration. You could use the ICC, the UNCITRAL model rules, or the local laws. If it's an institution administering the arbitration, consider mentioning the rules that will be guiding the arbitration process. Always state the law that will govern the agreement itself, as it's usually a source of conflict when disputes arise. Another aspect to consider is the seat of arbitration. The seat of arbitration is just not a place, because the seat of arbitration determines the procedural law, and also the courts that will be overlooking the arbitration proceedings. So when considering the seat of arbitration, it's always apt to ensure that you choose arbitration-friendly jurisdictions, yeah? And seat of arbitration is usually known as the law of the place of arbitration, because it's there that you will have to go to court for enforcement, run there for injunctive orders. So whenever you're drafting an agreement pertaining to arbitration, always ensure that there's a neutral place that you choose. For instance, it might be easy to enforce. If you have had a seat like New York, New York, it may be easy to enforce because it's friendly and it's a signatory to all this. So you should also know that you can have a seat chosen as London, but the hearing is in Paris. So the seat does not necessarily mean that that's where you sit for the arbitration. In your clause also, you should always include the appointment, the mode of appointment, and the number of arbitrators. Now, this depends on whether you're going to use ad hoc means of appointment or institutional means. It's always important to mention the number of arbitrators you intend to, whether it's a sole arbitrator or it's a tribunal of 3, it's important that you mention that when you're drafting. And also always indicate who will serve as an appointing authority in case of default. And if there is any requirement, any expertise requirement regarding the arbitrators, always state it. For instance, you may want an engineer who has 15 years of experience. You should indicate it in your clause so that at the time of the dispute, you're not guessing on who should be the arbitrator to handle the matter. The other aspect is the language that should be used. To avoid confusion and translation costs, it's always important to mention which language the arbitration proceedings will be held. And in consideration of this, you can look at the contract, the key documents that you're going to rely on, excuse me, and also the likely abilities of the likely arbitrators that may be chosen. So, of course, when you choose a right language, you'll not incur extra costs in translation. Or we all know that many things get lost in translation. Governing law, yes, you should always state the governing law. The substantive and procedural law should be clearly stated. And we should know that the law that governs the agreement may differ from the law that governs the arbitral proceedings. So this should always be indicated clearly at the start so that there is no conflict later on. Confidentiality is one clause that is ignored because we all know arbitration is private, but private doesn't mean that it's confidential. So if you think you're going to have an award handed down and enforcement won't happen, and you want it kept confidential, it doesn't hurt to add that the arbitration proceedings and the award should be kept confidential. You should also always include the issue of finality. You state that the award shall be final and binding onto the parties. This helps with closure. So I shall now delve into the training aspects to consider in the evolving environs of arbitration. And these include including AI usage guidelines, if need be, especially where parties will be needing some AI use, and there is a lot of cybersecurity. So if you're considering use of AI, you should always have guidelines so that there are no cyber attacks and breaches therein. Also, for smart contract arbitration or technology-driven contracts, one has to consider specialized rules designed for on-chain disputes, e.g. low-tech, UK digital dispute resolution rules, virtual or hybrid hearing protocols which encourage environmentally paperless practices. You should also address the geopolitical and regulatory risks together with sanctions that may impact contractual performance. Consider how tribunals will handle sanction-related legal sanctions, especially where parties or experts are subject to restrictions. For instance, right now may not be the best time to appoint an Iranian expert or arbitrator for a contract whose seats and enforceability is either in the US or the Gulf. Always add provisions pertaining to ESG, given that environmental, social, governance issues are now prevalent. So you should always address potential claims if you're handling such. Also, do consider issues of sovereign immunity and carefully address waivers in both arbitration and enforcement stages. In complex contracts, there is a preference for provision of multi-tiered clauses, at times referred to as made-up, steps. So this is where parties agree that they will first go for either mediation or negotiation before they delve into arbitration. But when you are considering this, always ensure that the steps are time-bound so that you don't waste a lot of time on those steps which precede arbitration. Also, consider multi-party consolidations, especially in complex and multi-contract or multi-party deals, with clear provisions on consolidation so that you avoid clashing or inconsistent awards. You find that you have to make extra provisions in this because in consolidating, some parties may say they are not privy to the consolidations. So you have to give provisions for what happens if they're not part of the consolidation. Is the award binding? All those provisions have to be taken care of. Also, in an arbitration where parties are from different jurisdictions, the International Center for Disputes recommends that you could add these aspects briefly. These are notice requirements, forum or claim or the counterclaim, the format in which you would have to present the same, the mode of interim and emergency relief provisions, appointment of arbitral tribunal, arbitrator's conflict of interest, scheduling, place of arbitration, power of the tribunal, jurisdiction, conduct of arbitration and taking of evidence, proceedings in absence of a party's participation, allocation of costs, and the form and effect of the award. So whilst you're at seat, you have to avoid some pitfalls during the drafting. And these pitfalls include equivocation. Equivocation is the failure to state that the arbitration is mandatory. So always quote your clauses in mandatory forms. Also, inattention and failure to tailor the clause to specific circumstances. Yes, there are institutional clauses that are given, but they should be modified to suit the purpose. Also, omissions where important elements are left out is extremely unwelcoming. For instance, you could leave out an aspect where you require an expert to have a particular particular years or a particular expertise. If you leave that out, then your arbitration will be left in the limbo. Also, setting unrealistic expectations with impossible deadlines is something that should be avoided, as it's a pitfall, because if you're going, for instance, for a mid-up step, you're going to consider, let's say, negotiation before arbitration. You cannot say that we shall negotiate for 1 day and then if we fail, we delve right into arbitration. That would be very unrealistic. Yet if you dragged it on a little bit longer, let's say a week, probably you could sort it in there. There's also a problem of litigation envy, where one tries to replicate litigation procedures in arbitration. This should also be avoided. So my parting remarks this afternoon are: always use model clauses with modification, keep it simple, be specific, avoid ambiguity as you think about enforcement, and ensure the award will be recognized in the jurisdiction you wish to enforce it. Always avoid asymmetrical clauses that give leverage to one party over the other, as they may not be enforceable in other jurisdictions. Thank you for listening and have a nice day.
Let's appreciate her better, please. Thank you so much, Lillian. That was powerful, and I believe we've taken out tips. Remember when we were having the masterclass the other day and we talked about proper drafting? I think that was a rapid one today, and thank you. Allow me to invite the second expert. That is Mr. David Kagwa. David, I'm not very sure you'll take it from there or you'll come here. Please. David will handle two subject areas. I understand Mr. Adrico SC may not be joining us, and so David will be taking us through tips on selection of the arbitration panel as well as enforcement of arbitral awards. Please welcome David.
Thank you, Huntington. Good afternoon, ladies and gentlemen. In a special way, I wish to welcome our chairman, CIAB Kenya branch, Professor Wine. You're most welcome to Uganda. Yes, my task is simple: to selection of arbitration and aspects of enforcement. And selection, I'll start with one common pitfall that we lawyers face. When you receive a letter requesting you to concur to the appointment of, say, Mr. Chirunda or Patson, you either just ignore it, or you respond saying, I'm still consulting. There is a lot of jurisprudence now from the commercial court that if you behave in such a way that you're taking yourself outside the jurisdiction of the arbitration, the results of that process will bind you. There was a decision of Justice Mubiru in Lakeside Diaries versus ICAMEC. The respondent deliberately refused to respond to any letter that was requesting them to concur to the appointment of the arbitrator. ICAMEC nevertheless proceeded and made the appointment, and the respondent still did not attend those proceedings. But the arbitrator, for every step of the way, continued to serve the respondent with all the proceedings. They did not participate in anything. And at the time of setting aside, they filed an application saying that they were denied a right to be heard. The learned judge said, the failure to participate in proceedings, when you've been served all the way, it meant that they took themselves outside the jurisdiction of the process. So selection is very important. If you receive a letter proposing Kirunda, and the dispute is about AI, and you know he has competence in AI, the best you can do is to respond agreeing, or if you think that you need a multi-professional panel, there are certain disputes which are multi-professional. There might be a construction dispute which has aspects of contract interpretation,
aspects of quantities, and aspects of structural integrity of a building. At that point, you can suggest that let us have a multi-professional panel. It can have a construction lawyer to help with interpretation. It can have a civil engineer to help with the structure. It can have a quantity surveyor to help with the quantities. They'll come up with a fantastic award on almost all of the disputes. So that's one takeaway. Now, next is enforcement. Now, the fundamental duty of we arbitrators is to make sure that the awards that we write are valid, they are enforceable, and most importantly, they are final and binding. One tip I need to emphasize to we all ADR practitioners, at least I use it as an arbitrator. I write an award for 4 people, and pay attention. The first person I write that award for is the loser. The loser must be satisfied that the procedure was fair and that they were hard. The second person that I write that award for is the winner. The winner must be happy that they have won on the merit and that it's because of their evidence that they have won. The third person the award must be written for is the court to which it is sent for setting aside or enforcement. So you must be aware that there will be a judicial officer who will read through this award and make their own conclusion without you having to make any explanation. So you must write it bearing in mind that a judge will look at it. And of course, lastly, and most importantly, you write it for yourself. You need to go to bed knowing that you've dispensed justice. But most critically, there are certain tips that must be followed, and you may not find them anywhere. The whole process of the arbitration is consensual in a sense that parties agree to almost everything apart from the decision. And the best way of recording the parties' agreement is through procedural directions or through procedural orders. And you won't find this written anywhere, but one practice which I encourage you practitioners to do is, and I do it, for every award that I write, I attach the procedure orders as appendices. And I'll tell you why one time it was a very important aspect. I rendered an award, and a few months later, the Civil Division rendered a decision that the Executive Director of CADA did not have powers to appoint the arbitrator, and I had been appointed by the Executive Director of CADA. So the loser went to the court and said that notwithstanding the nice English, I was appointed by a nullity. But when I invited the parties for the first preliminary meeting, they agreed to the entire process, right from filing of the claim to the response, to the scheduling memorandum, to witness statements. But I always include paragraph number 1. The parties hereby agree that this arbitral tribunal has been properly constituted and that they have no objection to the tribunal to hear this matter. That is clause number 1. Then clause number 2 goes into the filing. And I attached this procedure order as an appendix to the award. And this matter went before Justice Stephen Mubiru, and he said, notwithstanding the Executive Director's lack of capacity, the fact that the parties signed procedure order number 1, they appointed the arbitrator themselves. And that award was enforced. So at any one time, you must be aware that that award will go before a judicial officer to see whether it was validly made. Now let me go to the aspect of enforcement. The first aspect is you need to know whether it is a domestic award or a foreign award. They will all have the word final award on the face of it. So you need to be able to distinguish. So it is domestic if it is made in Uganda and the seat is in Uganda. It is foreign if it is made in any state that is a signatory to the New York Convention. And Uganda became a signatory to the New York Convention on 12th February 1992. And this convention was domesticated upon the enactment of the Arbitration and Conciliation Act in 2000. And this means that awards made in the New York Convention countries are enforceable in any of those countries. And to bring it home, some of the awards have come to Uganda. The first one was, not the first one, the one that I can think about off the cuff is Aya Investments versus Industrial Development Corporation of South Africa. It involves the Aya building that you know in Nakasero. It was a foreign award seated in South Africa. And as soon as that award was rendered, the winner, that is the Industrial Development Corporation, filed an application for enforcement in Uganda, since it's a New York Convention country. And at that point, the loser, Aya, filed an application to set aside that award, and the judge declined on the basis that the seat of the arbitration was South Africa. So the Ugandan court did not have jurisdiction as far as setting aside, but the court had jurisdiction as far as enforcement is concerned. And it's because there are different legal regimes. When a court is faced with a foreign award, it applies the New York Convention, which allows recognition and enforcement. If a court is faced with a domestic award, it applies Section 34 of the Arbitration and Conciliation Act of Uganda. But it is very critical to know that when you're faced with a foreign award, you can apply for the court not to enforce it based on the New York Convention, and the grounds there are similar to the grounds for setting aside, but the regime is different. Another distinction is that you have 30 days under the Ugandan law to apply to set aside a domestic award, and you have 90 days to apply to refuse recognition of this award. But there's a debate on that aspect. And the debate is that the arbitration rules, which are part of our act, it is said and believed with evidence that they just did a copy and paste. We had an old law, the Arbitration Act, which was repealed. So just to borrow Lillian's words, at midnight, they picked those rules and pasted them in our new act. So there is a conflict in a sense that Rule 7 says you have 90 days within which to apply to refuse recognition and to set aside the award. Section 34 says you have 30 days. The previous law, which was repealed, had 90 days. So you can see that these rules were meant for the old law. But Parliament is busy passing the UPDF Act. They have not had time to correct some of these things. But the judge, Justice Egonantende, made a decision in Kinembe Mines to say when there is a conflict between primary legislation and subsidiary legislation, of course, primary legislation takes the day. So it's 30 days, so notwithstanding what Rule 7 says. But since Section 34 applies to domestic awards, you may not come and rely on it if you have an international award. So ultimately, there is still that window of 90 days. So I think when we have our law amended, we can cure this aspect. Another aspect is there was a decision which was rendered in Kenya. It was seated in Kenya. The parties were Housing Finance Bank versus Kampala International University. You know Basajja Balaba. So he had borrowed money from Housing Finance in Kenya. He didn't pay. So the decision was rendered in Kenya. So Kenya was the seat of the arbitration. And the court in Kenya, there had been an application to set aside in Kenya, which was dismissed. So Housing Finance Kenya filed an application for enforcement under the New York Convention, and Justice Mubiru enforced that award. So one of the key aspects is that public policy. Public policy in Uganda can be different from public policy in Kenya or in Singapore, notwithstanding that they are all New York Convention countries. So the country to which the enforcement application has been filed retains the discretion based on its own public policy. To put it differently, in Uganda, you cannot arbitrate tax matters. In New York, you may. So a New York award, if brought to Uganda and it seeks to enforce tax, a judge in Uganda can refuse, rightly so. And the reason for refusal is it's contrary to public policy of Uganda. And it has happened. There was a case of Great Lakes Energy versus Zabo. It was a decision rendered, the seat was London. It was under the London Court of International Arbitration. So it was, the award was rendered in London and brought here for enforcement under the New York Convention. And Justice Mubiru refused to enforce part of it. It had given orders that certain shares in a power company be transferred. It was a 3-member panel of arbitrators, that certain shares in this company be transferred, and it was an order which they sought to implement in Uganda. And Justice Mubiru's reasoning was that because we have the Electricity Act, which established the Electricity Regulatory Authority, which is the supervisory authority for companies that are engaged in power production, any transfer of shares you must seek the approval of the authority. So to the extent that the arbitrators directed a transfer of shares without considering that such process required the Electricity Regulatory Authority to perform, to that extent, that award was contrary to public policy, that component of the award. So the rest of the monetary award was enforced, but that component, which was contrary to the Electricity Act, was denied recognition. That's all I can say for now. Thank you.
Please, let's give a better one for David. In my culture, I'm a Luo. When your mother is not sitting properly and the guests are approaching, you can't just tell her, Mom, sit properly. You know, you go and tell her, guests are coming. So I was not able to stop my teacher, even though he had exceeded his time. So I couldn't tell him to sit properly. Thank you so much, David. And ladies and gentlemen, even as I call the next speaker, it would be a serious dereliction of duty to miss to point out that amongst us, we've been joined by our Minister for Justice, Honorable Norbert Mao. Welcome. And we've also been joined by Professor Wayne Mutuma, the Chairman of Chartered Institute of Arbitrators, Kenya, as well as Mr. Victor Mugabe, who is the Secretary General of Kigali International Arbitration Center. Welcome, Victor. Thank you. Allow me to invite Dr. Robert Kirunda to please just give us tips in a few minutes on how to harness technology for cost-effective arbitral proceedings. Welcome, Doctor.
The Honorable Minister for Justice, my lords, the judges and justices of the courts in the room, I am especially grateful and gratified that the leadership of the Commercial Court is here, because that is where all this business eventually goes, and we are grateful. As a practitioner, I had to say that. Professor Wayne, it's always a joy to be in the same spaces with you, and we cherish your stewardship and leadership. We are grateful. Distinguished ladies and gentlemen,
my good friend here has given me a few minutes. So I'm going to suggest that I use them as follows. When I scan the room, I see mainly 3 or 4 centers in the audience. My lords, the judges, practitioners, clients, and then those of us who sit as arbitrators. So I'm going to make 5 propositions on how we can harness technology in arbitration proceedings, and I'm going to try and translate what that means to these 4 constituencies, if I may. But I want to start with an opening line. And the proposition to the House, if I was leading a debate, I would say this House believes that the cheapest arbitration I can design for you would be deeply dangerously cost-effective. The question is whether you would want to enforce that award. If I design for you a very cheap arbitration process that is dangerously cost-effective but results in a flawed award, would you be pleased with that outcome? And here are my 5 propositions. Number 1, do not try to optimize for cost. Optimize for value efficiency. The wrong frame produces the wrong solutions. A cheaper arbitration that delivers an unenforceable award, or a compromised evidentiary record, or a dissatisfied repeat client is really an expensive failure at a discount. Now, what does this mean for the parties? Before signing an arbitration agreement, demand technology protocols in the clause itself. I would suggest that we specify document management platforms, virtual hearing standards, and presently an AI disclosure obligation upfront. How shall we handle AI at the different stages of the proceedings? The use of AI for evaluating evidence is different from the use of AI for transcribing proceedings. One of them is essentially an editing function. The other is essentially a value judgment proposition. If you don't have a protocol defining the two, you can imagine what will happen when you appear before my lords at the commercial court and we are debating whether this award should be set aside. The solution to that is put it in the clause when incentives are still aligned. Because at the point of signing the arbitration agreement, parties still have the hope that they will never need it. Trying to agree these things after the fact, the incentives are no longer aligned. I am doing everything I can as the weaker party to avoid the arbitration. You are doing everything you can as a stronger party to have a successful arbitration. We will likely not agree. So I would suggest that parties who are negotiating an arbitration clause specify document management protocols, virtual hearing standards, AI disclosure obligations. Don't negotiate these mid-dispute when incentives have shifted. I participated in a London seated arbitration, and this was in the middle of COVID. Naturally, when we were deciding, do we go to London, do we stay? The weaker party was saying, let us go. The stronger party was saying, I don't see any reason for spending all this money trying to fly people across the world. It's too expensive. What we did was to agree on which tools the parties will use, what will the arbitrator use, who are the transcribers, do they have consent to listen to these proceedings, because they belong to neither party. But this is a third-party service provider. And how long will it take for them to give us a transcript after the hearing? Because this was a back-to-back hearing. And so it made things simple to know that if we ended the proceedings at 5 p.m., we would have a transcript by 8 p.m., same day. And they delivered. What does that mean in practical terms? What about for counsel? Build differently. This is a controversial one. I'm trying to say things that will get us to think about these things differently, so I will intentionally say things I know to be controversial. If technology cuts your review time by 60%, passing the full saving to the client while retaining the same fee is dishonest. Restructuring towards fixed fee or outcome-linked models forces genuine investment in technology rather than performance using technology. Patton and I were discussing a matter not too long ago where we have both been before an arbitrator on different occasions, different proceedings, and we both had cost concerns. So you can imagine what that means if a client or a colleague calls us and says, I am considering agreeing to an appointment for so-and-so. What do you think? Now, if people know that Robert Chirunda can use AI efficiently, and if at the point of doing procedure order number 1, I have a clear protocol on how to use AI, should I be the same way I would if I wasn't using AI? Think about it. Now, what does this mean for my lords, the judges? I'm trying to pick my words carefully, but at the risk of being more controversial than necessary, those of us who sit on this side of the arbitration process view the courts as an enforcement risk. And the reason matters. When technology-assisted award reaches your court, the question you will be asked, hopefully not too long from now, this gentleman alleged that I am a prophet. I can neither confirm nor deny. But if I was to see through the crystal ball, I would suggest to your lordships that one of the earliest questions in the AI dispensation is going to be whether you should set aside an award reached using AI. Do you define a threshold? How do you go about this question? And you will be asked to answer these questions. Was due process observed? Start with developing your own framework now before the first serious challenge lands at your desk. What level of AI involvement in an award crosses the line from assistance into delegation? Was there consent? At what point was the consent exceeded? The answers you give, even informally, in firms like this, or even in Orbiter, will shape how arbitrators and counsel use technology in every proceedings that follow. Proposition number 2, technology applied to a broken process just breaks faster. It doesn't solve the problem. The cost drivers in arbitration are party behavior, counsel strategy, and institutional design. It is rarely ever technology. AI layered on top of runaway, disclosure, or adversarial case management accelerates this function. It doesn't cure it. What does this mean for parties? Insist on early case management conferences with binding procedural timetables. Technology cannot substitute for discipline, but it can enforce it. Platforms that auto-escalate missed deadlines or flag document production gaps put structure pressures on the other side without reducing procedure application. For counsel, we can use technology to narrow, not to expand the process. AI document review should be deployed to identify the 10 documents that win the case, not producing 10,000 documents that bury everyone in process. For arbitrators, your case management powers use case management powers aggressively and early. Curb document production. Set hard page limits on submissions. Require parties to jointly operate a shared document repository. The arbitrator who treats procedural discipline as an administrative courtesy is subsidizing inefficiency. The arbitrator who treats it as jurisdictional obligation changes the economics of the dispute. I see my brother is edging close by, so I will try and move faster. For my lords, the judges, I think the ever-continuing discussion on backlog is really a good indication here. And the way to solve this problem is to make sure that in the way that parties are using AI, they can maintain their discipline and avoid unnecessary challenges. If we are running to court throughout the process of arbitration to argue about every technology dispute, no, they are using AI now, stop, because under the Act, what I don't challenge at that stage, I have conceded. So maybe it is time for the court to start thinking about how will we apply the sections of the Arbitration Act with regard to challenges that are technology-driven. And that's why I started by saying, define these things early. Proposition number 3, do not assume capacity symmetry. Don't assume that the ability to use technology is equal, especially if you're the arbitrator. One party may be more skilled than the other. If one party is going against MTN and MTN says, oh, no, we're happy to use technology. Of course MTN is happy to use technology. Why? They're a tech firm. But again, if one party is saying, I'm suing MTN in what is essentially a tech dispute and is disagreeing with every technology proposition, is that fair? As an arbitrator, you want to curb that practice and to bring everyone within the room, and don't let people have too much liberty because of party autonomy. There will be things that we can define quickly and swiftly as arbitrators to solve that problem. What that means, especially for my lords and judges, is that when we come down to the question of fairness, was this procedurally fair? Is this public policy? There's a decision by Justice Mubiru where I lost. I was on the side that lost. And we were trying to stay a matter, and he said, no, it is a lived reality in our jurisdiction that appeals take time. We were trying to stay, and he said, no, by the time you go to the Court of Appeal, this matter, I would have finished it to judgment. So I foresee a situation where the law changes slower than technology, but I think the use of technology will force us, especially if we want to harness the benefits of the 2000 reforms in the Arbitration Act, to think more carefully about how much scope we give the parties in terms of setting aside. Proposition number 4, as you can see, I'm trying to step it up. Nobody is pricing enforcement risk into their technology choices. When the New York Convention was designed, it was not designed for AI-assisted times or even transcribing tools. And so if a court in the enforcement seat finds that the involvement of AI or document review, legal analysis, or most critically, the award itself comprised procedural due process, every cost saving evaporates. You have paid for cheaper process and received an unenforceable outcome. It is one of the hottest topics, at least from what I can see in following in the AI space, that we are going to have a heated debate on whether or not the use of AI should lead to setting aside an award. I think that the answer is going to lie, if I might offer a proposition, in between one of two things. Number one, what did the parties agree? Number two, what was the threshold? If the arbitrator was using it to refine writing, that is different. If the analysis was done using a large language model, then that is definitely not an award by the arbitrator, and so I think that should fail on public policy grounds. Why? Because the parties agreed to the arbitrator, not the tool, which begs the question. If they agree to use a tool but didn't define the scope, what do you do? I will leave that for the House to think about. But for Council, disclose, document, create a record of every tool and every time the parties agree to use a tool in the process. My last proposition. Technology is bifurcating this AI market. Every institution here is already choosing a tier. Most just haven't admitted it. Whether we like it or not, we are all actually, actively or inactively, the subjects of technology. The wise thing to do, therefore, is to think about cost-driven technology as producing mass market arbitration. It will be fast, it will be standardized, and it will be mediated adequately if we pay attention to what protocols we need. Technology will handle the majority of disputes in the long run. I like using the example of online platforms. If you have shopped on Amazon, if you have shopped on eBay, if you have sent money using PayPal, the PayPal engine alone last year adjudicated 1.2 million disputes. No court in the world, no country in the world has a judiciary that efficient, not even China. Now, what does that mean? It's only a matter of time before we admit to ourselves that the same way that we gave up the typewriter for a more efficient device, which is the computer, is the same way that we will actually sit and agree that used correctly, technology will simplify the way we administer arbitration, the way we reach decisions, even in terms of the accuracy. When I've used AI tools, I have found that they give me, even in writing submissions, I have found they give me layers and verticals of analysis I couldn't have thought about on my own as an individual. Of course, I start with my own draft. I never ever let AI generate my first draft. My proposition for Council is that we should position deliberately. Practitioners who will lead this market in the next 5 to 10 years are not the ones who resist technology or the ones who outsource judgment to it. They are the ones who can fluently operate across both tiers, technology and human tiers, deploying AI at a speed in mass market matters and deploying irreplaceable human expertise where stakes demand it. Now, my view is that AI will not replace lawyers. It will change the way we do work. In fact, for any lawyer who has at least 3 years of experience, I would propose that what is going to happen is that you will be able to bill a lot more if you know how to use AI well than you are billing now. This means that in the arbitration space, we should actually be thinking about this more carefully. And I will, before I go to my closing remark, I will propose here that on this point, for my lords the judges, the bifurcation of arbitration into mass market and premium tiers will eventually bifurcate enforcement jurisprudence as well. Summary enforcement of standardized, low-value technology-mediated awards may require a streamlined judicial process, distinct from the full public policy analysis applied in complex, high-value disputes. A good example we can learn from here is the ICC rules. I believe the ICC rules give us a mechanism we can study on how we should bifurcate the market. The ICC have this, Patson will remind me the right term, but I think it's a short version of the arbitration process where you can agree to an accelerated arbitration. The formalities there are less. The process takes a shorter time. I don't know whether it translates into cost saving in tangible terms, but I think that if we think about setting aside, it would be unfair to apply the same public policy setting aside framework on an accelerated arbitration than one that is not. So if tools are giving us a faster way to resolve disputes, maybe we should eventually think about where the jurisprudence will go when it comes setting aside. My closing proposition is the most dangerous practitioner today and in the next 5 years, if you are in this room, it is not the one who refuses to use technology. It is the practitioner who uses it without understanding what they have delegated and to whom. I thank you for your time.
Thank you so much, Doctor. The challenge of being pitted against opponents who are stronger than you is that you cannot even throw a punch. So even if he exceeds time, you can only watch helplessly. As I go to my final expert of the day, I would request Mr. Francis Jimara, who is my team leader, to join the table where Professor Wayne is as we transition shortly into the next exciting and quite expected session. But meanwhile, may I request Patson, this is my peer, at least I can throw a jab if he exceeds by 1 minute. Please, just come and give us tips on setting aside arbitral awards. Thank you.
I feel bullied. I will definitely take a short time, and I presume that this conversation is in regard to international arbitration specifically. So I'll try to be brief since Chirunda and David have touched some of these matters relating to setting aside. First, to begin with, what is critical. The arbitral awards derive their authority not from the coercive force of the state. They actually derive their legitimacy from the fact that people believe that the process is fair, it's legitimate, and reliable. So from that perspective, that's why a good number of arbitral awards are actually voluntarily complied with less enforcement mechanism that is expected. But the second point is the fact that the reason why people go to arbitration is the aspect of finality. Otherwise, if it was not for finality, I would rather go to the elaborate process in the court system with probably 4 or 5 layers of appeal process. But that said, it does not mean that the arbitral process should not go through scrutiny in terms of whether they have done the right thing. But the scrutiny of the result, which is the award, is also very, very narrow. And this is based on the 2 principal instruments that are very critical to my discussion. Of course, one is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and the Unicitro Modulo upon which Arbitration and Conciliation Act is premised. These 2 instruments are very critical in 3 ways. One, the fact that they provide us with a global foundation upon which arbitration is set. And I think I agree with the discussant yesterday who talked about that we can no longer talk about domestic and international arbitration. What comes out as domestic arbitration can escalate into international, especially on the enforcement if you want to enforce in other jurisdiction. But these two instruments are critical in many ways. One, the New York sets the standards in terms of under what circumstance can you recognize and enforce the arbitral award. The convention does not set the grounds upon which the award should be set aside. And the idea is that that is left to the national courts to determine. The reason why these two critical instruments are important is that the in situ model law, for it goes ahead in addition to the grounds for recognition and enforcement, it also sets down a list which is considered exhaustive on the circumstances under which an arbitral award should be set aside. And a number of that Article 34 of the model law has actually been replicated in a number of more than 72 countries, globally. What that means is that those two instruments have harmonized the grounds for judicial intervention in as far as intervening in an award where parties require finality. So what that means that setting aside grounds have generally been made clear, not only in Uganda but also globally. And that list is from the jurisprudence across different nations. That list is not intended to be added on generally. I think the only addition, especially for the model law states, is the fact that national courts are allowed leverage on the public policy considerations to define it within their borders. The other key aspect is the fact that the two instruments provide or create a balanced system of judicial supervision. When you have an award that has come from international arena, which courts have mandate to set it aside? And which court can actually recognize and enforce? And the two have a complementary aspect. One of it is the fact that the law of the seat or the country of the law of the seat has the primary jurisdiction to set aside that award. What that means that in discussions of setting aside, determining the seat of arbitration is very important. What remains is that then the rest of the other countries have the secondary jurisdiction to deal with the recognition and enforcement. But we've seen debates sometimes where an award comes and the question is whether actually the court has jurisdiction. But if we are to mirror what is coming from the two instruments, is to understand that once you recognize that this country is the seat, then the idea is that the proceedings relating to set it aside belong to that jurisdiction. You can decide not to enforce it on almost similar grounds, because Article 5 of the New York Convention, which deals with grounds for recognition and enforcement, are actually the same grounds in the model law dealing with setting aside. The same that have been mirrored in our Arbitration and Conciliation Act. So I wouldn't want to go through the grounds. I think they're quite familiar. But I think what is critical for practitioners as well as arbitrators is the fact that when faced with aspects of setting aside, I think the first critical question to ask ourselves is, even for the tribunal, is where is the seat? Because the seat has a lot to do with the grounds for setting aside. It has a lot to do with the jurisdiction or the forum where you will go actually to set aside. And we've seen that while countries have adopted the New York Convention or even modeled their law under the in situ model law, they have also added other grounds that may not be in the two instruments. And that's why you need to go to the seat to understand what you need to do. The second question, if faced with setting aside, you need to review carefully the arbitral record. Even with the law of the seat, the courts are not required or they do not operate as appellate courts. Why? Because the intention is actually to scrutinize, one, the legitimacy of the process, as well as the integrity of the process. if the tribunal followed the process and the law of the seat, even if court believes that they could have reached a different conclusion, the mandate is not to review whether the tribunal got it right on facts. That is not the mandate on setting aside. Court cannot review whether they got it wrong on the matter of law unless it fits within the policy consideration ground for setting aside. But also, you need to ask yourself the strategic question whether this setting aside proceedings is actually a strategic error intended to delay enforcement, or you'll be able to succeed. And it's a question of whether you can put up a legitimate case based on either the Article 5 of the New Convention or Article 34 of the model law, which is reproduced in our Section 38. So from the arbitrator's perspective, I think for us, always the question is that when you're drafting an arbitral award, you must be mindful of the fact that you cover all the bases in as far as setting aside is concerned. And some arbitral institutions have created a layer that scrutiny to avoid such. And I think ICC is one of them, where you have a panel of members of the court, and each arbitral award will be scrutinized before it can be published by the tribunal. Of course, some other jurisdictions have criticized that process. What's the mandate of that court, and can they pinch holes on the merits of the award? But the understanding is that whatever comes out of the ICC or any other arbitral institution should be strong enough to withstand scrutiny in as far as Article 34 of the model law is concerned. And Chirunda raises a critical point that is also trending in as far as AI is concerned. I think we've seen, I think in the US, cases that have come up now to set aside arbitral awards on the basis of the use of AI. But I think what is coming out prominent is the fact that even with the use of AI, the grounds to be used to challenge AI, again, must be premised on Article 5 or Article 34 of the model law. If you use AI and fundamentally it replaces your adjudicatory powers, then therefore as a tribunal, you have abdicated your role. Or is the panel duly constituted if it is AI that delivered the award? So the issue would be whether the tribunal is appropriately composed as a result of the use of AI, or whether this is actually a tribunal award, especially where the reasoning has been fundamentally adopted by AI. That is not to say that the use of AI is wrong, because I think almost all arbitral institutions currently and most of the international arbitrators have actually adopted AI. But to what extent? Doing research, document analysis. But when it comes to evidence analysis and decision making, I think there's a general accepted standard that you cannot abdicate that role to AI. So what could be some of those reflections that we can have in as far as setting aside is concerned? One is the fact that it's not an appellate process. Two is the fact that setting aside goes counter the principle of finality, and therefore the grounds must always be given a narrow interpretation and not to add on those on the list that has already been provided for. And the third one is the fact that we have to always be mindful of the seat, because it takes a lot in as far as setting aside is concerned. Which court, what grounds, and the rest can only deal with enforcement and recognition. I thank you.
Thank you so much, Patson. I think you've done justice. And I would request, in the interest of time, that we take just 2 burning questions. And please, by show of hands, 2 burning questions. Okay, we'll start there and you take the microphone there, please.
My question is directly to Patson. In yesterday's presentation, we had Justice Stephen Moviru, and one of the things he spoke about is around appeals or for awards. I don't know if you want to say something about that. He said parties can reserve the right to appeal, however, it is restricted to matters of law. Only to matters of law and not any other matter outside, matters of fact. I don't know if you can say something about that.
Okay, mine is also, I have two questions. I'll be quick. The first one is to Patson. You say that, and rightly so, that arbitration, setting aside the arbitral award, there is a narrow interpretation to the grounds for setting aside. So my question is, what happens in scenarios where there is evident, there's manifest injustice that does not really squarely fall under the 5 grounds contemplated in Article 5 and 34 of the ACA? And yeah, what do parties do? Do they, like, where do they seek recourse, and how do we make sure they don't have that bitter taste of feeling like they've not gotten, they've not found like justice and arbitration? And the second one is where we have, for example, a framework supply agreement between parties that have a valid arbitration clause, and performance requires that they bring on board a subcontractor who is not party then to the agreement, and a dispute arises out of obligations on the part of the subcontractor. What happens in the spirit of arbitration? The person is not party to the agreement, and we know that consent of the parties is paramount. How do we sort of try to bring them into the arbitration sector?
All right, thank you for the question. I will start with one relating to appeals. I think it begins from that simple proposition that globally, especially for the countries that have adopted the in situ model law, is that they expect finality. But the law has also given leverage to the parties to agree to reserve appeal on a point of law, and it's even also in our Arbitration and Conciliation Act. So if parties in the arbitration agreement agree that they will appeal, so be it then that right of appeal is reserved. Only that still they cannot agree to appeal on points of fact. It can only be on a point of law. And I think that is also the same position in UK as well. Yeah. But in some other jurisdiction, in case there's manifest injustice, even to address that point, I think in Singapore and in China, there are also limited grounds where there's glaring injustice. You can actually have that, although as a ground for setting aside not an appeal. For instance, where there's utmost breach of the due process to the extent that such an award should not stand, in some jurisdiction that can be reopened. But when you look at the narrow grounds under Article 34 or Section 38, as well as which are reproduced under Article 5 of the New York Convention, the idea is that you must bring your grounds within the limited exceptions. Because the idea is that the arbitral award should be final. You will only set it aside on those limited grounds. Otherwise, then there will be no difference between arbitration and mainstream litigation if there's no end to the litigation process. So even if there's manifest injustice, for instance, there's a glaring error of the law, I don't think court should use that unless it fits within public policy consideration. If not, just because the tribunal got it wrong on a matter of law fact, cannot be a basis for setting aside an arbitration award.
Thank you. I know the experts are burning to say something. Unfortunately, I will not allow you. And let's put our hands again together for these experts. As in our tradition, I would request Dr. Isaac Yak to come forward and please shake our experts' hand and hand over for them an appreciation. Even as I do that, and then once they are done, I'd request the Minister for Justice, the head of commercial divisions, and my lords to join them here. We take a group photo. Please, may I start with Lillian, right? Let's give them in order. Let me start with David. Robert next. Robert. Lillian. And finally, but not least, Patson. I would request the Honorable Minister, my lords, just have a group photo here with our guest plus Dr. Isaac. Let's take our... Thank you so much, and I now welcome you to our final session of Gumzo ADR 2026. And this session will be moderated by my team leader, Mr. Francis Jimara SC. And this session comprises some of the heavyweights, Professor Wayne Mutuma, Victor Mugabe, as well as Nora Kagwa. These are the custodians of the institutions of arbitrations in this region. So I'd request Mr. Jimara to come and take over and welcome our guests. Thank you.
Thank you, Huntington. Clap for Huntington and the panel. Friends, the Gumzo train is coming to dock almost. In a few minutes from now, we will be done. I just want to request you stay with us for the final panel, and then we will, after that, invite you for a cocktail down so that we can continue to network. But we'll keep this very, very interesting. Allow me, with a lot of humility, invite Professor Kenneth Wayne Mutuma, who is a distinguished legal and governance expert with over 23 years of professional experience. He has a PhD in law, an LLB, and I think you will hear this for some of you for the very first time, a Bachelor of Architectural Studies from the University of Nairobi, a chartered arbitrator, and a certified professional mediator. He is the current chairman of SIAB Kenya. As you know, SIAB Kenya has played a very key role in hand-holding SIAB Uganda, whose interim leader, Mr. Kagwa, was on the previous panel. He is an accomplished academic. He was actually named the Law Teacher of the Year 2024. He's published very widely in ADR and corporate governance. And in my view, he is not only a thought leader, but a practitioner in the ADR field. Now, we have had several conversations, the context of this topic, looking ahead. We had two leading lights here. Yesterday, Professor Githu spoke eloquently about coming together to expand the arbitration pie for the African community. My brother, my elder, my friend, Supo Shashore, spoke again, as usual, in a deep manner, unveiling the history of arbitration and what we need to do differently. We want to close because Gumzo should not and cannot be a talking shop. We want it to point us towards directions. And that's why for us at Gumzo, the conversation has been, how do we bring our leaders in the judiciary, how do we bring government, how do we bring ADR practitioners in the same room, so that we speak to each other, we make recommendations together, and then we implement together. So this being the first Gumzo, we would like to have some resolutions, and then next year, we will audit those and keep moving until we make ADR work for all of us. Now, Professor Mutuma, I will invite you to have a seat. And then he will lead us to discuss on how we look forward. But to join him to unpack a bit of what they have done, but also very influential, the Kigali International Arbitration Center. They have run ahead in many ways. And with us, we are graced by the man who runs it. Been a practitioner for many years. He has worked with the Rwanda Bar Association for many years. He has worked with the justice sector in Rwanda for many years. He is a professional lawyer, and also he's a member of SIAB, rich experience in institutional development and ADR. Friends, welcome with me Victor Mugabe, who serves as the head and registrar of the Kigali International Arbitration Center. Victor, karibuni sana. Last but not least, the lady who has been handling and driving the International Center for Arbitration and Mediation in Kampala since it was set up, but also serves as vice chairperson of SIAB Uganda. A distinguished ADR practitioner in her own right, and also an institutional leader. She has seen ICAMEC grow from 0 cases when it started in 2019 to 51 cases today, December 2025. That is not a mean achievement. Friends, welcome with me Nora Kagwa, not related to the other Kagwa in any way. They only share a name. So some of you may begin to say, is this thing about the Kagwas only? No. Nora Kagwa is the registrar of ICAMEC. Now, friends, looking forward, I'm going to ask Professor Wine to articulate what looking forward is like. If we have all these institutions, what more can we do to begin to converge, to begin to work together? So this Gumzo is about that. Dr. Wine, Professor, come and talk to us. Asante.
To the Honorable Minister, I have very pleasant memories when I look at you. I still remember some place in some hotel, what you have done for this ecosystem is fantastic. Allow me, before I say anything, just to salute you and the tremendous work you've done for ADR in this part of the world. Thank you. I also thank very much Senior Counsel Francis, the ALP team. This is absolutely fantastic. We come from Kenya to Uganda to learn so many, many things. You probably take them for granted, but they are powerful lessons for us. And I'm looking at my very good friend and colleague, the vice chair of the Chartered Institute Kenya, David Njoroge. We have been having a lot of secret conversations on the fantastic conferences, including this and very one of its kind, Gumzo. Asanteni sana, tunashukuru kabisa. Now, I would like to make sure that, Minister, you stay with us, so I will be very, very brief, because the last thing I want is for you to have pressing matters and we miss out on your wonderful presence. My lords, my ladies, allow me to sum up the present context in this form. We are in the heart of a business strategy. Dispute resolution often gets lost in many other nuances that we tend to forget that we are dealing with a business strategy. That how you deal with business disputes has everything to do with how successful your business is. The construction industry will tell you a lot about that. Second, of course, dispute resolution has everything to do with cohesion, relationship, and sustainability. So I want to premise everything that I'll say on that twin-pronged lens to our specific conversation. So what does that mean? When it comes to African arbitration, this is what we observe. We have practitioners, and we've been doing a lot of work in that regard. I don't think the question of capacity still holds. You know, that is a question we've had in numerous periods of times in the past. Two, there's been a lot of work in policy and law. So we have the ancestral model domesticated in so many regions. I don't think we can say that we are infertile or impotent when it comes to the question of law. Three, we have a lot of work, got disputes. And those disputes are the subject of various transactions that Africa is involved in, including very complex transactions when it comes to the CFTA, the Continental Free Trade Area, and what it has brought up, various RECs, like you had earlier on, various commercial enterprises, both within the continent and out of the continent. So there is a sufficiency of people, policy, and the actual work to accommodate a dispute resolution ecosystem. Now, what is the problem? I think the problem can be summed up in this word: institutional fragmentation. I think Africa, in many respects, still remains cumbered with what the Pan-Africanists identified several decades earlier, that we are so fragmented. And with that fragmentation, we are involved in very unprofitable competition. And furthermore, that this makes it easy fodder for external players to take advantage in the name of the divide and rule concept and context. And that continues to be the major challenge, whether politically, socially, or in the context of the dispute resolution arena. Let me talk about our current strengths so that you can see why this challenge has enormous problems for the continent. In many ways, just like you can see our land, minerals, and other resources, we are not bankrupt in the area of dispute resolution. We have a lot of arbitration institutions. You simply need to move around the world. The other day I received a call from a government official in Mogadishu asking me to set up and guide them in the setting up of yet another international arbitration center. If you go and you count around the continent, I'm not sure what you would guess the number to be when it comes to arbitration bodies and institutions. We have over 90 arbitration bodies and institutions. Of course, there are the larger ones that we can identify that are present here with us: SAKICA in Egypt, KIAC, NCIA, AFSA in South Africa, just to name a few. But look at the density of the operation when it comes to the institutions. Of course, I had mentioned earlier that a quick survey of our legislation will show that the vast number of countries have, in one way or form, adopted the ancestral model law, and they are ratified. They have ratified the New York Convention. I have to also attest and accept that in many respects that we do have a collaboration that exists, ad hoc as it may. So we attend conferences, arbitration weeks together. In many circumstances, we have MOUs that are crafted between institutions. In even more limited circumstances, we have joint training programs, and practitioners in their own independent way have networks through which they collaborate. So we are essentially at a stage where there is collaboration. However, that itself has not yielded the kind of fruits that we hope Gumzo to take us into a new horizon. Because there are structural challenges in how all of that happens. One, the paradigm of competition instead of cooperation, where, of course, we jealously guard caseloads, reputation, and revenues in each of these centers. And we operate with the heart of strengthening ourselves vis-a-vis other competitors. And the language that you find in the business world of margins, profits, and costs of operation creeps in to our relationship with each other. The result of this fragmentation that I had mentioned earlier is, of course, a dilution of the African brand. So when people look at us from outside and they think about Africa and arbitration, the sheer extent of small entities competing with each other, of course, has a massive impact on the collective brand of whether Africa is a home to dispute resolution. Furthermore, of course, there is an incredible duplication of institutional infrastructure and expertise. Instead of what the economists often refer to as economies of scale, we have a very fragmented, small-scale farmers that costs us when it comes to infrastructure and the ability to tap into the expertise that is present on the continent. And ultimately, the outcome is we are losing high-value cases. A lot of cases that could essentially be here are taken elsewhere. What do we need to do? And I think Gumzo, there is a wonderful opportunity from this platform. I think we need to move beyond cooperation to coordination. I think we need to start thinking in the language of shared panels, and panels that are not exclusively within the reach of one and not the other. So in the CIAB Kenya branch, I have been actively asking for professional practitioners, Mr. Gimara, I reached out to you on this, that have a certain stature, because as we were talking with the VC, we would want that expertise available to disputes in Kenya. We would want your CV, we would want them to have the ability to access very powerful practitioners in this world. So the idea of shared arbitrator panels. What does coordination look like? 2, the harmonization of rules. And we all have been a part of mechanisms where in one way you are subjected to different rules, playing fields, reporting lines, and what that does to the cost of business and the ability to attract business. I would like to suggest that there is room to harmonize the arbitration rules so that we can enable cross-institutional recognition of proceedings. I think that task is up to us in whatever capacity we serve in this international institutional frameworks. And then, of course, I think more importantly, there are wonderful lessons to be acquired from South Africa. We've seen the AFSA SADC Alliance Charter, this ability to harmonize regional frameworks. I was very, very pleasantly surprised to see the SIAB South Africa branch propose a regional SIAB outfit that would cover Southern Africa. They may have been listening to what John the Baptist of that gospel, his name is Francis Gimara Senior Counsel, has been espousing that this particular region should be looking at a membership or that is East African in identity and not necessarily within our specific countries. I think that thought, Mr. Gimara, that you have been espousing deserves a round of thunderous applause. Thank you very much. And then, of course, I think it's important that we keep the spirit of Pan-Africanism and the spirit of the East African community. Its lofty aspiration doesn't stop at coordination, but the long-term dream of our forefathers still remains, and it is that of integration. So we need to move from coordination, where we can integrate our arbitration data frameworks, where we have published standards that are collectively owned within the region, where we can share digital infrastructure, where we can have joint capacity pipelines. I think, and I'm looking at my colleagues, my wonderful friend and great leader, David Kagwa. I don't see him, just a great man who inspires so much. I would like to see the possibility of joint training programs. He will be training quite a number of Kenyan professionals because of his unique expertise in the construction adjudication world. And we have poached him to render a service to the wider region. And I'd like to see more joint capacity development programs in one pipeline. Quite a number of us here are accredited faculty members with the SIAB London list. We should be providing that capacity to different areas and probably at a much better cost than they do when they come all the way from the north. And then, of course, I would like to see, in terms of messaging, a joint advocacy and policy approach, so that, and our Chief Justice is very big on this, they have already started their own caucus, my lords, my ladies, with the Ugandan Chief Justice, the Rwandan Chief Justice. And I'd like to see that idea of a joint advocacy at a continental level and a joint branding, again, at a continental level. So I have written a paper on this, and I would sum up
the paper in this sense, that a strong continental arbitration system is certainly going to require a continental arbitration data framework. By data, I mean all the resources that we can pull, including people, infrastructure, a harmonized institutional quality standard, a joint continental capacity pipeline, shared technological infrastructure, and most importantly, a coordinated continental advocacy approach. Thank you very much, Honorable Minister. It's wonderful to have you, my lords, my ladies, and our wonderful hosts. Allow me to stop at that point. I thank you very much.
Thank you so much, Prof. In the time he has had, he has laid it out, a couple of recommendations that focuses us on moving beyond cooperation to coordination. A round of applause for him. Mr. Victor Mugabe, you have heard what Professor Wine has shared. And KIAC has been one of the most prominent African regional hubs as far as being a center is concerned. Can you share with us in a practical way what you think you can do to move this forward as KIAC? You know where you see it and from your work. You can speak from there if you wish, you could speak from here as well, whatever you prefer. Okay.
Thank you very much, Senior Counsel Francis Gimara. As my previous speakers said, let me join them in thanking you and your team for organizing such a successful event here in Kampala. So in fact, briefly, this event is actually one of the solutions that we think should be put on the table to address the issue of flourishing arbitration on the continent. So as far as the title of the topic that we are going to talk about is concerned with regard to the collaboration or institutional collaboration to enhance the arbitration opportunity in Africa, I will go straight to the point, because most of the points have been said by previous speakers, including my senior Professor Mutuma, even the previous panels that talked about the effective arbitration on the continent. But I would like to refer the points that I want to share with you on the key researches that have been conducted by non-African research institutions with regard to arbitration opportunity on the continent, the challenges, and how we can address that. And that has been our major concern, especially in Kigali, in Nairobi, Cairo, and other leading arbitration institutions in Africa, like AFSA and some other arbitration institutions in West Africa, especially Nigeria. So we've started already putting ourselves together, especially since 2024. We signed an MOU in Nairobi. I think Professor Mutuma was there when we signed the MOU. And we did it in collaboration with non-African arbitral jurisdiction, especially those from Europe, especially from Germany, which I think is the leading European economy, to make sure that our efforts that we are making in Africa in promoting arbitration is even known beyond the borders of our continent, because we've been suffering with the bias and bad reputation by especially some foreign jurisdiction, thinking that arbitration is not a reality on our continent, and that is wrong. So it's wrong because I'm basing my intervention on 3 surveys that were conducted by the 3 research institutions, and those institutions are not African institutions. The first one is the SOAS survey, the SOAS University of London survey of 2020 on attitudes towards arbitration in Africa. So That survey was conducted among 34 countries in Europe, in Africa, in America, in Asia, in Middle East, everywhere. And the respondents from that survey said that 88% of the respondents said that they would recommend arbitration dispute to be administered by one of the African arbitration institutions. That means there is opportunity for arbitration on the continent. So that is the opportunity. But another survey from the Queen Mary University in 2021 said that regrettably, but the survey didn't say regrettably, but us as African, Pan-Africanists say, regrettably, they say more than 80% of international arbitration institutions disputes takes place out of the continent, including even the disputes that have African parties to the dispute. They take all the arbitration dispute to non-African jurisdictions, especially for the 5 leading arbitration institutions, Paris, London, Switzerland, Singapore, Hong Kong. So you can imagine we have our dispute in Africa, the parties are African, we are taking our disputes to foreign jurisdiction to be governed by foreign law being the governing law, even, let's say, the English law being the governing law of African dispute. So that is a shame on us. So we are fighting as the leading arbitration institution to have really this stopped. The third one is say, okay, arbitration in Africa can be recommended. Regrettably, most arbitration disputes, African arbitrations, are taking place in Europe or in America. But there is another survey by White and Case. Say, yes, arbitration in Africa is possible. The competencies are there, but it will take time to build reputation and track record of what we are doing. And I think, Senior Counsel, that's where we have to work very hard.
Thank you. Thank you for sharing the insights of those surveys that we all need to be reminded about and what they portend for the growth of arbitration in Africa. I turn to you, Nora. You've been overseeing ICAMEC for some time now. Maybe talk to us, if we speak in terms of domestic vis-a-vis international synergies, given ICAMEC plays a critical role in the Ugandan market, how can collaboration between domestic-focused centers like yours and regional hubs such as KIAC and Nairobi International Arbitration Center help onboard businesses in Africa onto the international arbitration ecosystem?
All right. Thank you, Francis. I've been fortunate to come after Professor and the registrar, so they have covered a bit. But let me go a bit practical. When we talk about collaboration, I want to show you what we have done, or what has been done, and its impact. Francis, I'm sure you remember, in 2017, we approached CIAB Kenya, right? One of the challenges that we had when we were establishing the center was that at the time we had about 5 accredited arbitrators in Uganda when the idea for the center was born. And one of the challenges that was shared, and it was part of our concept note, was we need to find a way for Ugandans to get accredited in Uganda. Ugandans were having to fly to Nigeria, Kenya, and I think there was, you had a partnership with Nigeria at the time, so Ugandans were also going to Kigali. So accreditation was one of the biggest challenges that we had. If we were going to push for arbitration and for Uganda to be recognized as a hub for ADR, we needed to have accredited practitioners. So we reached out to CIAB Kenya. It took some time, but in 2022, CIAB Kenya worked out whatever needed to be worked out, and that's why we have the Chartered Institute of Arbitrators Uganda chapter. So that is the strength of partnership and collaboration. Beyond that, I think sometimes when we talk about partnership, we're thinking big things. Before KIAC started, I don't know if you're privy to the history. When KIAC was starting, they came and benchmarked on KEDA. KEDA that doesn't exist, granted, but they came and benchmarked on KEDA. Went, created an institution that is now considered the Singapore of Africa, right? Now, when we were starting the center, we went and benchmarked on KIAC. Now, I need to emphasize that as much as we don't see this as collaboration, they could have said no. KEDA could have said, no, we're not going to give you any information, we're not going to help. KIAC could have told us, we're not going to help. No, you're competing with us, so we're not going to help. But they did not. We had Thierry come, help us, put some systems in place, put the right foundation in place, help us with whatever needed to be done for the center to be credible. Those are the types of collaborations that help push ADR ahead. Now, I don't want to repeat what the professor said, but look at it this way in terms of sharing our roster of arbitrators, right? Imagine you are not just on the ICAMEC panel. Imagine you are also on the SIAB panel of Kenya, on KIAC, on the Nairobi Center. What does that mean for you as practitioners? That broadens your range and type of work that you can get. But what does it also mean for our businesses, right? If I know that I can have my dispute, I have business with Kigali, I can have my dispute either resolved by KIAC or ICAMEC. Or something else that maybe we should appreciate is with trade as is currently, if, for example, we had a party in Kigali and another one in Kampala, right? If KIAC and ICAMEC worked together to administer this dispute, that would reduce the cost of the dispute. It would mean that we collaborate with KIAC, the parties do not have to fly, the arbitrators do not have to fly. They can use the ICAMEC Center and they can use KIAC to ensure efficiency and continuation and reduce the cost. We have been talking about cost of arbitration, reduce the cost of arbitration. We could also share, we could do research together. We could see what has happened in Kigali, what has happened in Uganda, how can we learn from that, and how can it inform policies. So there's different things that we can do. I think the mindset of competition, honestly, if we are hung up on competition, we're not going to move forward. There's enough business for every center. There is enough business for all the practitioners. And I think if we are going to go ahead as a continent and stop relying, and I have nothing against the big institutions and London and Paris and Geneva, really, they have had their name, but it's time for Africa. It is time for us. If we can come together as a continent, right, and actually do what has been recommended, collaborate in terms of administering disputes, or come together as arbitrary institutions, right, to create one African institution. The local ones can help promote ADR in the region, but we can also have one African arbitral institution that can be used, and they can stop saying, no, Africa doesn't have credibility, Africa cannot handle these disputes. Francis, I know we are pressed for time, but let me give you one practical example. So normally, the institutions are approached, and I'm sure KIAC is approached as well, by disputing parties who want to have the center administer their dispute. So they will ask you questions like you're on an interview of some sort, right? So we had some parties approach the center because they wanted to sit in Uganda, which was a first for us. So we were very responsive. We thought, this is nice. These are parties who are not even African, and they want to come and sit at the center. They came, they looked at the center, looked at the facilities. We talked through everything. And the last question we were asked is, but have you ever handled a dispute of this nature? And it was not the subject matter, it was the quantum. They were talking about, have you ever handled a dispute of this magnitude, right? Because how can a center like yours handle such complex disputes? So when I asked about how much the dispute, what was the value of the dispute, they told me it was $3 million US. And I looked, I thought, we handled one for 8 million. So really, 3 million, and the 8 million was African parties, right? These ones were European parties, but they thought that a $3 million dispute was too big for an African institution. So as I close, let me re-emphasize. It starts with us. We're the ones who draft the clauses. We're the ones who keep putting Paris. We're the ones who keep putting London. We're the ones who keep putting Geneva. And then you come to us as the centers and you say you never get appointments. How are you going to get appointed if you continuously put institutions that don't know you? So if you want the trajectory to change how you draft these agreements. That's
Thank you. Thank you so much. Yes, a clap for would do. When Nora spoke about the Singapore of arbitration, it reminded me of a debate going on in a neighboring country. One of their leaders has promised that he wants to make that country the Singapore of Africa. And the opponents are saying, no, you can never make us Singapore. The problem of us looking inwardly, and I think it has been emphasized, as Africans, developing the confidence to expand the African opportunity to make it work for all of us is the elephant in the room. Many times it is easy to blame colonialism. It's easy to blame people who are out of the borders of Africa. But I think, as someone who once said, don't agonize, organize. So I want to throw back this to the room. You know, here there are practitioners, our president of CIAB Uganda, Mr. Chirunda, and all these other people who keep traversing Africa, have now become experts in their own right. I would like to throw this to the audience. What more can we do, you know, on this topic, looking into the future? What must we do, you know, to ensure effective institutional collaboration, not only institutional, but also personal collaboration as a mechanism for enhancing the African arbitration opportunity, because it exists. And it does, because you see in Nigeria, I think Professor Githu, the former Attorney General of Kenya, yesterday in one of the keynotes made this point, that they had to take the decision that a Kenyan law firm would be instructed as the lead firm in any of the international arbitrations. And then, if they wanted to instruct another firm out, that would, they would come in to assist a Kenyan firm, and that changed the terrain. Nigeria has done the same thing. In Nigeria, it is the firms that, you know, Nigerian firms that lead in representation. So I just want to throw this to us in the audience. What can we do? Where are what ideas, how much more can we do together? One or two people who want to chip in? Yes, move the microphone to Mr. Kirunda's neighbor. I don't see her properly. At least Mr. Kirunda, I know him for years. You can tell us your name and then you make the point.
Thank you. My name is Isabella Kankwata.
Yeah.
I think ideally what could be considered is firstly harmonization of laws.
Yes.
harmonization of laws in a way that arbitration already is very cross-jurisdictional in nature.
Yes.
That every single nation, as much as it would want to have its own laws because there's a principle of sovereignty, it cannot take, arbitration cannot exist outside nations recognizing that we actually have to work with each other.
Yeah.
Then secondly, that we could consider is government interference in regards to arbitration is a result of investment. Investment policies are seated and handled often by governments. So if government, even in its own policies, is able to put these preconditions, we clearly see that there will be a better development, because as much as the arbitrators, the people that chair all these forums, are able to say, let's arbitrate. But if government says, for you to invest, for you to actually have this construction project, if conflict arises, arbitration, the cities here, all these different policies, it would be a much more logical, pragmatic approach. Thank you.
Thank you for those practical recommendations. Now that your neighbor is there, Mr. Chirunda, say one thing on that topic as a mwalimu.
I never saw this one coming. But I will tell you, Francis, that David and I, and maybe three other, David, Patson, myself, and two other colleagues, when we were in Zambia recently, we sort of stepped aside and said, but how are we all here and we are okay, in the sense that we are sitting and discussing how can we support each other to move forward. And I sort of inserted myself into a discussion between Prof. Wayne and David. And even just listening to the two of them, I saw Africa's future. What do I mean? The point about collaboration is a brilliant one, but I think one thing we can't think about is what are we all really deepening our expertise on? Because 5 Ugandans meeting in Zambia, I was confident that there was not a single person in that room who could outpace David on construction law, perhaps other than, and I see that Prof. Wayne agrees with me. And yet, even on the areas where Prof. Wayne and David were collaborating, you could see they were not competing.
Yeah.
They were not contesting.
So you are making the point that at a personal level,
we
need to develop the mindset
we must do two things.
Yes.
The first is that we must deepen specialized expertise.
Yeah.
The second is that we must support each other in collaboration. Many times we think about collaboration in terms of what can I get from Prof. Wayne, instead of thinking about what can I do to drive Prof. Wayne's agenda forward. Because in the end, when he is in the same position, he will think about me because he recognizes and respects my expertise.
Yeah.
A rising tide in the end does raise all boats.
Thank you. I knew I would extract some things from you, and I thank God I gave you the microphone. But I think the point you make is very, very important, that, you know, one good turn deserves another. Many times we come into these things as if we can take everything, but let's pass the ball to a more specialized colleague. Let's support them. Then they will also support us where it's necessary. Let me have a new legislator. He has practiced in Canada, but now he's an MP-elect for Agago, Honorable To share with us his perspective. So, but also we count on you going to Parliament and helping put the framework that we need. Share with us your perspectives, Honorable To.
Yes, thank you, Senior Counsel Gimara. I think I would think of, from my practice in Canada, what I saw when I tried to infiltrate the market. Most of the big firms, 500 partners, would look for big firms in Africa. And I think one of the problems we have here is everyone is on their own. Law firms are breaking up, Ottawa, it's hard to get law firm of many partners. And I think when we come together, it will be hard to ignore us. The other thing that I see is credibility. Most of these international organizations will not pick on, I mean, corruption is a problem that is killing us. So I think for us to be competitive at the international level, we need to also work on our name, corruption, get that credibility. Yeah. But also, the other thing is, I saw Boo in Uganda. I don't know whether Build Uganda, Buy Uganda. I don't know whether it applies only to whatever it is, but I think we need something like that. In Canada, I'm an immigration lawyer for Canada. You cannot hire anybody from outside Canada to do any work unless you advertise 3 times and you have proved that you have advertised and you failed to get a non-Canadian. In Uganda, yeah, you find foreigners everywhere. So I think we need to move and close that door. We need to have some laws that will stop us from just bringing in services from out of the country without first checking whether we cannot provide that expertise. Thank you. Thank you so much.
Thank you for those insights. When you speak about Boo, for us who do continental practice, we are saying move from Boo to Baba. Buy Africa, build what? Africa. Lastly, the lady behind, and then I'll bring it to the panel to close us out.
Thank you very much. We've had numerous conversations about creating Africanacity around the idea of arbitration, but I think we are also dancing around what it means to create Africanacity, but more importantly, what it takes to create it. The first question is, are we actually willing to go that direction? And I think the gentleman that spoke right before me makes an important point. However, when you look at the arbitration sector, when it comes to conflict resolution and the law in general, a lot of people do not necessarily have access to knowledge around this and how it exactly works for them. If you look at, for instance, within the corporate sectors, business owners, majority of them, when you look at, for instance, Uganda, are not the most educated individuals to have access to this knowledge. So the first thing is, are we able to push narratives that allow individuals interact with the law systems in themselves to understand the importance of the law? The biggest complaint you'll hear, especially in a Ugandan perspective, is the idea on how government tramples over the justice systems, which it is true. However, we need to condition ourselves to begin moving beyond our limitations. And that means a lot more people now have to be interested in the law. A lot more people now have to be interested in understanding how arbitration processes work. And I think this, in the broader spectrum, also conditions most legal practitioners in the involvement of conflict resolution, for instance. We can question, why is the US coming in to settle a dispute between DRC and Rwanda like we do not have African practitioners, which is true. However, how many of us are willing to find information and understand these processes, understand the history of these conflicts, which I think, if you push to what Dr. Chenda said on being very specific and intentional about where you want to deepen your knowledge, I think that can as well go as far as internalizing and understanding the existence of certain things through intersectionality. If you are an arbitrator, for instance, have you taken the time to understand in terms of public policy? Have you taken the time to understand beyond just public policy, but what is it that states consider sovereign? Why is it something so important to them that they are willing to bypass collaboration to maintain that sovereignty? Because I think it's also one of the misconstrued things that we understand as states and as like statehood in general. I think those are some of the perspectives we could look at.
Thank you for calling us to dig deeper so that we get to the bottom. Let me bring it to our good panelists. And in closing, I would like each one of you to share with us how we can, individually or collectively, prioritize the use of African seats and institutions to enable the growth of the African arbitration opportunity. I'll start with you, Victor. You can close the way you would like to close, but under 2 minutes, and then we bring it to Nora, and lastly, Professor, you will close us out. Yeah.
Yeah, thank you, Senior Counsel. In fact, first and foremost, it's up to us, arbitral institutions in Africa, to work together, to avoid thinking that we are working in competition, because we should tell the users of arbitration services on the continent that we are creating a multiple choice for them to use arbitration. But you have that responsibility, again, to create that safe environment by creating safe seats of arbitration in Africa. But collaboration is very key. But also, we should also think about working with other key stakeholders, because the responsibility, it's not really lying on us, institutional arbitration only, because we need working with the government. I really appreciate how the government of Uganda was really fully represented in this forum. So government is very key. I think the elements that the government should do to enable a conducive environment are long, but I'm not going to list it because some of the speakers listed them. Then judiciary, working with the judiciary. Judiciary is very key for a very successful arbitration system. How do we work together? It's a matter of sitting together and embracing that arbitration friendly among the state courts. But also the SIAB. I'm very happy to have SIAB here because it has really enabled us on the continent to start practicing arbitration. We need you for capacity building and development of standards and ethics and controlling them as well. So we also work with the Bar Association. Arbitration cannot succeed without involving the Bar Association, the lawyers. So, but they need capacity building and getting expertise. Other stakeholders, like a school of law. So let's this ADR mechanism, arbitration, be taught from the early stage of the legal education, so they will grow up with that. But also the business community. Let's talk to business community, telling them how arbitration can be beneficial for them, but also other professionals, especially those that create jobs for lawyers and arbitrators, like engineers, quantity surveyors, land surveyors, professional accountants. So we need to take everyone on board. That is really beneficial for a very flourishing arbitration system. But most importantly, let's work together and share information. Thank you.
Thank you, Victor, for your thoughts. Nora?
Thank you.
Please clap for him.
Ladies and gentlemen, ADR works. The evidence is clear. The evidence is there. It's overwhelming. It works. And in the morning, we heard that ADR is African. So it's ours. Now, where we go from here is, I guess, what is important. We've talked about collaboration, and I can guarantee we're going to collaborator centers. We've already done so with SIAB, and we're not going to stop. I can only say this, and I can't emphasize it enough. As practitioners, there's only so much centers can do. As practitioners, appoint your fellow Africans. If you know that David Kagwa is credible and has the expertise, why are you looking for Mr. Smith? If you know that David is going to understand, he gave us an example yesterday, the tree which was in the middle of the road. If you know that he's going to understand cultural issues, and you know that the dispute is based in Uganda, why not appoint him? Why not appoint African arbitrators to resolve African disputes? So as institutions, we can collaborate, we can do what is necessary and what has been proposed, but it still falls on you. When you're drafting the clauses, if you put Paris, don't cry if you're not appointed in Africa. If you keep taking your disputes out of Africa, don't complain that there are no appointments in Africa. We have to support each other. So when you're drafting, properly draft. We covered this yesterday. If in doubt, just go to any institution, carry their model clause, but also appoint. As an institution, we always get people who say, no, I don't want Ugandans. And they're serious. They do not want Ugandan arbitrators. But then you will see them at training saying, no, you never appoint me. But you don't want Ugandans. So my parting shots are, the buck stops on you. If you want the profession to grow, start choosing African seats and start appointing African arbitrators. Thank you.
Professor Wine, before you come in, I just want to recognize the presence of the Principal Judge, Republic of Uganda. Welcome, my lady. We are closing, and it's very good that you are here with us. We will return to appreciate you. Before you make your final comment, SUPO has been Attorney General of Lagos. They played a big role in getting the government of Nigeria to use African arbitrators. He wanted to make a comment. Let's allow him, then you can wrap up.
Yes, thank you very much. I'll be very brief. I just wanted to be on record. It's a comment from the discussion from the panel. Very interesting discussion. Thank you very much. But my comment is by way of just chipping into...
Put the mic near, yeah.
Chipping into what you had said. I think the question of how to get the seat and not the governing law, it's not as important as the seat into our agreements. I want to suggest that we should advocate, and Gumzo should possibly take this on, advocate that at least the government authorities and the public NOCs and the big corporates affiliated or inside government should front load the requirement of seat in the dispute clause when they are advertising the PPP project, the privatization program, or they are soliciting for bids from the counterparties. Front load it so that whoever sees along with the requirement to have 5 years tax clearance, 5 years financial capability, and all the other technical things that are front-loaded when you apply, we should include that this agreement, that this definitive agreement that will culminate in this project will have a dispute clause with an African seat, i.e. X, Y, and Z. So that way there will be no surprises, and the scale that is imbalanced at the closure of the contract will not exist. Because at that time, he's soliciting and trying to get a deal. Not when he's got a deal. And then finally, to see the legal departments of public authorities, particularly the offices of the Attorney General, but not just him, the ministries of justice, to let us see themselves as risk managers and to include dispute experts in the transaction negotiation stage, not to call on Francis Gimara, the dispute resolution expert, when there is a dispute. We must call him at the time of contracting, even if he's not a subject matter expert in the transaction and the project itself. So those two things I'd like to put on the table for advocacy.
Thank you.
Thank you very much.
Thank you. And I think that you speak from experience because they've worked in Nigeria. Thank you. Yes, thankfully, the Honorable Minister is in the House and the chambers of the Attorney General. They would be pleased to receive those proposals and consider them. Professor Wine, close us out.
Thank you very much, esteemed moderator. I would start with what generally everyone has said. So 3 areas. Capacity. So this is basically known as the tripod of the arbitration ecosystem. So capacity, I think, has been mentioned. It means that we have enough practitioners in to house a seat. We have a judicial system that has awareness of arbitration because of the importance we had in terms of setting aside points of law and so forth. And we have an awareness amongst the users that all of this is available. The second tripod, of course, is law
and policy, the infrastructure, that we have the necessary law reform to make this viable for an investor. So that's great. And then, of course, third, and I think my wonderful senior counsel, Supo has mentioned the world of procurement and what that looks like in facilitating African institutions and their appearance in contractual documents. So that is where the discussion is. But allow me to finish with something that's slightly uncomfortable. Sometimes I get the sense that we need to deal with Afro-pessimism. And Afro-pessimism works both ways. It works from the north to the south. That even if you get it all right, like my wonderful colleague Nora was saying, you are still not thought of being capable. So that is very, very key. But Afro-pessimism is not just a north-south thing. I think one of the worst legacies of colonialism is that it also works amongst us as Africans, that we don't believe that we are capable. Even when you have a David Kagwa and you have Victor Mugabe, you've got a Francis Kimara, we still think, and that was what Professor Githu Muigai was trying to say, that this lead council should come from somewhere from London, Paris, Hong Kong, and Singapore. And we have to deal a heavy blow to that psychological damage that we have suffered. And here is one way to tell Afro-pessimism. I was talking with my good friend David Njoroge. When we have choices to travel, and Francis, you invited us to this wonderful and sumptuous feast in terms of arbitration, but will you come to Kampala or will your inclinations take you to Paris? The Paris Arbitration Week is just around the corner. And when we're faced with those easy choices, we don't show up in Lusaka, in Kigali, in Kampala. That is a sense of what we think about business amongst ourselves. When we have to appoint someone, who are on our panels? When a big matter comes, who do we think should do that big matter? And I want to challenge us that this can go on to the next generation. Hopefully, Minister, you will lead us in dealing with the biggest problem that we have in our the greatest weakness as Africans, which is how we feel about our own capabilities. Thank you very much.
Thank you so much. Friends, a big round of applause. There could never been a team to close us out, to think about Afro-optimism as a way forward. I think, Honorable Minister, you will address the issue of procurement. I think that was the issue, how that can be tinkered. But there was also a question whether the resuscitation of cadre can be used in a way you have proposed to promote Baba, not Bubu. That's something, if you deem it necessary, in your discretion, you address. If you want to address it much later or think about it, that's also perfectly fine. Friends, the commercial court has been with us for a long time. From Wednesday, they have headlined these conversations actively, moderated many of them, shared ideas. And I would like to invite the head of the commercial court to help us in awarding certificates. And as a way of recognizing their great role in this Gumzo. Thank you, my lady. Come and do us the honors of awarding our last panel. Yeah, welcome. Segment. Thank you. You may just put them there and take a photo, a panel photo. Yeah. Yes, I will do the thanks. Thank you. I will do the thanks. I will do the thanks, my remarks, and then you take over close. No, no. You start by closing. Then I give you the no, no. The minutes to invite the people to make a report. No. So friends, on my own behalf and on behalf of the co-conveners, allow me say the following. Mine is to appreciate. Let me begin by appreciating the Chief Justice of the Republic of Uganda, the Principal Judge, and the top leadership of the Judiciary for their leadership, not only in promoting Gumzo La ADR, but by coming here not less than 2 times. The Chief Justice came here twice this week. The Principal Judge has also come twice. Now I have traveled in conferences. I have not seen that happen a lot, together with the minister who was here for almost the entire week. Now, you know, we may take these things for granted, but I'm going to ask you to join me in clapping for the leadership. It demonstrates intentionality, and their support in Gumzo is indeed something that we don't take for granted. For the Minister of Justice and Constitutional Affairs, thank you, Honorable Minister, for leading from the front. Honorable Minister incidentally celebrated his birthday yesterday, and Gumzo was born this week. So I think this is, I think, a week of great births. So happy birthday, Honorable Minister. Please don't rush to go here together with all the delegates. We have organized a cake for you to cut and enjoy with the delegates as one of the chief hosts just after this at the foyer down. Let me also recognize the Africa Chief Justice Forum on ADR, which was part of the co-conveners here, and you had the president of that forum was represented by none other than the president of the East African Court of Justice at opening. Please join me in clapping for them. And as we thank the Judiciary and African Chief Justices Forum, let me thank the staff of JTI, led by the Executive Director, Professor Hauha. May the staff of JTI all stand up, please. Thank you so much. They have worked behind the scenes, sitting long hours. My Lord Principal Judge, you have a very good team at JTI. They have done the rapporteuring. They have been here from 6 a.m. to 8 p.m. every day, ensuring that we have a wonderful Gumzo. Let me also thank the team at ALP Dispute Settlement Hub. I think I've worked with young, wonderful people, Judith and the team, all of you arise. Please join me in clapping for. They have been under immense pressure to deliver this. I think they will have their, for the first time after a long time, they will sleep well tonight. Thank you. This wouldn't have been possible without the support of partners. International Development Law Organization, led by Mheshimiwa Barbara. Thank you so much for the logistics, but also for being part of the conversations. I think, please clap for Barbara. She's doing a lot of work in the background to support these processes. Then let me also recognize the Embassy of Sweden, the Kingdom of the Netherlands for the wonderful support. May I also recognize ALP Nigerian company represented by Supo Shashore for the support to this conference. Thank you so much. MTN Uganda for your wonderful support. I think I see MTN people. Please arise for us to recognize you. Thank you so much. We also supported by Abmac Associates. Thank you, Abmac Associates. Housing Finance Bank, thank you. Matt Abacus, thank you so much. African Women in Arbitration, thank you. And many institutions supported us in many ways. Here, let me mention the African Women in Arbitration. They organized the debate yesterday, and they had a wonderful dinner for women to unpack their role in arbitration. Thank you so much. Let me appreciate the Uganda Law Society. Their vice president came and committed that they will promote ADR. That was a good intervention. Thank you, East Africa Law Society. Thank you, the Muslim Arbitration and Mediation Center. Please clap for them. Let me in a special way recognize SIAB, Kenya, both the president and the vice president at the top of their leadership. Spent their money, came here, shared knowledge. Asante sana, Professor, and Mr. Njuguna, thank you. Together with a team of rapporteurs who joined the rapporteuring team all the way from SIAB, we recognize you and appreciate you. Let me thank as well in a special way SIAB Uganda. They were here, they were on the panel, a lot of, and in this I would single out the president. Mr. Kagwa, thank you so much for being here this week together with the team. Ikamek, Nora, and your board, thank you for being part of this. Kiak, Registrar, thank you not only for being here, but also for sharing Gumzo with your stakeholders. Kiak Rwanda, and then the African Women in Arbitration. So before I hand over to her worship to lead us to the closing ceremony, allow me to say that at the Gumzo La ADR Conference is definitely at a turning point for our country and continent. This was conceptualized with stakeholders to bring the major stakeholders in the room. And there have been a lot of conversations, both in the room and online throughout this week. We can say that the conference has exceeded our expectations, and we think that this has been possible because of partnerships the people have mentioned and you wonderful participants. Thank you so much. My Lord, guest of honor, PJ, throughout the 5 days, we have successfully re-envisioned the entry points of justice from mediation, determinations, to arbitration. We have been able to collectively agree that our goal to resolve disputes better can be done by having these gumzos, not only in this room, but also when we go back to the various institutions. We have explored the vital referral pathways between courts and the other AGS practitioners and arbitrators. We have now agreed that this momentum that we aimed to achieve, that we now have, must translate into implementation strategies, where we move from policy to action. And we can even deepen that by being sector-specific to be effective. As we close this Gumzo La ADR, let us not just live with notes, but with a mandate. Let us remember that we are not just resolving disputes, but we are building an environment to prosper Africa, an environment to make Africa better, where investment is safe, justice is swift, and harmony is the norm. As we debate, let us aim at restoring harmony and not just delivering legal outcomes, but let the resolutions that will be read from a short time from now help us be blueprints, build blueprints for a more efficient, inclusive, and peaceful Africa. I want to wish those who have joined us again, our special visitors from the various parts of Africa, I want to say thank you so much for coming. And for those who have been part of this dialogue throughout the week, thank you so much. I cannot say thank you enough. I'm just going to ask all of us to clap together in appreciation for everything good this week. Gumzo will return for its second edition. Please save the date, 15th March to 19th March 2027. See you then, and let us keep peaceful, let us resolve disputes better, and let's work together. My name is Francis Gimara. I have been working behind the scenes together with the stakeholders to have this happen. Thank you so much. May I now invite Her Worship, Lillian, to lead us into the closing ceremony. And then may I also take this opportunity to invite you after this to join the minister and our chief guest at the small cocktail that we have organized. It won't take long. It's just a networking. Please remember that these conferences are also about networking and getting to know each other. And that's the essence of the cocktail. We'll be honored to host you there. Thank you so much. Lillian.
Thank you very much, Francis. Our chief guest this evening, the Honorable, the Principal Judge, the Honorable Minister of Justice and Constitutional Affairs, my Lord, the Deputy Chief Justice Emeritus, my Lords, the judges present, the development partners, distinguished participants from all sectors, and our guests from beyond Uganda, good evening once again. We are going to have a short closing program. Particularly, we are going to have resolutions. They will not take more than 5 minutes, my Lord PJ, after which we'll invite the Honorable Minister to address us, and the Honorable Minister will invite you to close us off, my Lord Principal Judge. And without much ado, let me invite Your Worship, Gladys Nachibude, who was heading the rapporteuring team, to please come forward and present the resolutions, and to do so in less than 5 minutes, because we are standing in the middle of this and the cocktail that has been organized. We need to get out of here and go and socialize. Thank you, Gladys.
The Honorable Minister of Justice, my Lord, the Principal Judge, all judges present. I stand on the rest of the protocol laid by Lillian in the interest of time. I can assure you that in this dialogue or conversation by Gumzo La ADR, we've collected a lot of recommendations and resolutions. But due to time constraints, we've come up with 5 key generic recommendations that speak to them. We undertake that the comprehensive ones will be published, provided to all the convener websites for reference by the audience since Monday to Friday. We apologize for that. But these key generic ones speak to all the many resolutions and recommendations that you make. Semantics notwithstanding, the key recommendations, I may call them resolutions, are 5. 1, we undertook to institutionalize an ADR first posture practiced by all the justice actors in the ADR spaces. What it takes is that generally to embed dispute avoidance mechanisms and ADR screening at all the contract management stages, right from the grassroots and dispute management processes. That way, we'll be supporting the scaling of the court-annexed mediation, whilst at the same time providing an enabling environment for the recognition of private mediation. There's a need for this intricate balance. This, as a result, will require the full operationalizing of the national ADR policy, Your Honorable Minister, within the justice sector institutions, even with other African states. The second generic one also speaks to many, but basically is to modernize the legal and procedural framework for mediation, alternative justice system, and arbitration as a whole. What it entails is to support domestication, at least of the Singapore Convention on Mediation, align arbitration support with the ancestral consistent practice. This, of course, including emergency measures, virtual hearings, and electronic signatures among the comparative developments on the plains. And also issue guidance on AGS referrals across states and recognition that upholds constitutional safeguards. For example, in Uganda, Articles 126 and 127 of the Constitutional Republic of Uganda, 1995, alongside observance of human rights. In land matters, we affirm statutory functions, for example, of the registrars under Section 88 of the Land Act, Uganda, while preserving at the same time the parties' rights of appeal. This was because there is a tendency of parties in land disputes to run to courts, and there was that danger of courts like sort of to surpass these statutory duties of the oversight roles of the registrars in the land registries under the Act. The third one, to adopt structured management of land and construction disputes. In a sense, to establish a Judiciary Ministry of Lands Land Board Consortium referral protocol to channel the appropriate land disputes to mediation, then strengthen the land registry integrity through secure tamper-evident record systems to address the abuses such as, or inadvantages such as double tutoring and fraud, and also to normalize the dispute boards or standing adjudication bodies in construction alongside enforcement of governance gatekeepers. That is, ensure sound design feasibility for construction projects, land possession before a contract is given, and secure funding actually before the contract execution to avoid the related dilemmas that bring about disputes and case backlogs. 4, generally, to strengthen professional capacity, culture, inclusion, and ethics for all the practitioners in the ADR spaces. That we task the training institutions, including judicial training institutes, to deliver specialized mediator training, for example, in financial and commercial areas, land matters, and workplace governance spaces. This training institution should also support capacity building for customary and traditional leaders in their rights-compliant practices, embed ADR or AGS in legal education, promoting a settlement-oriented litigation culture, which seems to be missing, while at the same time upholding diversity and ethical standards in the tribunals to reinforce legitimacy and enforceability of these tribunals. The last one is also generic but speaks to so many, to embed governance and performance management that make ADR durable. In particular, encourage the Ministry of Justice and Constitutional Affairs in Uganda and other states to accelerate the drive towards policy implementation, require attendance by representatives with full settlement authority in mediated processes, CEOs, or their representatives who appear in the mediation table discourses, to deploy division-level dashboards to track referrals for people to see settlement rates, time to disposition, and backlog reduction, and coordinate with the Attorney General's International Disputes Function to ensure major state contracts and treaty exposure are proactively managed with a clear ADR provisions, which seems to be the gap. The plenary, these will speak to so many others that we are going to develop and publish. I'm Nachimule Gladys Doctor, in charge Research Judicial Training Institute for the Judiciary. I thank you.
Thank you, Your Worship, Dr. Gladys. I believe that she has represented what has taken place here in brief for the last 5 days. Francis Gimara thanked everybody that was behind the scenes organizing this, and he forgot to mention himself, and I think it's probably not in order for one to thank themselves. So let me take this opportunity to thank you, Francis, for tirelessly coordinating us into delivering this important Gumzo La ADR Conference. My Lord Principal Judge, before I invite the Honorable Minister, permit me to deliver a message from Professor Kauka, who is not able to be with us. I stand on the protocol that I established earlier in the interest of time. As we bring this enriching 5-day dialogue to a close, allow me, on behalf of the Judicial Training Institute, to express our sincere appreciation to all the participants, facilitators, and partners who have contributed to the success of the Gumzo La ADR here in Kampala. Over the past several days, we shared insights that reaffirm that ADR is an indispensable component of modern justice delivery, one that promotes efficiency, restores relationships, and expands access to justice. We are grateful for the continued leadership of the Judiciary of Uganda and the strategic guidance of the Honorable the Chief Justice in advancing ADR as a key pillar of justice sector reforms. At the Judicial Training Institute, we view our role as supporting the judiciary by equipping judicial officers and sector justice actors with the knowledge and skills required to effectively implement these reforms. The dialogue during this conference has generated important ideas and action points that will guide our work going forward. As the training arm of the judiciary, the Judicial Training Institute will continue to implement these action points in line with the direction of the Honorable, the Chief Justice, and the entire top management of the judiciary. In particular, JTI will continue to strengthen and expand training on ADR and AJS in collaboration with other actors in the justice sector, including Ministry of Justice, arbitration practitioners, the academia, and development partners. Through these partnerships, we aim to deepen the skills, knowledge, and institutional capacity necessary to make ADR more effective and widely utilized. We recognize that the success of ADR depends greatly on continuous capacity building and collaboration across institutions. It is only through sustained training and partnerships that we can ensure that ADR mechanisms are effectively integrated into our justice systems. On behalf of the Judicial Training Institute, I thank all our active participants and contributions to this important dialogue, and we look forward to continued collaboration as we advance the development and institutionalization of ADR. These are remarks of Honorable Justice Professor Andrew Kauka, the Executive Director of the Judicial Training Institute. Thank you. I'll now take the pleasure, Honorable Minister, to invite you to make your remarks, and thereafter to invite the Honorable, the Principal Judge, to close us off.
Our guest of honor, the Principal Judge, dear friends, we have come to the end of a very, very fruitful week. Everybody who should be thanked has already been thanked. I can only say, when the full list of participants will be published, then you will appreciate the convening power of Gumzo La Africa. And yet this is just the beginning. Our guest of honor, the only thing for me to say is that as the Ministry of Justice, we welcome the resolutions that have been read, and we pledge to work alongside the judiciary to ensure that they are implemented. CADA is going to be strengthened. Before the end of this month, recruitments will have been concluded. And now that the Ministry of Justice is moving into larger premises, we will have more room for this important department to perform those functions. Before the end of this month, I will also be announcing the names of the National ADR Advisory Committee, those who are supposed to advise the ministry. That will ensure that we are on our toes and that we keep on track. Concerning procurement, I propose that I take that as homework. We have received accusations that our procurement processes are not transparent and that they favor certain law firms. I think we should have an honest discussion about that. We must always ensure that those who support government's work in the field of ADR, locally and internationally, are selected, and that those who merit the assignments are the ones who do it. Our guest of honor, we have overcome what I would call the paralysis of uncertainty. As a result of these conversations that we have had, we are now sure that ADR is African and that it is mainstream. Our distinguished professor asked, is Africa a home to dispute resolution? Are we a domicile? The emphatic answer is yes. Of course, we get people flying in from Europe and North America to come and lecture us about something we know. Somehow, people who are from out of town are more expensive than people who are not from out of town. So to be a consultant, you are better paid if you're a foreigner. Even in the field of traditional medicine, I hear on radio adverts about witch doctors from Zanzibar and Mombasa. Apparently, they attract higher fees than our local ones from Bukunja. This brings me finally to the subject of our own sovereignty as Africans and the need for us to have confidence in ourselves. We had a prime minister here called Samson Kiseka, and this was his main topic. He always said that even our language shows some tendency towards inferiority complex. If you see a big, well-fed dog, you say, that must be a European dog. If you see an emaciated mangy dog, this is for sure an African dog. So he would go on radio and say, in Uganda, that when you see a big, well-fed dog, you say, Kabwa Kazungu. When you see the emaciated one, Kaganda. So if you eat well, you say, I've eaten like a white person. If you are suffering, you say, I've suffered like an African. But as this week has demonstrated, through the series of discussions and papers presented, we have concluded that ADR is not only African, but is also appropriate. So it does not simply stand for alternative dispute resolution. It stands for African dispute resolution and also appropriate dispute resolution. We have pushed back our guest of honor very vigorously against those purporting to introduce, in quotes, Africa to ADR. Nobody needs to introduce Africans to ADR. This is our thing. This is a favorite subject of our president, who, alongside President Gaddafi, one time stood at the shores of the source of the Nile to demolish a monument which had been erected by a one John Hanning Speke, who claimed that he had discovered the source of the Nile. Yet he was led there by Africans. In fact, he was carried by Africans and shown where the source of the Nile was. Then he discovered it. So we must reclaim the African roots of ADR. True, the epistemology of ADR in Africa is not well developed. Epistemology is basically the theory of knowledge. So the fact that something is not documented doesn't mean that it did not happen. We may not have documented many of the things we have done, but truly they happened. We have answered the question, what does unadulterated justice look like in Africa? Our justice is beautiful, and it is premised on 5 things, which we can claim as Africa. In South Africa, they summarized it into Ubuntu. So the first core of our dispute resolution mechanism is dispute avoidance. We prevent rather than cure. It has been amply elaborated. Number 2, reconciliation. We don't just want a debtor to pay his debt. We want to put him in a position where he can borrow again. In other words, we rebuild broken bridges. Number 3, it is all inclusive. In African villages, this matter of settling disputes is everybody's business. There is no court orderly to keep anybody out. The moment you hear that there is a meeting concerning a dispute over land, everybody goes there. to hear. And they will proudly say, in my language, Acheroka Winyulok, I'm going to hear. So everybody, in one way or another, is a judge. Number 4, consensus building. Now, consensus does not mean unanimity. It means an outcome that everybody can live with. It does not mean a perfect outcome, but one which we can live with. And finally, we make sure that we match disputes to the best process. In Africa, processes and outcomes go together. So in the words of the lead organizer, Francis Gimara, he said, our goal is to ensure that investments are safe and that justice is swift and that harmony is the norm. I thank you very much for listening to me. It's now my honor to invite you, my Lord, the Principal Judge, to address us and close Gumzo La Africa 2026 and give an appetizer for Gumzo La Africa 2027. Welcome.
The Honorable Minister of Justice and Constitutional Affairs, happy birthday. I read it in social media. You said you are 59 years bald. So a happy birthday. My lords, the judges of the High Court here, your worships, distinguished guests, esteemed facilitators and speakers. I saw people being introduced from Nigeria, from Kenya. Yes, ladies and gentlemen, a good evening. I want to begin by thanking all of you for your committed engagement on this final day of our Gumzo La ADR. I am pleasantly surprised the room is still full. 5 grueling days. This conference has been nothing short of transformative. It has been a true gumzo, or dialogue, that has united ideas from across the continent and beyond to reshape the future of dispute resolution. It has also exemplified the power of collaboration in addressing the evolving challenges of justice in Africa. From day 1's mediation gumzo to day 2's alternative justice systems workshop, which I opened, which unpacked Uganda's AGS strategy and forged linkages between the formal judiciary and the traditional mechanisms, to the masterclass on construction, contracts and adjudication, then domestic arbitration gumzo. And finally, today's discussion on international arbitration, which I got the last bit of it. I was supposed to have really attended the whole afternoon. I'm so sorry I missed it, but sounded really interesting, where we have navigated emerging disputes in the energy sector, charted a unique African pathway in global arbitration, examined the African continental free trade areas dispute framework as a catalyst for intra-African trade, and of course fostered connections through commercial arbitration. These sessions have not only demonstrated the potential of ADR to reduce judicial backlogs, promote economic integration, and ensure culturally sensitive resolutions, but also positioned Africa as a figure of innovation in dispute resolution. This also shows that ADR is the future of justice in our continent. I must commend the technical teams from the JTI, the amazing JTI. Thank you so much. Yes, they're an amazing team. They have really been very consistent in their excellence, so thank you so much. The ADR Registry and the ALP Dispute Settlement Hub for their meticulous planning, which ensured a seamless blend of themes strategic policy dialogues, and of course, practical workshops. This collaborative effort has brought together a diverse faculty of retired justices. I recognize you, my Lord, Justice Stephen Kavuma. Yes, retired Deputy Chief Justice. Thank you for sitting in all this time. The regional experts, academics, practitioners, and non-legal stakeholders, reflecting the inclusive spirit of our justice ecosystem. In a very special way, I extend our heartfelt thanks to our esteemed conveners, the Judiciary of Uganda, the Ministry of Justice and Constitutional Affairs, and the ALP Dispute Settlement Hub for bringing us all together. Your vision and dedication have created a platform that transcends borders and have promoted dialogues that will ripple through policies, practices, and partnerships across Africa. To our speakers and facilitators, and of course you, the participants, your expertise and active contributions have been the essence of this conference. From the energy sector innovators to the AFCFTA visionaries and institutional leaders, you've truly enriched all of us. And to our international partners, of course, not forgetting IDLO and the Embassy of Sweden, your support has amplified our efforts, reminding us that Africa's justice reforms are actually a global endeavor. As we conclude, I want to encourage us to carry forward the key takeaways, which include, of course, commitment to ethical, efficient, and inclusive ADR, strategies for integrating AJS with formal systems, and a unified push to position Africa as a premier hub for international arbitration. Before I close this week-long conference, I just want to share with you a Karamojong proverb, because as we started this conversation of ADR, I actually thought about a Karamojong proverb, which let me try to translate it, but of course it will die along the way, because if it is said in Karamojong, it is really rich. It is said that when people gather under a tree to solve a conflict, the conflict loses its strength. That just emphasizes the fact that ADR actually is the pathway to justice. You know, it begins with a conversation sometimes. That's why they say the conflict loses its strength, which means by the time you start the conversation, it's already done. So it really reminds us that we are on the right path. With those few remarks, it's now my distinct honor to actually declare the Gumzo La ADR Conference 2026 officially closed. I say all this for God and my country.
Let's applaud the Honorable, the Principal Judge. We will rise for the anthems, after which we will take one group photograph at the front here. National anthems and the regional anthem, please. The team handling the anthems, are you ready? Thank you very much. My Lord Principal Judge and the whole of the front table, I request that you come to the front on the carpet area so that we have other people stand behind you. My Lord, the judges, you will join the Principal Judge and the Honorable Minister at the front. Let us come forward to join in the group photograph, and then we can proceed for the cocktail. My Lord DCJ Emeritus, kindly. Our panelists, please join in at the front. All the working teams, this is the time for you to show that you were present. Let us all rise and come and join. There's enough space at the back there. We have steps. So others who are not at the front will stand at the back. JTI, ADR, our rapporteuring team from Kenya, let us all come forward and join in the photograph. Photography team, you will guide if there are people that are in places where they can't be seen, guide them on which direction to take. Thank you very much. My Lord Principal Judge, I would like to invite you and the rest of the members to a cocktail, as Francis Gimara did earlier.